Good morning. Good morning. It's Thursday. It's September 12th. We're going into live court today to cover a trial that I was curious to see if it was even going to go to trial. And today we are going to be able to condense everything down into one day because this trial finished a few days ago. So even though this trial finished a few days ago, I'm going to condense it down and watch it with you because there was some testimony I very, very much wanted to see. So the witnesses will be timestamped down below. There's two key witnesses I wanted to see. You know I love opening statements, but the case is Nevada versus Redden. You might recognize this as the judge jumper trial or the bench jumper trial because he was being sentenced on a separate case when he leapt onto the bench and onto the judge. And then the judge's clerk of court came flying over to try to get him off of the judge. And I very much wanted to see the judge's testimony and I wanted to see the clerk of court's testimony because what even happened in this courtroom? We saw the video that went viral on the internet, but I really want to see the opening and those two witnesses particularly. So we're going to go through that today. We're going to go through the whole case in just one day. Some of you have already seen the resolution of this case. Thank you for no spoilers in the chat. I wanted to watch these witnesses. I am not watching this for the outcome. I'm watching this because I want to see what the judge has to say. I want to know more about what happened. And I only saw the viral clip and I really want to know what went down. So before this case started trial, he had a fairly extensive rap sheet, but also was being sentenced from out of custody to in custody on another case. During that sentencing is when he was becoming more and more agitated with the judge and eventually leapt. Normally when defendants are ramping up in agitation, you can tell. You could tell he was frustrated, but he wasn't giving signs that he was going to leap at the bench. And then it seemingly out of nowhere leapt at the bench. I imagine that we'll see video of that during opening statements. If I was the DA, I would. So we're going to see the video of what happened because this trial is centering around his attack of the judge who was presiding over his other sentencing. There were 7 charges total. He pled to 6 of them and then decided to go to trial on the attempted murder of the judge through not guilty by reason of insanity. So that is the position of this case going into opening statements. So thank you for those of you that are like, I just want to watch court. I want to watch court too. We have a lot of trial coming up with Donna Adelson. There was a hearing today that I'm going to summarize in a podcast episode. I have some travel, some undisclosed travel, to talk to you about next week after things happen, but I have some travel next week. So we've got lots coming up here, and then we'll be back in court with Adelson and then back in court with Sarah Boone. So I love live court. You love live court. I love when I can not do gavel to gavel and just be like, hey, today we're summarizing it. So we're going to zoom through stuff. We're going to do this today. So let's see. Mary said he got charged with attempted murder of a judge, not assault. He got charged with 7 charges. There were assault on an individual over the age of 55. But the charge that he went to trial on was the attempted murder. If you're going to ask me why it's an attempted murder, I'm optimistic that we are going to hear more about why it's an attempted murder in the opening statements. And they're going to play, I think, that video of him leaping onto the bench. So we're going to go through that. Yay for court. Just Raina said, what is that shirt? Today we are with Neon Rolling Stones shirt. So that's what we're doing. So for everyone who doesn't know this case, that's great. For everyone who's watched it, that's great. But we're going to court. I miss court. I miss live court. And I wanted to summarize it. So thank you for being here. Thank you for riding with me. I was really curious about what was going to happen. So we're going to watch it together because that's what we do. Live court's my favorite. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media. And don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a law nerd. Okay, look, I was not anticipating that we were ending the video. We're not ending. I'm not like, we're going to court. Goodbye. We were supposed to intro. The music is the same, so it didn't even catch me. We're gonna be summarizing those. Here we go. Look, hear ye, all of ye law nerds gather to order in the state of Nevada. Bring ye away from the piano bars, out of the delicious food, away from all of the shopping, and let's go to court. How about that? Oh wait, here's what we're gonna do. First of all, look. And second of all, let's go to Nevada. When I say that I am tired this week, my brain is exhausted. And all of you heard the music and you're like, we're in it. It's fine. We're going to be truncating the intro soon anyway, but I love that music. So it will still be here. But yeah, let's go to court. We're going to go to court for opening statements. I want to see what happens, so away we go.
Introduce the evidence. I don't know what Mr. Arnold's preference is.
So that's what we're doing. They are just coming into court, and this was a few days ago. They are getting ready to start.
If you're reading instructions, because it is going to be introduced, like we said, probably off of the first witness. And so we don't want to take the time then to go ahead and, do the Travis instruction.
Okay. Okay, I'm going to go ahead and let's go ahead and bring the jury in, and I will read it right after I finish my instructions before they get up to do their opening. Okay?
Thank you.
We're going to zoom past the jury instructions. Also, I did see that Karen Reed's defense attorneys filed an appeal. They said they were going to. We knew where they were going to. This is not new information. It just happened. I'll cover it in quick bits this week. It's not, they're going to argue the exact same thing that they already argued. So, let's see. Penguin Pammy asked, do we know if he's restrained or shackled? He will be shackled at the ankles because of the nature of the previous incident. He might also have the shock cuff on his calf. However, it really depends on the particular court and what they choose to do. So as I'm failing you at the zooming, we're going to zoom while the jury comes in, and then we're going to zoom through jury instructions to her final instruction, because they're going to talk about the video, I think. So that is him watching the jury come in, which is appropriate. Some defendants stare down the jury menacingly. He didn't.
Of the jury.
Defense
Right.
does.
You may be seated.
Guys, at the end of the day, we should
Okay.
So I want to see her say hi to the jury, and then we'll.
Okay, ladies and gentlemen, you are admonished. No juror may declare to a fellow juror any fact relating to this case as of his or her own knowledge. And if any juror discovers during the trial or after
That's
the
an interesting way to start.
that he, she, or any other juror has personal knowledge of any fact in controversy in this case, he or she shall disclose such situation to me through Officer Black in the absence of the other jurors.
That's an interesting way to start
If you learn
jury
in
instructions.
the course of this trial, you are acquainted with the facts of this case or the witnesses, and you have not previously told me of this relationship, you must then declare that fact to me. During the course of the trial, the lawyers for both sides are not permitted to converse with members of the jury.
Okay, that's where things normally start. So she's going to go through 30-ish minutes of jury instructions. We're going to go to the end of that.
Give you Any evidence that the defendant committed offenses other than that for which
It might
he
be
is on
because
trial,
this
if
went
believed,
viral.
may not be considered by you to prove that he is a person of bad character or to prove
They're
that he
talking about
has
his
a
priors.
disposition to commit crimes. Such evidence was received to provide context to the events upon which
Right.
the charge is based, and because it was not possible to omit other relevant evidence and at the same time exclude evidence of other crimes.
That's important. So what the judge is telling them is, look, you're going to have to hear information that this defendant has other crimes, because you can't talk about the context of why he's in court leaping at a judge if you don't talk about the fact that he's being sentenced for being, you can't talk about him being sentenced for crimes and potentially going to prison if you don't talk about the fact that there's other crimes. So that is what he's going to do, or that's what
Should we mark
is
that
going to be
as,
shown.
Court's instruction number
Where
8?
is my
Yes,
napkin?
Your Honor.
Are you okay with that, Mr. Arnold?
Yes, Your Honor.
Okay.
I'm dropping things.
All right, counsel.
Thank you, Your Honor.
Opening statements. Oh, PowerPoint. Jules Marie asked, he's the guy that tried to attack the judge. I mean, he did attack the judge. He went hands
Turn
on.
it on right now.
That is a PowerPoint slide. Okay. Here's what we're going to say about PowerPoint. Not having an all white background, having a darker background with white letters is so freaking appreciated. The glaring white background is so hard to read, but that if he said that, that's why we're here on an attempted murder case. So the opening statements are just coming in hot. This case is what you're here for. And he said, I tried to kill a judge today. Wow. So whoop, there it is.
Give me my phone. I'm about to turn it on right now.
Okay, thank you.
It'll also be nice to not hear, Lally. So that is a self-snitch. I'm
I tried
interested.
to kill a judge today. Those were the defendants.
I'm interested to hear the context. Okay, sorry, counsel. I'm going to let you go. I'm interested to hear the context. Okay, I'm going to shut up. I want to hear opening statements. Emily, stop talking.
I tried to kill a judge today. Those were the defendant's words mere hours after he violently attacked Judge Mary Kay Holthus in this courthouse on January 3rd of 2024 in courtroom 3F.
Oh, I like the blue suit. Oh, we're going to play the video.
According with the laws of the state of Nevada.
So the PowerPoint started with his statement and then the video of what happened. If there's a video of the case, that's one way to start. Jazz the cat, the judge was hurt.
Is she okay? Hey, radio somebody? Fucking radio somebody!
Somebody in court being like, well, fucking radio somebody is incredibly real.
We're all here today because of that attack. Judge Mary Kay Holthus is here today because of the bravery and intervention of 6 men. Her law clerk, Michael Lasso.
Oh, these are the use of
Correctional
force
Officer
photos.
Joseph Cabralda. Chief Deputy District Attorney Jory Scarborough.
I will say, when we had a defendant run from court and one of the DAs gave chase, our whole office got lectured about the fact that it's not your job. But when somebody's gone hands-on with the court, I think everybody just panicked, especially because this is a a very scary situation to have somebody behind the bench. I've never seen it happen.
Chief Deputy District Attorney Richard Scow,
2 DAs jumped in?
Marshal Shane Brandon, the court marshal in Department 18, where this event occurred, and Marshal Ben Bachhuber, who is the court marshal in the courtroom next door.
The fact that it took so long for people to get there is wild, but the
On
judge...
the date of this incident, Judge Mary Kay Holthus was 62 years of age.
The judge couldn't, because it happened so fast, I don't think the judge could even reach the panic button.
She had been a judge since 2019. She had a mixed caseload, which meant she heard both civil matters and criminal matters.
That would be miserable.
January 3rd of 2024 was a Wednesday, which meant it was a criminal calendar day.
It'd be so
In
hard to switch
anticipation
between
of
the
her
two.
calendar, she went through her calendar before the calendar actually occurred.
As one does.
Mr. Redden's case was obviously on calendar that day. She reviewed the relevant information pertinent to Mr. Redden's matter, which was on calendar for a motion to quash bench warrant and rendition of sentence, meaning he was supposed to be sentenced in front of her. The information she reviewed consisted of his pre-sentence investigation report. That report provides her important background information about Mr. Redden, but also the facts of the underlying offense. She made some preliminary notes. There was nothing particularly unique about Mr. Redden's case. Then her criminal calendar occurs. When Mr. Redden...
I very much appreciate that she started with, this is what he said, this is what he did, this is the context of it. She is not going into and sensationalizing everything else that happened. It's just this. And I really appreciate it. For those of you commenting on her voice sounding shaky, adrenaline can do that to you. I've been there. And the beginning of trial, you're like running 1,000 miles a minute to get ready for trial. And the time you start with trial, the adrenaline can absolutely make your voice sound a little bit shaky when you get started. And so I wouldn't necessarily chalk that up to nerves. I would chalk it up to adrenaline. So for anyone who's never experienced that, that can very much be what it is. But she's just the facts, ma'am, and I appreciate it.
Redden's case gets called. It's approximately 11:10 in the morning.
Oh, I don't want to. Okay. Yeah.
A little more than halfway through her calendar, which began at 9:30 a.m. When the case gets called, initially, everything is going normal. You'll hear that typically with criminal sentencing, the state gets to argue first. Then a defendant is free to make a statement if he wishes to. In this case, Mr. Redden did. He argued for probation. He presented the court with information that he believed mitigated against a term of incarceration.
Facts.
After Mr. Redden was done, his defense attorney, Cesar Almasi, also made an argument to the court, seeking probation on his behalf. After Mr. Almasi was done, but prior
There's the
to
breath.
Judge Mary Kay Holthus having the opportunity to impose the sentence that she believed was appropriate, she made a comment, and that comment was interpreted by many people in the courtroom, including Mr. Redden, as indicating that he was not going to receive probation. After that comment was made, and before she imposed the sentence, Mr. Redden jumped over defense counsel's table.
I love that there's measurements. This is so helpful.
Which was approximately 2.5 feet
But
tall
he
and 3 feet
leapt.
deep. He then bolted towards Judge Mary Kay Holthus's judicial bench.
I mean, how far did he have to run to get to the bench? It doesn't seem like that far, but he leapt the table and leapt the bench.
As you can see from this picture, the courtroom is set up.
For all of you saying
differently from
Massachusetts could never,
how
yes.
this courtroom is set up. There's only one entrance and exit to the judicial bench in that courtroom.
So there's
He
nowhere
then
for the judge
launched
to go.
himself 4 feet, more than 4 feet, in the air, and tackled Judge Mary Kay Holthus like she was a football player. He then, once was over the bench and made contact with her, pulled her
Oh, the slow-mo.
by the hair as hard as he could, and yanked her to the ground like she was a rag doll. When she testifies, you'll hear that she remembers being struck in the head, but she doesn't remember how it happened. She doesn't remember if it was an intentional act by the defendant, whether her head hit something, an object
'Cause head
nearby
injury.
during this altercation. But she remembers being jolted and frightened. She was trapped. This is the judicial bench.
Yeah,
in that court.
trapped.
That entrance is the only entrance to or from where she sits when she presides over her calendar. And the altercation that you saw in the first clip happened right there.
Yeah, there's not
She
a
had
lot of
nowhere to
space.
go. She was terrified.
Of course
She
she
knew that
was.
she was no match for his physical strength. So she hid. She hid as far away from Mr. Redden as she possibly could. She crawled into the corner of that bench and waited there until the entire thing was over. When you watch the full video, you'll see that it took approximately 3 to 4 minutes before Mr. Redden was moved from that location. She was so shaken up, you'll hear that initially she tried to climb that wall that you see in the picture and exit her courtroom where her court clerk sits.
Which is what
That's
judges
not
are.
an exit.
Judges are supposed to, if there is something that goes down in the courtroom, what the sheriffs will normally tell the judges is if you can get out, you need to get out of the courtroom because the sheriffs need to handle whatever they need to handle without worrying about also keeping the judge safe. So if something goes down, the general rule is that judges are to leave the courtroom and let the deputies handle what they need to handle.
But she did not want to be near Mr. Redden, and Mr. Redden was still in the entrance when he was eventually apprehended. Michael Lasso was the first person to intervene on her behalf.
You saw his
because he
face
was
in that video.
situated
He's like,
closest. Michael Lasso is her law clerk. He's been her law clerk for several months now. He'll tell you about what his job duties are as a law clerk.
I'm so interested to hear from him.
But more than a law clerk, he is also a close family friend of the Holthuses.
Oh, shit.
He has known Judge Mary Kay Holthus his entire life.
Well, that's
He
interesting.
was not supposed to be at work that day.
What?
Fortunately, he changed his mind and decided to go in. He will
Wow.
tell you that among his many job duties as his law clerk, or as her law clerk, is he sits next to her during the calendars in case something comes up that she needs help with. Thankfully, on this day, he was situated exactly where he needed to be, to her left in that courtroom, as she presided over criminal matters. He was answering emails, performing work, and also paying attention to what was occurring on the calendar.
As you do as the
He first
clerk.
realized that something was amiss when Judge Holthus made a comment and her marshal moved closer to Mr. Redden. You will hear that when her court marshal moves closer to a defendant who appears out of custody for sentencing, that generally means that defendant is about to be remanded into custody.
Right.
When the marshal moved closer to Mr. Redden and started to unclasp his handcuffs, they jingled.
Oh.
And then he remembers seeing Mr. Redden bolt over defense counsel's table and across the courtroom. Initially, he believed that perhaps Mr. Redden was trying to exit out of one of these rear exits
trying
in
to flee the
courtroom
court.
that staff use.
That happens
But
too.
it became apparent to him pretty quickly that his intended target was Judge Mary Kay Holthus.
Up and over.
And when you watch the video, you'll see the surprise, the shock in his eyes as he's watching this occur.
Yep.
He remembers Mr. Redden launching himself directly at Judge Holthus and knocking her out of her chair with such force that her head hit the tile wall behind the bench.
That explains the memory.
He immediately
Cena,
knew
yes,
that
it
he
is.
needed to take action because he was frightened for her life and was frightened for his own life. So he lifts Mr. Redden off of Mary Kay Holthus because he's the closest person to her. He got some assistance along the way. And the first person to come to his aid, and Judge Holthus's aid, was Correctional Officer Joseph Caralda. You will hear that on this date, he was assigned to the Field Services Unit at the Clark County Detention Center. That means that he's one of the correctional officers that's responsible for transporting inmates to and from their court hearings. He's also responsible for documenting the outcome of those hearings. So he was seated in the witness stand in that courtroom,
Right.
which is directly next to the judge, but there's no doorway between the witness stand and the judge's bench.
Right, because you have to go out the other
So
way.
when he saw the defendant go for Judge Mary Kay Holthus and tackle her, he had to climb over that wall to get to the point where he could assist. When you watch the video where the yellow circle is, that's Officer Caralda climbing over the wall.
As the clerk is trying to pull the defendant off of the judge.
At this time, Officer Caralda was the only correctional officer remaining in the courtroom, because other correctional officers had just done what they call a download, which means moving defendants who were already done with their cases back to the detention center.
Oh, that sucks.
You will hear that he struggled mightily trying to get control over Mr. Redden. That Mr. Redden resisted both he and Mr. Lasso and everyone else that came to their aid very hard. At some point, Mr. Redden was able to knock him to the ground. At which point, Mr. Lasso and Mr. Scarborough began to work even harder to get him off of Officer Caralda, because Officer Caralda was armed back, which could have presented a whole new set of problems. Mr. Redden continued to resist, which is why you see Officer Caralda and Officer Lasso.
I wonder if
over and
he
over again.
even remembers
They
this.
needed to get him to comply, and he was
Like,
not getting it.
I don't know if the defendant even
He was still
remembers what
struggling to
happened.
get away from them, struggling to get back to Judge Holthus. Eventually, they do get him under control. And Officer Caralda actually uses one of Marshal Shane Brandon's, his actual set of handcuffs. He gets one cuff on Mr. Redden, but Mr. Redden is still resisting. So it takes an additional marshal before they can actually get him into both arms into the cuffs. Chief Deputy District Attorney Jory Scarborough was in the courtroom that day because he had another matter that was on calendar, not Mr. Redden's case. He's assigned to a specialty unit at the Clark County DA's office, the gun crimes unit. And you'll hear that as a specialty team deputy, he makes multiple court appearances in a day, oftentimes.
Yep.
So he arrived at Judge Holthus's department at around 10 a.m. and he was still present, waiting for his case to be called when this broke out.
Playing,
Again, he
Cell
was
phone
partially
games.
paying attention, partially not.
It's
But
my
he got the
speculation.
gist that Mr. Redden's case was on.
right.
for
He was sitting
sentencing.
there waiting for his case to
The
get
state
called
wanted prison time.
on his
Mr.
phone,
Redden
doing whatever he needed to
wanted
do,
probation. And then
feeding his Snorlax.
he figured out that Judge Holthus was not going to give him probation.
Well, he heard.
He remembers
He
like
heard
Mr. Lasso
the.
watching
He
Marshal
heard
Shane
the
Brandon move closer to the defendant.
handcuffs.
He looks down to do something else. And when he looks up, he sees that the defendant has.
Megan asked in the chat, and a couple of you have asked, what are these pictures? Those are the use of force pictures. So after any incident where there is any force at all with them having to go hands-on with the defendant, the sheriff's department takes full body pictures of people to show if they have any marks, any injuries from anything. So those pictures are them immediately after the incident, probably in a hallway, still stunned, at least as to the law clerk and the attorneys, who this is not part of their training or their work, standing there being photographed for that incident. A number of you have asked, why isn't he handcuffed now? There's quite a lot of case law about the perception of handcuffs being prejudicial to a defendant in front of the jury. So he would be shackled at his legs if he does not also have some kind of a stun cuff. Sometimes they have those on the chest. Sometimes they have those around the calf, but he would be shackled elsewhere. But no, his hands will be free. He also was out of custody going into custody, which is when you can have those issues with somebody obviously doesn't want to go into custody, or in his case, back into custody. So he was on the original sentencing out of custody, and then the deputy was going to be taking him into custody. So yes, any shackles would be under the desk, and you wouldn't really see that until he comes in and out of the court, but he'd already be seated before the jury comes in, so they don't hear those or know. So let's continue on.
Already cleared defense counsel's table.
Oh, one last question. Some asked, why is he going to trial on this? Is he fighting the attempted murder charges? He's going to trial on a mental health defense. And so the hope is for a not guilty by reason of mental disease or defect, or reason of insanity, depending on the jurisdiction. Some jurisdictions still call it by its older name versus the mental disease or defect, which is still not an ideal name. But the hope is that then you are in prison or not in prison and in a mental health facility. So more like the Shabusiness case, where the hope is to be in a mental health facility. So we will continue on.
And is running full speed and hurling himself at Judge Mary Kay Holthus.
He absolutely hurled
like Mr.
himself.
Lasso and Officer Cabralda, he immediately knew that he needed to assist. So he went
I know, Sassy.
around
It is not
the witness stand,
it is what it is called.
climbed over the same wall that Officer Cabralda climbed over.
I try to be accurate to the
And
court
tried
languaging,
to
even
wrap
when the
his
languaging is
his elbow
dated
around
and
Mr.
not
Redden's
ideal.
neck to gain compliance. It obviously didn't work initially.
No, it did not.
He'll tell you that Mr. Redden was elbowing him repeatedly and trying to buck him off so that he could get back to Judge Holthus.
Well,
But with the assistance of Chief Deputy Richard Scow and the other people who I've already mentioned, they were ultimately able to get him to comply. You will hear from
I don't know if they
Michael
got him
Lasso
to
and
comply
George
or they
Hargrove
subdued him, but
that once Mr. Redden was under control, their first thought was to check on Judge Holthus. When they checked on her, they saw her still curled up in the fetal position underneath her bench. And she looked terrified.
of course she was terrified.
She was frightened, disoriented, shaken. And that really struck Mr. Lasso because he's known Miss Holthus his whole life.
Well, she had hit her head.
And he's always thought of her as a tough cookie. But in that moment, she was scared.
I mean, we saw the judge, and this is not a criticism of the judge in the Darrell Brooks case, but we saw the judge in the Darrell Brooks case leave the bench because he was mad dogging her. Like, he was glaring at her, and she made a record that the way he was staring at her was frightening, and she got off the bench and took a beat because of how agitated Darrell Brooks was getting, and he was in court and he was restrained. So I'm not surprised that this judge was terrified. Nobody should be attacked, period, but nobody expects to be attacked in their workplace. But courts are dynamic and courts can be dangerous. And this is one of those unfortunate times where court is dangerous.
Marshal Shane Brandon, as I mentioned earlier, is assigned to Department 18. He's been assigned to that.
They could have found a better picture for
approximately
him.
2 years.
This poor man.
As the court marshal, he is responsible for maintaining order and safety in the courtroom during calendars.
Right, by himself.
Because of a previous incident that he had where an out-of-custody defendant tried to flee from the courtroom, it became his practice to stand exactly there. The doors behind him that you see in this photograph are the public entrance and exit doors.
Defendants fleeing
So
is
he
more
stands there to
common
prevent defendants from fleeing the courtroom.
than
if they don't like
attacking
the
people
outcome.
in the courtroom. the flight instinct is
like Mr.
real.
Lasso and Mr. Scarborough, he realized that Judge Holthus was not going to give Mr. Redden probation. So he made his way directly behind Mr. Redden, at which point he intended to handcuff him to remand him into custody. He unclasped his handcuffs, and immediately Mr. Redden bolted across defense counsel table.
Which is wild.
When you watch the video, you'll see that Mr. Redden hops the table, but Court Marshal Shane Brandon walked around this device that was kind of blocking his path to Judge Holthus. It's called an elmo. And in his pursuit of Mr. Redden, just as he was about to grab his legs, as he was lunging over the bench, he tripped or somehow fell. And when he fell, he sustained a huge gash to his forehead that required 25 stitches.
Right.
In addition to that gash, he severely injured his shoulder. He didn't initially notice that his shoulder was injured until he stood up in front of Judge Holthus's bench
And went, fuck.
and tried to propel himself over the bench using his arm. At that point, he realized there was something severely wrong with his arm. He had to have shoulder surgery and was placed on light duty until just a few weeks ago when he returned to full duty.
So there would have been charges for
He doesn't
that
remember a
as
whole lot
well.
of the incident, not surprising. But when he stood up and realized what was transpiring, even after he couldn't get over the bench because of his injured arm, he walked around the desk where court staff sits to assist as best he could, given the circumstances. He passed his handcuffs off to Officer Cabraldo and helped try to restrain
Right.
Mr. Redden. Eventually, court staff in Department 18 alerted the marshal next door to the emergent situation that was occurring in Department 18.
He was injured trying to get to the defendant. So there can be charges for that because it was the defendant's action. The defendant was charged with 7 things. He's only on trial. He pled to the others. He's only on trial for the attempted murder.
He is the court marshal assigned to courtroom 3E, which is directly to the left of Department 3F, which is where Judge Holthus's courtroom is. Court staff walked into the courtroom. They were in session, just like Judge Holthus, and said, "We need you now. It's an emergency. Please come now." So he walked out one of the rear exits to the courtroom like that, and then walked into the rear exit of the courtroom where these events were unfolding. When he walked in, his entrance into the judge's bench area was blocked because her chair, the law clerk's chair, had all kind of piled up right there.
As people were
He moved them,
scuffling.
and when he got to Mr. Redden had one handcuff in the cuffs and one still loose. He was still resisting very hard, and they were struggling to get the cuffs on him. So he took control of the loose
Well, at that
arm
point, he's in full fight
so
mode.
that the other
It's not
individual could get
shocking
him in
that
handcuffs.
he's not going to just stop fighting with them
Once
at that point.
the defendant, Mr. Redden, finally calmed down to the point where they felt comfortable relocating him, he was taken to the holding cell just to the
Manders,
side
yes, I
of
was eating,
where the court staff sits.
so I made myself little so I could eat.
And once he was in the holding cell, Marshal Bachhuber and the other marshals that were down there at this point did what they needed to do to document what had occurred in the courtroom.
That was loud. I'm turning that down. If they show this, I might turn it back up, but I'm not turning it up just with the beeping in the background. That's fucking terrible.
I think it's someone on blue jeans.
Oh, it's somebody on Blue Jeans. Can you mute them?
Something, oh, that wasn't her trying to play something. Something is playing through the court, and they're trying to say it's somebody through I don't know, the video system. I think it's the Blue Jeans. She was saying it's somebody on Blue Jeans. I wonder if they have access for people to watch court like Zoom, and they're just not muted. That's embarrassing in trial. The prosecutor looks so fucking agitated. I would be beside myself. I didn't have to deal with Zoom court because it wasn't a thing when I was prosecuting. That's wild. All right, well, everybody take a deep breath. God, I'd be so mad.
Some inappropriate video on there. It was inappropriate. Okay,
Did you see the clerk is like, somebody had an inappropriate video on there? Okay, so it seems that they also have Zoom access to the case or Blue Jeans access to the case. And somebody was playing inappropriate video into the courtroom and like Zoom bombed the case. Oh my goodness. Look at her. She's actually flustered. We're talking about the clerk on the very end in front of the screen. She actually is like, somebody's playing an inappropriate video. Oh my God.
oh God, what? Somebody.
Wait. Now I hear the moaning. I missed it before because this is so wild, but I missed the breathing. The breathing. I'm sorry. I would be horrified if I was in this court. But what is happening? You can hear it. I turned it down because I thought they were playing the video again. And it was so loud, but now I'm this is why we watch live court. Oh my God.
Blue Jeans are. I think it's somebody on Blue Jeans.
What?
I think it's someone on Blue Jeans.
Oh, it's somebody on Blue Jeans. Can you mute them? Stop. Oh God, what? Somebody put some inappropriate video on there. It was inappropriate. Okay, we may not be doing Blue Jeans or Zoom during the hearing, if that's going to happen.
Yeah.
Okay, I'm sorry, counsel.
It's okay.
And I'm sorry.
Somebody invite me to the National Judicial Conference to teach everybody how to not have this shit happen during Zoom court. I have thoughts. This happens. I don't know how courts still have these not locked down. Some courts are very good at it. Idaho does a really good job with it. Utah does a really good job with it, but the clerks who saw it are dying because that's absolutely wild. Oh my God. Okay.
This has never happened. At least.
Ma'am, if you've never been part of a trial that is streamed, shit that doesn't normally happen will happen because people like attention. People will do things that they would not normally do because it is being streamed. I'm dying.
Hearing, if that's going to happen. Yeah. Okay, I'm sorry, counsel. And I'm sorry. This has never happened. At least not while I've been on the bench.
It was the first time for everything.
The clerks are like,
Anyways, going back to where I was. Mr. Redden sat in the holding cell outside of the courtroom.
the fact that he didn't start laughing is, look, for the defendant to remain composed is admirable. I don't know a lot of defendants that would remain composed if somebody came into their trial and started playing porn over the speakers in the courtroom. But Cole, yes, the clerk that said it's an inappropriate video was actually like flustered. so inappropriate. It's just so wild. Oh my God. Vegas.
Before Marshal Bachhuber, Marshal Rollinson, and their lieutenant escorted him to the Clark County Detention Center. You'll hear that it's the court marshal's responsibility to book an out of custody inmate who was remanded into custody, which is why they had to do it. So they walked him over to the Clark County Detention Center where he began the booking process. You will hear from Correctional Officer Darren Needham and
This poor prosecutor.
Correctional Officer Elmis Cabrera that during the booking process,
This
the inmate
poor
sees
DA is just like,
both psych and classification. And that's done for the purposes of determining where to house these individuals. When Mr.
okay, this is getting into his statements about what happened. And he said in regards, only the judge she sentenced me to prison denied having a plan to harm the judge. So this is a eval as he's getting booked.
Redden was seen by psych on January 3rd of 2024. He reported homicidal ideations. Specifically, the report indicates, in regards to homicidal ideation, patient stated, only the judge, she sentenced me to prison. He denied having a plan to harm her.
So when asked, he was like, no, the judge sentenced me to prison and I decided that that was the end of that. So yes, after the fact, in his evaluation, he indicated that he was going to harm the judge. That's probably why this is charged as an attempted murder.
He also denied thoughts or intent to harm officers or other patients, or anyone other than the judge who sent him to prison.
Whitney in the chat said courtroom gets heated in a way that we're not used to.
Because of his expression of homicidal ideations, they determined it would be best to house him in Unit 2C. You will hear that Unit 2C is the unit where they send people with homicidal ideations, among other things. But with regards to his classification in 2C, it was because of his statements. So officers Darren Meekum and Elmis Cabrera went to transfer release, where the defendant had been waiting for classification. They were tasked with the responsibility of getting him dressed out into his Clark County Detention Center uniform, as well as performing what they refer to as a strip search. You'll see the video of them in the area, but there's no audio.
Yeah, we don't need the video of this.
Officer Darren Meacham is the
search,
taller
please.
individual standing at the
It's already
front.
been a full ass morning.
Officer Cabrera is the individual off to his left. And when they walked into the cell, it was a single person cell. He was by himself. They observed him casually laying on the bench with his hands behind his head. They gave him commands, told him what they were there for, and he spontaneously stated to them, "Sorry I'm moving so slow. I'm kind of sore today. I tried to kill a judge."
Well, there's the context.
Those statements that Mr. Redden made and that violent attack against 62-year-old Judge
That
Mallory
explains what he was trying to do.
are the reason that we're all here today. And when the state is done presenting its evidence, we are going to ask that you return a verdict of guilty as to the only charge in this case.
Wow. Kaylo said, I was not prepared to have pearls clutched this morning. Me neither.
Thank you.
Jolene, it seems that somebody put it on the Zoom and it played through court because the Zoom was not muted. I think somebody was trying to be disruptive. For those asking, how do you dispute the defendant's statement? He is going to trial over a NGI, so trying to not be sentenced to prison, but to be sentenced to mental health treatment. So that it's disputed, but it's also trying to figure out where you go. And so that's where we're at. All right, let's continue. The defense is going to present their opening statements. I'm interested to see what they have to say. But what a wild morning in court.
Do you want me to get back on Zoom or no?
Not right now, I want to make sure his presentation's unobstructed.
Okay.
The prosecution's presentation was very obstructive, but we had the video.
May it please the court, counsel, ladies and gentlemen of the jury.
And now
Thank you for
defense
your
opening
time.
statements.
3.7 seconds. 3.7 seconds.
Is he the same attorney on the Keefe D case? I'm going to have to check. He sounds like the same attorney that's on the Keefe D case. So let me back up because now I'm confused.
0.7 seconds. 3.7 seconds.
2 steps ahead. I was always 2 steps ahead. Hold on. I'm going to back up and I'm trying to wrangle my brain back in, but I think he's the same defense attorney from the Keefe D trial. Keefe D's accused of killing Tupac Shakur, well, being involved with procuring the gun and what have you. So 3.7 seconds. Is he going to argue it's not enough time to premeditate his actions?
Thank you for your time and attention. 3.7 seconds. 3.7 seconds. That was when the officer unclaps the handcuffs. My client heard it, turned and looked at him, and made a move for the bench. This all occurred in 3.7 seconds.
That's not what the jury instruction says, though. It says it can be a split second. But we didn't have this perspective of the video earlier, so I'm interested to see this. You can see, that's really interesting. You can see the deputy move for his handcuffs. I'm backing it up a little. Emily, are we going full, like, play-by-play? Yep. So the deputy's moving closer to the defendant because the court is saying on the record things that indicate that he is going into custody, not that he is going to be released to probation. The judge also probably gave the deputy the heads up because she had made notes on her calendar that morning and had noted that she was sentencing him. Like, that was what she was inclined to do. Yes, she could have still changed her mind, but that's what she was inclined to do. And she would have told the bailiff that to give him a heads up so he's not caught unaware. But as he's unclapping, because you have the cuffs in a little pouch and you unsnap it and then you can hear the cuffs, it seems like the noise just absolutely sent this defendant into full fight mode. So, and you can see it. You can see him unsnapping his cuffs right there. I've not seen this from that angle. I've only seen the other angle. It is really quick.
3.7 seconds. That was not enough time for Mr. Redden to formulate the intent to kill Judge Holthus.
Well, that's not what the jury instructions
Remember
say.
what this case is about. There was one count of attempted murder. And for there to be an attempted murder, there has to be intent to kill. As everything else in life, the story didn't begin on January 13th. This story actually occurred on April 13th, 2020.
It's interesting that they brought in the nature of his charges. The DA didn't touch on it at all. The defense is allowed to, but the defense, it's interesting that the defense is choosing to bring that in. I'm curious where they go with that.
23. This is when Mr. Redden was first arrested for what brought him in front of Judge Holthus. And basically, Mr. Redden was arrested for swinging a metal baseball bat at his brother-in-law. What was he charged with? He was charged with assault with a deadly weapon. He was also
Baseball bat.
apprehended by the police, and he was taken into custody. When you're taken into custody, you're supposed to within 48 hours, stand before a magistrate so they could decide the question of bail or not.
Lead
Mr.
attorney, good
Redden,
to see you
on
in the
April
chat.
13th, told the officers that
Sir, did you cover this? I will have to go watch. It's wild to me that the defense is bringing in that he was attacking his brother-in-law with a baseball bat, but it's good to see you this morning. If you guys don't know lead attorney, he streams over on his channel and covers a lot of court. I found his channel when he was doing day-by-day, play-by-play of the Cardi B, Tasha K defamation case down there in Georgia. Good to see you in the chat.
had him in custody, that he refused to be transported. So he was just going to stay in custody without these charges being read to him. The following week, they waited some time.
Oh, he was a
to continue
refusal.
the matter. On April 20th, 2023, Mr. Redden, he failed to leave his jail cell again.
He didn't want to
He
be part of
says
any of
that
this.
he wasn't coming to the hearing. They had to continue the hearing. Again, on April 25th,
Did they have to?
Mr. Redden refused to be transported to the heading.
Emily, just keep listening to the opening. All things will become clear. Did they have to extract him to bring him to court? The order issued by Judge Cisneto to be transported by any means necessary. So he was a miss out for 5 days and then an extraction. Here's the reason a judge would issue an extraction is because when somebody misses out this long and hasn't gotten to court, the law requires you to appear before a magistrate. You can't just stay in your cell and be like, I don't want to go, and then have your defense attorney come in and be like, well, you haven't arraigned him within the time period, so you have violated his constitutional rights by not bringing him to court. So there gets to be a point, and this is different based on jurisdiction, but there is a point where the judge has to order the defendant be extracted from their cell and brought into court. So they can only miss out so many times, and they would have tried to bring him into court and told him every day, if you don't go to court, we are going to have to drag you out of here, literally shackled, all of the shackles to get you into court, because they have to appear before a magistrate. And not every jurisdiction has judges that are in. Some judges will go into custody and do all of the arraignments in the jailhouse. Sometimes they'll do it on Zoom. Sometimes they just can't. So it's interesting to me that in the weeks leading up to this, he was a miss out, and then they ordered an extraction.
Finally, the Justice Court Judge Jacinto, he did an order that says, by any means necessary, he needs to be present in this courtroom. So on April 26th, the officers got Mr. Redden, and he was present. The judge then, he's handed the charges. The judge asked him if he understood the charges. Mr. Redden didn't even respond to the judge's questions, even though he had a copy of the information, which was assault with a deadly weapon, on his person. And not only did he not answer the judge's questions, he became disruptive in the court proceedings. At this point, again, we have almost a week plus that we see this individual not coming to court. Once he gets to court, he's being disruptive and he's not participating in the court proceedings.
Shocking.
At this point, his attorney, which was a public defender.
And don't shade the public defender, sir. Aren't you also a public defender? What is the shade? I don't like the defense attorney shade. Maybe it's not shade. I'll keep listening. But it's not surprising to me that someone who doesn't want to go to court and is then extracted to go to court shows up in court and is like, I don't want to fucking be here. This doesn't surprise anyone.
Then petitions the court to send him to what's called competency court. Competency court is a whole
Right, they did
a
evaluation
here in our building. And competency court is for people that do not understand the legal proceedings, are unable to assist their attorneys in their defense, or number 3, appear to have some kind of mental condition that prohibits them from acting properly in court.
Setting him to an eval is not a
All
surprise.
those things were exhibited by my client, Mr. Redden. He was sent there to be evaluated and see if he can be restored to competency. Restored to competency is basically, we can't try you. We cannot prosecute you under the law since you're not understanding what's going on. You're not displaying courtroom behavior, you're not helping your attorney out. We can't sit here and prosecute you.
Competency can be restored depending on what the underlying reason is. This is what Tom Girardi tried, right? Tom Girardi tried to say, I'm incompetent to stand trial. And they're like, sir, you're in your 80s, but no. There are some that cannot assist with their defense and cannot be restored to competency through treatment, medication, or other means. And then they go into, depending on the jurisdiction, a mental health system, and generally stay there if they can't be returned to competency, depending on what the charges are. So that is a whole different side of the criminal justice system, and it is complex. But people can go through getting an evaluation and then go through getting mental health treatment and then be restored to competency because they are being adequately treated in the way that they need. And then they're like, oh, and here we are. So maybe if people could receive that treatment, outside of the criminal justice system, we wouldn't all be here. But don't get me ranting today.
So basically, he's found.
So then he was committed.
He's sent to Lake Crossing. Lake Crossing is a mental institution here in town, and what they do at Lake Crossing is make sure that you're evaluated to test your competency. Sometimes, people are sent there and they have lingering symptoms like they're just making up, acting crazy. Other times, they sit there and evaluate someone and their mental instability is so severe, they just have to stay at Lakes Crossing for an indefinite amount of time because, again, the state can't prosecute you under that incompetency. So in regards to Mr. Redden, he was evaluated.
Remember, they are looking for a mental health defense. That's why they're going for this.
Who will be here and he'll testify in regards to this case and in regards to his finding of incompetency. And there are other psychiatrists because there at least has to be two that make that determination. And what they determined was he was incompetent to stand trial. And so he was given a course of medication because his evaluation indicated that during this course of medication that would calm him down, bring him back to earth, bring him to a person that we can work with, that he can go to court, he can understand the proceedings, and not be disruptive in court. So Mr. Redden, when you go back to that one, I just want to make the last point that he was at Lakes Crossing for 5 months. He is eventually found by the doctors on October 20th, 2023, to be competent to go ahead and proceed with trial. So exactly 5 months later. Go ahead now, sir. After he returned back to Justice Court, he was in front of Judge Jacinto. He had discussions with his attorney at
This is his whole background before he flew onto the bench.
And enter into a guilty plea with the state of Nevada. Again, now he's of right mind. He is able to discuss his case with his attorney. As you can see, there was no courtroom outbursts or anything like that. And so much so, the judge released him on November 1st, 2023. He was released from custody. Okay? He returns to back to court, and now this is district court. This is in front of Judge Holthus. And on December 6th, he has no.
He went into so much more detail than the prosecution did. But remember, the defense is laying out that this is a NGI defense, saying, look, he was on his medication and he was fine. And I think where we're going with this, because we heard it in the sentencing before the leaping on the bench, is that He had gotten out of custody and then was not able to follow up with care and then was off of his medication and was not fine. So the reason Brianne in the chat asked, how is this helping him? That's how. They are not saying he didn't do it. It's on video. He said, I'm a little sore. I tried to kill a judge today. They're not trying to say that he didn't. They are trying to explain why he didn't so that the jury will say what he needs is not prison, but mental health, a locked mental health facility, and he needs to receive treatment. So they are, that is what they're arguing. There's not a lot of arguing that he didn't. So what they're saying is leading up to his guilty plea, it was fine. He was released. And then there was no follow-up care. And then we end up here. So that's why he's going through this so extensively.
Behavior goes ahead and the guilty plea agreement's read to him. He answers a myriad of questions and he pleads guilty to attempt assault with a deadly weapon. The sentencing was scheduled for January 3rd, 2024. Next slide. What you're going to see through medical records, through the testimony of Dr. Paglini, Mr. Redden did not receive his medication that he had.
Right, that's what I thought.
While he was
this was going
here in Clark County Detention Center. What happened was he gets released and he's given a prescription. That prescription is supposed to be filled at the Mojave Health Center. He calls and you'll hear testimony from Karen Springer. Karen Springer is his foster mother that he stayed with during this time. They made several attempts at appointments, called and attempted to get him in so he could take his medication. However, you'll see through the testimony, he does not get medication and he doesn't get it for 2 months. So from November 1st to 2020, and November 1st, 2023 to January 3rd, 2024, a period of 60 days, he does not have his medication that put him in that state where we saw the appropriate behavior. What you're seeing today, basically, he's under that medication that he had when he was in CCDC. And that's why he's displaying, good decorum, appropriate courtroom behavior.
Interesting.
He's not going to wild out, and trust me, I'll tackle him if he tries to, do anything like that. But bottom line, that's not going to happen.
That's an interest. It's interesting that his defense attorney is like, ladies and gentlemen, you don't need to be scared. This is not someone you need to be scared of. He's not going to wild out in court. Don't worry, I've got him. I don't think I've ever seen a defense attorney be like, I'll just tackle my client. But he's trying to make the point because his ultimate argument is that this defendant was acting out in court, attacking the judge because of mental illness, and he wasn't being medicated for it. He is now being medicated for it because the lawyer wants the jury to say, yes, what he needs is mental health treatment, not prison. So the lawyer's argument is what we need is mental health treatment, not prison. This is, again, I am particularly sensitive to it. Maybe more so, but our chat is very neurospicy, and all of you know the struggles when you can't get medication for whatever it is, including ADHD. I'm going to try not to rant about med shortages, about how long it takes people to get in for appointments, about the fact that when you're on a medication to help you focus and do the tasks, you have to make appointments every month to still be on the medication to do the things. I could go forever. It is not easy. It is not an easy system to work within. And so I understand the defense attorney trying to say what we need is treatment, not prison. And this is a huge part of our criminal justice system that we don't see highlighted in a lot of the cases that we cover. A lot of the cases we cover don't deal with this side of our criminal justice system, which is how do you work within the fact that our criminal justice system has a huge component of mental health that is part of the system. So what do you do when someone is on their meds and is compliant and can function within society, and then is released from custody and cannot get their medication, and then comes back into court and attacks the judge. It makes it very hard. So this highlights, and I think this case shines a light on, this is beyond somebody going into full like fight mode in court, but it highlights a lot of what the criminal justice system deals with every single day. But our criminal justice system shouldn't be a mental health system. But I digress. We're going to continue on. If the people are well, then things are better. But I could rant forever. So I hear you. Tracy in the chat, thank you for that. Tracy said, it is the same attorney on the KVD case. He was retained for this guy too, not a public defender. I thought he was, but also you will see me get spicy when people take digs at public defenders, because I think public defenders, A, overworked, B, totally needed in our system. Their clients take pot shots at them enough. I don't like it when other attorneys take shots at public defenders, because they do the work a lot of people don't do, but they are incredibly valuable. And most of them are incredibly good attorneys. And any DA that would tell you otherwise, well, maybe has different experiences than I do, and I don't want to discount that. But the defense attorneys I have worked with and the public defenders I've worked with are excellent attorneys and are in court all the time and are compassionate towards their clients. It's why they do the work they do. So when people just want to take shots at like, that's the public defender, you will always see it ruffle my feathers. But I've had such positive experiences with public defenders, and then I've had some negative experiences with privately retained attorneys who think their shit doesn't stink, who would get the courtroom wiped with them by public defenders. Dr. Barry says, Natalie Lawyerchick is a public defender. She's amazing. And they really do not get the respect they deserve. Ian Runkle is also a defense attorney and a public defender. They are great attorneys who choose to do a job that is incredibly needed. So I'm done ranting, but I hate it when private attorneys take shots, like private defense attorneys taking shots at public defenders pisses me off. Triggered. Just triggered.
He's medicated, he's calm, he understands what the proceedings are and what's going on right now. During this 60 days, Mr. Redden slipped back into his unstable mental state.
So I'm going to let him finish his
opening. He was first arrested for assault with a deadly weapon and charged and eventually pled to attempted assault with a deadly weapon. Next. Then we have this unfortunate incident that happened on January 3rd, 2024. One thing I noticed.
Also, I hate the white background of the PowerPoint, but now we're getting through the day of the incident. Again, very easy to follow. January 3rd is the day this happened. He didn't take his medication. They're arguing no intent. Intent can be formed in a split second, and that's what the jury instructions will say.
I looked at this videotape several times from the very beginning to the very end. I know that all the parties involved. A simple question wasn't asked. And I'll explain later as to why it wasn't asked. But no one asked Mr. Redden, did you take your medication today?
I mean, that's not really the court's job.
His attorney didn't ask.
Oh, that's why he's taking shots at the defense attorney.
Nor Judge Holthus asked. I'm not saying this is anybody's fault. It simply wasn't done. So he comes into court.
His family stated it on the record, though.
What his real mental state is.
His family said it.
Time. Nobody knows that for 60 days, he's been having paranoid thoughts. Nobody knows that he's been staying at home, not going out into the public, and different other things that were discovered by
Maybe
Dr.
it was said the next court hearing.
discussed.
It did come up, but it might have been the next court hearing.
Mr. Redden did not intend to kill Judge Holthus. The evidence will show that Judge Holthus, she hurt her head when she struck the
You're
wall
losing
that
me,
was
sir.
directly behind her.
Sir, look, she is a 65-year-old woman. She didn't fall off of her chair. She struck her head. The defendant didn't hurt her. It was the wall. We're not going full bring it on. I didn't break her arm. It was the position with which she hit the ground. Like, no, sir. The reason the judge hit the wall is because your client leapt upon her from the ground. She was not striking your head, even though you don't see bruising under somebody's hair, can cause medical. Sir, you are making me mad with this. This is not on the judge, dude.
She also was hurt when she fell on the floor. You'll see pictures.
She's hurt from falling on the floor, y'all. It's not because breathe, Emily. Just let him finish.
Wasn't significantly bruised. She was bruised, but it wasn't significant bruises. And those were basically on the areas where she fell. She had no cut.
She didn't fall.
She had no strangulation
She was
marks on her throat.
attacked.
There will be no evidence that anybody ever that saw Mr. Redden touch her throat. We'll have specific evidence of where his hands were placed right before he was pulled off.
Why are you
by
bringing
Judge
that up?
Holthus. But again, his actions do not indicate that he was intending.
I mean, but his
to
statements
kill
kind of
Judge
do.
Holthus. And again, you always have to go back to intent. That is going to be the big question that you guys are going to have to deal with at closing. Did he have the intent to go ahead and kill?
That's the
We're
argument.
going to submit that the evidence does not show there is any intent to kill Judge Holthus. Thank you.
The intent to kill.
Counsel,
I wonder if they're not going to go further with the NGI defense other than saying there was no intent to kill. They're going to be finishing up this court day, so we're going to zoom to the witnesses because they do opening statements and dismiss the jury. They are running this court on half days, so they're going to dismiss the jury, and I don't think there is much more to this day other than them dismissing the jury and resuming on the record. So the jury is being dismissed.
To the jury, although
Okay, I'm going to back up because I want to see if they talk about the porn. I was going to just go to the witnesses, but I didn't know that somebody like porn bombed the Zoom that the jury heard, and I'm confused how the court deals with this. So that's where we're at. The jury is leaving the
Has left
courtroom.
the courtroom, and you may be seated.
I want to hear what happens.
Norma, what exactly, do you know what happened?
Excuse me, y'all. What the fuck happened during opening statements?
I don't know what happened, but when I switched to Zoom, there was a very improper video.
Okay. Counsel, I mean, I want to be able to give the public access to the Zoom and all that. I'm just not.
No, fuck that. I'm sorry. If people are going to wild out, they don't need access to the Zoom if you've allowed pool cameras. I think the court is allowed to say, we will give a link for family members through the DA's office, through court staff, through the DA's office. But you can absolutely close it down. This is being streamed. They can go watch it on court TV. Like, no, screw that. Jacqueline, we're going through this entire case today. So.
We've called IT about this?
I reported it, yes.
Okay. Never had this happen before, but apparently something very
Public
inappropriate
cases.
went on the Zoom system.
Public
We
cases.
cannot have that.
No
and,
shit.
So anybody that wants to see this, definitely you might want to consider being inside the courtroom for that.
Just
And then
watch
we'll see
it
what
here.
we can do on our end so it doesn't happen again. And I apologize again to you for that interruption.
just for the record,
I will say that Utah does this very well. I've accessed the Utah public hearing system a couple times for the Frankie case and the Corey Richards case. When you enter the system, if you are not one of the attorneys, you have a separate entry and you just hear it on, you just hear the audio feed for the court. There are courts that know how to handle this. The problem is the courts talk within their state. They don't always talk with other states on how these solutions are. So each court has different tech solutions. We know that not all courts know how to mute the participants when they come in, so they can't unmute themselves. And courts forget to do that. So I think when you've allowed a pool camera in, it's appropriate to say the only people who have access to a Zoom are given access either through the defense attorney, through the district attorney's office, or through like victim witness assistance.
At no point was that broadcast visually to the jury. Although it was audible, we couldn't really tell what it was, in my opinion. But
I had to rewind it a couple times, and then we could definitely tell what it was. There was moaning.
visually, it was not in any way broadcast to the jury.
Yeah, I didn't think that it was either, so, no, she was the only one, I didn't see it on any of my screens.
Yeah, it only came up on Zoom.
And she was like,
I only had access to it.
she was like,
Okay, all right, but anyway, we will try and find out what happened there, okay? Okay, schedule, 1 o'clock tomorrow, we'll have a full day on Friday, half a day on Monday, half a day Tuesday, half a day Wednesday, if we get into Wednesday.
so they are
Okay,
running half days.
And start thinking about those jury instructions. Of course, the most important document is the verdict form that we will need
All
to
right.
get through. If you guys.
That's
could
day
agree-
1 done. There was a intrusion into court. We're going to go to day 2. The witnesses I really wanted to see in this case are on day 2, which is the judge, victim, and the clerk that worked with her. When I saw that this was going to trial, I wanted to see opening statements in those 2 witnesses. And guess what we get to do today? We get to see opening statements in those 2 witnesses. So we are zooming on to day 2. And on day 2, we are going to see from witness judge and witness clerk of court. So let's zoom until the audio comes in and the jury comes into court as we are getting started. I love the ability to zoom. Hopefully the opening statements were illuminating. I thought they were incredibly helpful. Let's see. The defendant is standing up for the jury to come in. There we go. And the jury is back on day 2. Again, they were running half days. Part of the reason I didn't cover this live is because they were running half days after 2 p.m. Pacific.
You promise swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the
And that
truth, so help
becomes
you God.
difficult.
And can you please state and spell your name for the record?
Mary Kay Holthus,
This has
M-A-R-Y,
got to be bizarre for this judge to have to testify in front of one of her colleagues.
Really fast.
Okay, I'm nervous on this side.
The judge is like, I'm a little nervous on this side. This is Judge Mary Holtz, witness 1. Your Honor, can you tell me what you use on your hair? Because I'm trying to embrace my natural wavy girl situation. You've kind of got that nailed, and I've got questions.
Judicial district court judge.
I am.
How long have
Also, thank you, Court TV. Court TV has indicated, wait, where do we go? Who their witness is. I appreciate this so much. There's no massive lower third, but we've got the judge and we've got state's witness number 1. I appreciate that. So we are keeping track. Let's continue on. That is Judge Mary Holthus, and we will continue on with her testimony.
you been on the bench?
Since 2019.
Oh, I'm going to,
Elected or appointed?
Elected.
I don't think that's
Since
relevant.
then, have you handled what we refer to as a mixed docket?
I have.
Can you describe what that is for the jury, please?
Means I do half criminal and half civil. So on some days I'm doing civil trials and calendars, and opposite days I'm doing criminal.
That would be hard.
Focusing on criminal calendars, what types of matters are you handling on a day-to-day basis?
All types that come to the district court, which are basically felonies and gross misdemeanors.
Are there various types of hearings associated with criminal cases?
There are.
Would that include arraignments, guilty pleas, sentencings, revocations, and trials such as this?
It would.
Can you explain to the jury briefly what a guilty
I appreciate that they appear to have a holder for a microphone so that it is where people's mouths are. Thank you, Nevada. I have optimism that when we get into the KFD trial in November, I think we have 3 or 4 more trials that I want to cover this year. Before we get into this trial in November, that we're going to have the tech nailed in the courtroom. And thank you for those of you reminding me to put subtitles on for day 2.
A guilty plea hearing is when, I mean, obviously, you know, most cases don't go to trial, they negotiate. And it's a negotiation between the defense attorney and the state. Defendant will enter into a guilty plea agreement. And then at the guilty plea hearing,
I'm just covering it
we do
today.
a canvas.
It's short.
They review paperwork, sign off on it, and then we also engage them orally to make sure they understand everything they're doing and the rights that they're giving up in exchange for their guilty pleas.
Subsequent to a guilty plea hearing, is in the matter set for sentencing.
It is.
And what is a sentence?
A sentencing is when they're going to be sentenced pursuant to negotiation or otherwise, whether they're going to get probation or prison. After we accept the guilty plea, we refer the matter to parole and probation. Parole and probation does what we call pre-sentence investigation report, criminal
PSR.
background, social background, medical background, all the history of the individual for consideration ultimately in passing sentencing.
Are there times in which a criminal defendant will appear in front of you out of custody?
Yes,
And are there other times in which they will appear in custody?
yes,
As a result of that, are there some sentencing hearings in which people are remanded into custody from out of custody?
there are.
Are there security measures in place in the courtroom for these out of custody defendants?
Yes, she did not say verbally. Oral instructions.
Well, there's security in the courtroom. We have marshals and we have corrections officers watching. I don't know per se if there's anything special.
No, that answers the question. Are there times in which you will sentence someone to probation?
Yes,
Other times in which you may send them into custody, correct?
yes,
When you sentence someone to probation, are they still monitored by the court itself?
and not by the court, by parole and probation.
And what is parole and probation?
Parole and probation is the division responsible for supervising individuals that are on probation. They may have to report, they tell them what to do, help them find jobs, or put them in programming, get evaluations to see what kind of programming is best to serve that individual.
Are there times in which defendants who you've presided over will get probation, they'll go out into the community, and then they'll essentially mess up on probation itself?
Yes,
And would they be brought back in front of you at that point in time?
not right away. Sometimes P&P tends to work with them a lot of times to give them multiple chances. But at some point, when they get to a certain level, then parole and probation will put on what we call a violation report, saying that they're violating their probation. Judge,
Okay.
it's time for you to
While we're
take
doing
a look. We
background,
think
we're going
they
to go to
should
1.25.
Go do their time now.
And then
that
when
goes in front
we
of
get to
you,
the
or
incident,
that's
we'll
that
slow down to normal speed.
Revocation hearing?
At revocation hearings, do you essentially make a decision if the
She's just giving the background, and once we get past background, we'll go to real time.
Yes.
I want to bring you back to November 20th of 2023. On that date, do you recall whether or not you took a guilty plea from the defendant in a prior case?
I do not specifically.
When I say the defendant.
She would need to look at her docket, I'm sure.
I do.
Who?
Mr. Redden?
Do you see Mr. Redden in court?
I do. Sitting between his two attorneys over there at the table.
Would the record reflect identification of the defendant?
Okay, there's three gentlemen and he's.
Middle
somewhere in
guy.
the middle?
Yep.
Okay, let the record so reflect.
So as you sit here today, you don't recall taking a plea from the defendant?
I do not.
If I were to show you a document that memorializes that plea, would that maybe refresh your?
Probably.
May I approach?
Yes.
I mean, they're dealing with
I'm so sorry.
20, 30.
I'm so sorry.
He's like, may I approach? And she said, yes. She's very used to being the judge, not the witness. But that's what that is. So for those of you asking, is the witness still working as a judge? Yeah. Like a couple courtrooms down the hall in this courthouse.
So I'm showing you court minutes as well as a guilty plea from November 20th
But they deal with
of
30
2023.
plus cases a
Are
day.
court
You're
minutes
not going to
essentially
remember
a
them
record
all.
of any court proceeding that happens
They are.
in the court. Do you recognize your name on there?
I do.
And do you see journal entry which suggests that you took the defendant's plea?
Yes.
Okay. And that would be on November 20th of 2023?
Correct.
Do you remember which charges he pled guilty to?
Attempt battery, substantial bodily harm.
Okay.
That I remember.
Okay. And so.
Well,
on
because
this
that became
particular
relevant
date,
later.
When you took the defendant's plea in the prior case, was he released from custody?
He was.
And was that pursuant to an agreement in the guilty plea?
Correct.
When he's released from custody, I would presume he goes back out into the community. Is that
He
correct?
does.
And then you set a proceeding to follow the guilty plea.
Correct. The
You want
sentencing. The sentencing date.
And you talked a little bit about the sentencing date. You mentioned that you received some materials to review in order to prepare for a sentence.
Right.
And in this
As one
particular
does.
case, did you receive those materials?
I did.
And what were those materials?
Well, I always have the guilty plea agreement, so I know what the.
I will say, though, the background of what happens is necessary. It can be a little dry because we're like, yes, get to the flying over the bench part. But do you notice how concise the prosecution's questions are? This, and then this, and then this, and then this. It is one question, like 5 words. And did you do that? So the questions are all broken up into 2 parts. Did you take a guilty plea agreement? Yes. Did you do it on that day? Yes. Did you have documents to review? Yes. Did you review those documents? Yes. What were those documents? Short, straight to the point, direct questions. That is the type of questioning you want to see on a good direct examination.
Negotiations were, and the pre-sentence investigation report,
If-
primarily.
It's good questioning.
If sentencing was set in this
Concise.
case on January 3rd of this year, when would you have prepared your calendar and reviewed those materials?
Sometime in the week prior,
And
usually
so-
closer.
Nowhere does keep it simple matter more than in court. Just keep it simple.
In time, so I remember. I don't remember because it was a holiday kind of time. It was our first day back. It may have been like the Friday before.
Okay. And so you know some things in advance about the defendant when you're going in to do a sentencing hearing. Is that
Oh, yeah,
do you remember reviewing a PSI in this case?
I do.
Can you explain just briefly for the jury, when you're reviewing a PSI, what are the types of things you're looking for?
How do you do your
in
job?
order to determine the appropriate sentence?
Which is interesting. We
Generally,
never
the
see-
first thing, partly
Judges
because
explain
first in the PSI is the age. Because depending on whether, if it's somebody older who's never been in trouble before versus somebody super young, a lot harder to send an 18-year-old to prison, to be honest. And just kind of, so age is what I look at first.
Continue.
And then I kind of peruse, is it somebody, do they have a lot of AKAs? That kind of gives you a little heads up. A look at the family. You're saying if their AKA on their official indictment is something like the ketamine queen, that might strike you as a red flag? I am shocked. We never get to hear this. I hear this in the conversations I have with people I know that are judges, but people who work outside the criminal justice system and don't work in courts like this, you never really get to hear from a judge how they go through this process. This is fairly unique that you've got a judge as a witness talking about how they do their job, how they prep their docket, and how they go through and decide the things they have to decide every day, which is how do you choose? How do you choose who gets probation? How do you choose who gets another chance? How do you choose who goes to prison? How do you decide that if this person's allowed to be on probation, the victim that they were attacking with a baseball bat, they don't go back to that same evening and harm or kill? How do you make those determinations about the chances that the defendant gets and deserves versus the safety to the victims and the public? And how do you meld those things together? And that's not something we hear often. So for those of you asking about AKAs, as otherwise known as, you will see at times when defendants use a lot of different names, they tend to do that to try to move through the system without having warrants detected, without getting picked up on things. So background to kind of see what we're dealing with. Looking at the background who's had their record, problems growing up. Has there been foster care kinds of situation? What's the family situation? Who are they as a whole person? Dad's in prison, mom took off, raised by grandma. All those things that you're kind of mitigating maybe on some level the behavior or trying to understand. Who are they as a whole person? Obviously, one of the big things is the criminal history. I always jot down how many felonies, how many gross misdemeanors, how many misdemeanors, and then looking specifically at those, what types are they? Is this somebody who's got a drug issue that needs to be addressed? Are we looking at stolen identity of another, possessions of credit cards and stuff, which more often that also indicates a drug problem and where these crimes are focused. And then kind of in a separate category is violence. And sex offenders, I suppose, another one that are a little bit different.
Is prior violence an important factor?
She's like, you see theft, and you can look at theft as related to a lot of life circumstances and things. So you're looking at, are we dealing with a lot of theft-related crimes? And what theft-related crimes are we dealing with? Are we dealing with crimes of violence? Are we dealing with sex offenders and other crimes? So when you're looking at how she categorized them, that's what you're seeing. Foley says, run for judge or magistrate. No, Foley, I appreciate that means you have faith in me. My face comes with subtitles. Also, the amount of tedious paperwork that is required, my ADHD brain could never I've worked with judges. I have friends that are judges. I worked as a research attorney for judges. I love doing this. I am meant to do this. I could not. I could not. Also, having to run in an election sounds miserable. Also, I'm not licensed in the state where I live, so that's not going to work. I will talk to judges about how to make their Zoom court better all day long. I would love to talk to judicial conferences about how we're going to deal with like AI, deep fakes and evidence and in court. I think there's room where I can help without being on the bench. And I would like to help in those ways. And I think helping us all understand the law makes us all better citizens. And so I feel like we get to do some good over here and I like it. So this is more fun. I can't sit during, could you imagine me as a judge sitting during the prosecution's opening statement being like, what? No. Really? He said that? Shock. Like, no, I lack what they call judicial temperament.
You when deciding whether to put someone back out on the streets or put them into custody.
Hugely.
And in this particular case, did you note prior violence in Mr. Redden's history when reviewing his PSI?
I did.
As you sit here today, do you have a recollection of any specifics?
I know that when I did the PSI, he was about 30 years old, and his first criminal conviction was in 2012, battery domestic violence. So literally, he hit 18 and it's domestic violence on his record.
Yeah,
And
that's
throughout the remainder.
When you see somebody who is first in the adult system with domestic violence, it becomes a concern immediately that it's not just crimes of violence, but it's crimes of violence perpetrated against those that are either they are living with, they are in a relationship with. That a judge starts to look at that with an early history of domestic violence and just being like, ew.
Until I saw him again, he averaged one battery domestic violence conviction a year, always. He had 3 felony convictions.
That's not going
he had
to
an
go
attempt
well.
theft that actually started out, it was pled to an attempt theft, but it started out as a robbery, which is the
With a
violent
weapon?
taking of property from someone else
Well,
against their will.
violent taking. Yep.
A classic crime of violence. He had 2 battery domestic violence felony convictions. You get a felony after you have so many misdemeanors, they start becoming felony. He had a battery with substantial bodily harm conviction. He had a gross misdemeanor for malicious destruction of private property, which started out as a attempt home invasion, meaning kicking in someone's home. Again, pled down to the malicious destruction. But I believe that was the one I had in mind.
She's highlighting this because he had a lot of chances where there were felonies that were reduced down. This is why the judge gave the instruction earlier that you're going to hear his background, but you can't hold his background against him. But the judge needs to explain why he was going to prison. And you're looking at, there's a case, it gets reduced and he gets a chance. Then there's another case and he gets reduced and it's another chance. But at some point, the judge has to look at the victims of domestic violence and be like, if you've got this history of domestic violence, at some point, it is not safe for you and everyone else. So that's where these scales are being tipped. And that's where the judge is like, he was given opportunity after opportunity after opportunity. This wasn't a first-time offense. Remember, the Darrell Brooks incident in Waukesha started as a domestic violence incident. That domestic violence incident that he was in the middle of was broken up by his partner's friend. And then he went off and perpetrated violence against the entire town of Waukesha at the parade. It started as a DV incident. So when you're looking at DV on a record, you are looking at a different type of individual than you are looking at if you were looking at habitual theft crimes related to drug dependency or what have you. So that's why she's explaining it.
I didn't recall it, but I've since learned that he was in my department on probation for that. And I ultimately revoked him because of
that
the
history
case that I was seeing him on back at the time of the attack.
Okay, so that's a lot of information.
I know, sorry. I do that.
I appreciate that.
Okay, do me a favor, both of you, make sure you let him get his question out before you respond and vice versa.
And I've got them sped up.
Court reporter is really good at what she does, but she's never mastered the art of taking down 2 people at the same time. Sorry.
In addition to criminal history, are you also reviewing the PSI to determine if that individual has had opportunities, probation,
This is that
services,
part.
mental health treatment, and all those types?
Absolutely.
And in this case, as you perused Mr. Redden's PSI, did you see evidence to suggest that he had several opportunities with the system when it comes to services?
I did. All of the crimes that we see, they're in a chart form, and then next to the chart is kind of what they got, probation, prison, violations and whatnot. And so you can tell that he had probation a number of times, that he had violated a number of times. According to his report, he had gone through mental health court. And
I will say, because twin mom is talking about IPV, there is a reason I did not refer to this as IPV, because a lot of his cases were perpetrated against family members, not relational partners. So when we are looking at domestic violence in the court system like this and those prosecutions, some of them are against a brother, some of them are against other family members. So they're not all against a relational partner in that way. They are against other family members, because domestic violence under the criminal system. So when we were talking about criminal cases, can be somebody that you are living with that's like a roommate. It doesn't necessarily also have the romantic relationship component. So that's why I was talking about domestic violence specifically, because a lot of these cases are not a partner case. They are family members, people that he's living with, things like that. So that was a choice on my part so that we're accurate with what the case is, if that helps.
multiple sanctions and got in trouble a lot of times, but ultimately was passed through and graduated from the mental health court program. According to the PSI 2 times, he definitely had jail terms, and he had been to prison for on 1 term.
And so you had mentioned a moment ago, you have since realized that you previously revoked his probation.
Correct.
I want the record to be clear about that. When you're reviewing his PSI, preparing to sentence him on the incident, you don't recall that information.
No, no clue.
Fair to say there are hundreds, if not thousands, of criminal defendants who've come in front of you over the years.
Yes.
And you have since learned that you had previously revoked his probation and sent him to jail.
Correct. And I don't know if I sent him to jail. I don't know if he was in custody and he stipulated that he had violated his probation. I mean, he may have been agreeable to it. I don't know any of the facts of that. I just know that I somehow ruled you're revoked.
Understood. I want to now move forward to January 3rd of this year. So on that date, you proceed into court for your criminal calendar. Do you remember how many matters you had on that day?
I don't.
Were there a mix of both in custody and out of custody defendants?
Yes.
At some point in time, did Mr. Redden, was his case called?
It was.
If you can summarize for the jury what happened when his case was called initially.
I mean, nothing. It was just the typical. He was in on a bench warrant return as well, because after we let him out, he didn't show up. So Mr. Almasi, his attorney, had put him on for a bench warrant return, meaning come into court and ask not to quash the warrant, not to arrest him on it. And so everyone understands he was out of custody on the day of his sentence. He was.
He had a bench warrant in that case, but he walked in from the street.
Correct.
Right. He walked in to clear the
The
warrant.
prior sentencing date.
Okay, that's what I'm looking for, Judge. So there was a prior sentencing date. He doesn't show up for that. A bench warrant is generated, and then he comes in out of custody at the second sentence.
Right.
Explain for the ladies and gentlemen of the jury how it is that the sentencing starts to proceed. Who talks first, and how does that go?
The state always has the right to argue first.
So now that we are getting into what happened this day, I'm going to slow this back down to normal speed. We're beyond the background of how she evaluates what's going to happen in court, and is now getting into what happened that day in court.
They'll negotiate away the right to argue for any particular sentence. They might agree to probation. They might make no recommendation. There's a number of things they could stipulate to a sentence per the deal. In this case, because the defendant failed to appear, any negotiation previously offered by the state
Hello, Court
is
TV.
off the table, and the state, what we
Thank you
call,
for
regains the right
timestamping your
to argue.
videos.
So even if they were agreeing to some other sentence
We love it.
previous, because he failed to appear, they have the right to argue for the sentence. So
So in this case, that occurred, and then I would presume the deputy district attorney that was in court that day would argue the sentence.
he did.
And he would recommend whatever sentence he deemed appropriate.
He did.
Ultimately, the decision would have been up to you.
It was.
After the district attorney argues for their sentence, what happens next?
Then I turned to the defendant, Mr. Redden. He goes next. Do you have anything to say to the court before I pronounce sentence? And he was very calm and articulate, and basically
Yeah,
he's
he wasn't
been doing great.
agitated.
He's at a better place than he ever was before. And, I pointed out your violent history, your failure to appear. And I don't remember whether mental illness came up, but I had said that he had been through mental health court. In his PSI, he had claimed that mental illness wasn't an issue for him. So it's kind of hard to, I didn't know how to reconcile it. But anyway, he had talked about he was going to have a job with the Teamsters and he was going to do all this stuff. Meanwhile, he had no employment history whatsoever, that at least according to the PSI, there was no employment history. So I don't know where he was going, but anyway, he was calm. And he said,
Go ahead.
I think you should give me probation. He said, and we did have, we talked about his criminal history, and it's just so much violence. And
Let me ask you some
Sure.
very specific
Sure.
questions. When Mr. Redden was speaking in court, did you observe any signs of impairment?
no,
Did you observe any signs of mental distress or disease or hallucinations or anything of that nature?
absolutely
He was
not.
incredibly lucid.
Had you observed something to that
In
effect,
court.
would it have been concerning to you?
Of course,
Are there times in which the court needs to jump in and say, hey, it's not appropriate to proceed today?
absolutely.
Here, did you see anything that caused you concern while Mr. Redden spoke?
Not at all.
After Mr. Redden spoke, who spoke next?
Mr. Almasi?
And when she
Who
said
that?
he articulated what he wanted, he went through telling the court why he should be given a chance, why he should be on probation, what the mental health program was like. I watched all of that hearing, and it seems that the second he heard those handcuffs, he absolutely went into full fight mode and just snapped and ran at the bench. But before that, often in court, and when you spend a lot of time in court the way these judges do, you get very good at reading people because it's part of your job to see if people are starting to get agitated. I've been in courts when defendant have done all variety of things, but it's very rare that people just go from completely neutral to 100. You can tell often that there is a ramp up. It's what the deputies look for, but the attorneys in court are looking for it too. And there was none of that rising agitation. You didn't see it in his body language. You didn't see it in his facial expressions from the video I've seen. And that's what judges do. They are very intently looking at the people they are talking to make sure that their courtroom is a safe environment for everyone involved, including the defendants. Because at this point, you don't want the defendants to harm anyone in court, but you also don't want them to be harmed. So that is their job. You get very good at reading people's body language. So there was absolutely zero warning at all about this.
Attorney, Caesar?
And was Mr. Almasi permitted to make a full argument to the court and ask for leniency and whatever he wanted?
He was.
And did he do so?
He did.
Now, in a moment, I want to play some video for you. Judge, with the court's permission.
That's gonna be hard to watch.
Stipulated to 58, may I publish?
You may.
That's going to be hard to watch for her. It's going to be hard for us to watch her watch it, I think.
Well, they should be on already, but maybe the TVs went off.
Judge Abby just texted me on her court break and said there was a new case. She's like, take a look at this ruling. And I said, dude, you're never going to believe what happened in the case I'm covering. She's like, wait, what? I was like, yeah.
He has it. Okay.
Before we get there, Judge, up until that point, district attorney speaks, Mr. Redden speaks, defense attorney speaks. Was everything proceeding as you expect a sentencing proceeding?
Yes.
Were there any signs at all that this was going to get out of control or violent?
No, it was actually completely contrary, because he was, like I said, calm and articulate, and he said, this is what I'm doing. But at the same time, he said, but Judge, I understand you got to do what you think is right, and I understand that. So it was,
which is also very common for people who
Better than I would normally hope. I
have
guess.
been through the criminal justice system, you will see people saying, I know what this is. I know what you've got to do. I know what I've got to do. I know what was done. I know how this goes. This is not new. There were times I saw more outbursts. We had a defendant run at sentencing on a case. It was oftentimes folks who had never been into custody before, who this was completely new to. It was not folks who had been in the system, and he had been in and out of court since he was 18 and is now in court at 30. So this is not his first rodeo. And I was always surprised, especially in the gang cases that I worked, that it was a lot of, it is what it is. They were generally not causing issues in court. It was in, society that there were some issues. But so for the judge to say he seemed to be like, I understand where we're all at, I'm not surprised that the judge was like, right, we all understand where we're at. This is not new. And he seemed calm. So.
Okay.
3697.
I wonder if they're going to play the whole video. I'm going to turn this down just a little bit because the background noise is tough on my ears. It's probably tough on your ears too. I can turn that down even more.
All right.
There we go.
This is time set for entry of judgment and position of sentence. Or legal cause or reason why judgment should not be pronounced against you at this time?
No, Judge.
The virtue be.
3697.
Is that your courtroom on January 3rd of 2024?
It is.
And is that your current courtroom?
It is.
As you look around this courtroom, is it set up a little bit differently than yours?
It is.
The folks that are on the right-hand side of the screen, do you know who they are?
Yeah.
Who are
The
they?
deputy DAs, Joey Scarborough and Richard Scow.
So as I go through this video, if it does get louder, I will lower it, but I imagine, and even Court TV in the chat said the judge having to rewatch the video in court was hard to see. I imagine that it will be. When there are cases where victims have to rewatch what happened to them, it is never easy. So I will turn it down as we get into the incident with people yelling. We saw that in opening that it got kind of loud as well. But it's hard. I'm going to zoom this. I had a couple pro per defense cases, but one of the pro per defense cases, they were cross-examining the victim, and it was hard to see the pro per defendant trying to needle the victim
It is.
who they had
You
stabbed.
can see that on your screen there, Judge?
I can.
The folks on the right, who are they?
The district attorneys, Richard Scow and Joey Scarborough.
And on the left,
Cesar Almasi.
is that the gentleman in the blue suit?
It is.
Who's that taller guy standing in the center of the room?
Shane Brandon, my marshal.
And is Shane Brandon, similar to Marshall Black, responsible for courtroom security?
He is.
Counsel, can I have you approach for a moment?
Okay, we're going to zoom, and that is one of the things I love. So Dr. Barry in the chat, it's always good to see you. Thank you. Her even having to be there again must have been difficult. The last time he was in front of her, he was heavily shackled with like 3 to 4 guards around him.
Judge,
And he had like
before we
this
move on with the video,
spit guard at one
follow up
point.
on a question I asked
So yes, Dr. Barry. And Dr. Barry, you guys, has a channel, Psychologist Responds. If you ever want to check out her channel, she has a channel here and always has such incredible insight on this channel, and joins Natalie Lawyer Chick on her channel. That's not what I meant to do. Emily, get it together. Streaming is dynamic.
You had mentioned PSI. What does that actually mean?
Pre-sentence investigation report.
And is that, as you described, several pages long, and it would give not only criminal history of an individual, but where they're from, their childhood, their background, their marital status, their health.
Brittany, I see your
Yes.
question. I'm going to hold on to it because I would like to answer it.
Essentially, it's a packet that is supposed to give you everything you need to sentence an individual appropriately.
Correct.
These individuals down here on the left, you can see at least one of them. Who are these folks?
Those are the other inmates.
And so they are in your courtroom, they're sitting where our jury is sitting today.
Correct.
And those are in custody defendants, is that right?
Right.
When a defendant shows up out of custody, do they sit back in the gallery area here?
They do.
And as you mentioned before, Mr. Redden was out of custody.
He was.
I'm going to resume the video.
This is time set for entry of judgment, imposition of sentence. Is there any legal cause or reason why judgment should not be pronounced against you at this time?
No, Judge.
By virtue of you pleaded guilty, I hereby judge you guilty of attempt, battery, or substantial bodily harm.
And this is on a plea deal.
My notes indicate the state retained the right to argue to the bench warrant. Is that correct? Yep.
That is correct, Judge.
All right. State.
So it seems that they're going to show the whole hearing. The defense is arguing that the defendant didn't form the intent. Part of what they are showing is his behavior leading up to this. Also, why the judge was thinking what she was thinking, explaining everybody's actions. And that is interesting. Kathy asked in the chat, is this attempted murder charges federal since she's a judge? No, they charged the attempted murder and then over, I think in Nevada it's 55 or 60, but over the age of 55 or 60, because there are ranges when you are attacking someone who is older in all jurisdictions. But no, it is not a federal case. They are trying this in the same county, in the same courthouse where this happened. So no, and I don't know if you can have, I would have to look if you have federal charges for a sitting state judge or just federal charges when it's a federal judge. But this is a state case, either way. I don't know what the squeaking is in the background.
I know you see all this, I don't need to rehash everything. My concerns are, there are crimes of violence.
Yep.
In the PSI, 3 felonies, 1 probation revoked. But you do see on page 5, there are many probation violations or remands on the probation honorable discharge form. But I am concerned based on the nature of the criminal history, home invasions, battery, domestic violence, assault with a deadly weapon in this case that led to an attempt, battery, substantial. I think felony is appropriate, and I think a prison term would be appropriate.
Is there any restitution or victim impact?
No, Judge, not that we have today. So, but I do think prison is appropriate. I asked the court to impose 19 to 48 on this case based on the criminal history and the facts of this case.
Okay.
Judge, could you hear that okay?
Yeah, the sound is tough.
When the deputy district attorney asked for 19 to 48, just describe what that means in our.
The attempt, battery, or substantial bodily harm that he was charged with could be treated either as a felony, where you could get 1 to 4 years in prison, or it could be treated as a gross misdemeanor. You get up to 364 days in the Clerk.
It's a wobbler, not
he was
like
asking that it be treated as a felony.
not like wobble baby wobble. It's a wobbler. So there are charges. Again, this varies by jurisdiction, but there are charges that can wobble either to be a felony or to be a misdemeanor, depending on what happened in the charge, somebody's background, their criminal record, so at the severity of the crime, etc. So you can either treat it as a felony, treat it as a misdemeanor. So the prosecutor is saying, based on all of what we've seen, this should be treated as a felony. And depending on the jurisdiction, felonies can stack. Prior prison sentences will stack. And so the more felonies there are, the more serious and severe it will get treated. Oftentimes that does not, you will wobble or shift something down to a misdemeanor if it is a first time offense, et cetera. So this is based on the history. And at this point, he's had a criminal record in the violent crime realm since 18, and we're now at 30 with multiple opportunities and successful completions of mental health treatment. So at some point, it goes upwards into the felony land.
The 1 to 4, and he was asking for the maximum sentence under that felony, 19 to 48. It's 19 months to 48 months. Here in Nevada, you get a max and a minimum sentence. So you get the 48 months or the 4 years. The minimum is supposed to be a truth in sentencing to let you know how much you have to serve before you are eligible for parole. And that would be the 19 to 48. The minimum can't exceed 40% of the maximum. So truly the maximum minimum and the maximum in this case was 19 to 48 months.
Mr. Redden, is there anything you want to say on your own behalf before I pronounce that?
So basically, I would like to tell the courts and everyone here, like, based on my criminal history, like, I feel that, like, I shouldn't be, like, sent to prison for a second time.
Have you looked at your criminal history? Have you looked at your criminal history?
I actually just, I looked at it.
I mean, you lived it, I
I
suppose.
just looked at it,
Yeah.
And, you know.
3 felonies, a gross, 9 misdemeanors, multiple DVs. Got a lot going on, sir.
Yeah, I just figured, like.
Battery on a protected person, robberies.
Battery on protected person indicates that there was a battery on someone that had a protective order against him. Courts do not look very favorably at all on batteries on those that have protective orders, especially when there is a history of domestic violence and then there is a battery on someone who has a protective order against you. It does not go in your favor.
Attempt home invasion. Go ahead, I didn't mean to interrupt you. I
just figure, like, I'm in a better place in my mind, my mental health, I have a support system. I just got hired as a teamster for, you know, the union, you know, making $2 an hour. And like the reason behind every single domestic violence, I've been dealing with mental health. I didn't know that I was dealing with mental health. And they put me in mental health court, and I still didn't know that I had a mental health problem until it was August 2022.
I get it, but mental health court would have told you that though.
When I realized I have a problem with this, and like having a dictionary and like understanding myself and know myself a little better, and applying it to my personality, and having an epiphany at that moment, in those instances, and just like trying to learn from my mistakes, you know? And I feel like I shouldn't be sent to prison, but if it's appropriate for you, then you have to do what you have to do. But I figure that, you know, if I'm in a better place in my life, I'm not doing drugs, I'm not out there committing crimes now, you know, and I feel like I should be given a shot because I'm in a better place than
He's
I
asking
was.
for another chance.
Then, you know, so that's, I'm a person who never stops trying to do the right thing, no matter how hard it is. And I just, you know, and I'm trying, I never give up trying to do the right thing. I know I'm not a rebellious person. I don't want to be standing there. I don't want you to have to, you know, sit up there and waste your time.
Sir.
You know, I'm not what the criteria of me saying this is.
You did go after a family member with a baseball bat.
The right things, even if it's hard. And I did the best I could. I have mental problems.
Thank you.
The I guess is tough. I have mental problems, I guess.
Mr. Almasi?
Judge, as contained in the pre-sentence investigation report, my client was diagnosed with schizophrenia and bipolar disorder. And speaking with him, it certainly seems that it's falling in the pattern.
As they are talking about his diagnoses, I will remind the chat, this is a law nerd chat. This is where the OGs are hanging out. So you guys know this, but everyone's mental health is different. Everyone's diagnoses are specific to them. There are plenty of people who function within society with all kinds of mental health diagnoses. So thank you for not generalizing his diagnoses to anyone else's diagnoses. Thank you, and we appreciate it.
This court has seen so many times, so consult medication.
We've had 2 goes at mental health court, Mr. Lasso.
He did. He does have 2 honorable discharge from probation, so he can do.
He can complete probation and has done so.
It is true that he did get this honorable discharge. He was revoked on a gross misdemeanor that he was supervised for just very recently. But he is in a different position now. His foster mother, who is present, as he shows support, her name is Karen Springer, has provided him a place to live, which is listed on the PSI. His current address is 80 Circle, Apartment A in Las Vegas. And she very graciously has allowed him to stay there rent free until he gets on his feet. Now, he is now part of Union 631 with Teamsters, and is.
He has a job. He has a place to live. So his defense attorney is arguing all of these things are what's needed because it is because he can be back on probation. He has the support he needs now. So the AK asked what is his defense during opening statements, which we covered a bit earlier. His defense attorney was argued that there was no intent here. So with no intent, an attempted murder requires the intent. So saying that there's no intent is saying, look, this is an assault, not an attempted murder.
Hoping to work his way through that program so that he can.
So this is what led up to the incident, and that's what they're covering.
Up until this point, Your Honor, you have suggested a couple times that you're not buying the argument for probation. Is that fair?
That's fair. Correct.
Did you just now observe Mr. Redden move his body position a bit?
Yes.
Did you notice that back then?
No.
Shannon West for any prospects that are available.
You seeing that now?
I am.
Is it common for a judge and her marshal to have a bit of an unspoken language that goes on when you're sentencing people?
Yes.
You work closely with your marshal?
Very.
And those.
This is very much
cues that you
inside
give in
court today.
They have a bit of a purpose.
They do.
What is that?
So he can get ready for a remand.
And a remand means putting cuffs on.
Taking somebody out of custody and putting him in custody.
I'm going to resume the video.
Through them. Finally, Judge, it's not just his mental health he's been contending with, but he also has a history of IDP in his education. And at 30 years old, he does not have a high school degree. And so we spoke about that as well, and I think it's high time that we did that. I think the court can trust that he is going to perform well on probation. I think he's worth this risk. The court wants the 1948 suggested.
And again, the defense is acknowledging he's worth the risk, but it is a risk. The risk is to the victims.
I think it makes more sense given the circumstances and his ability to do probation successfully and given this opportunity.
I appreciate that, but I think it's time that he gets a taste of something else because I just can't with that history.
And that indicates to him, you heard, I'm going to back this up. You hear the cuffs, but she says it's time for something else. And you can hear the cuffs, or at least I could with my headphones on. So this is when everything gets wild.
I appreciate that, but I think it's time that he gets a taste of something else because I just can't with that history. In accordance with the laws of the state of Nevada.
He says, nah, fuck that bitch. I appreciate that the closed captioning bleeps it out, but that he says, nah, fuck that bitch. And then leaps for the bench. The first time I saw this video was without sound when this was originally released. So I don't know if I've heard that before.
Taste of something else because I just can't with that history. In accordance with the laws of the state of Nevada.
Before we let that play, Judge, I want you to do your best to walk us through what happens next from your memory.
I remember remember him coming at me and really didn't think that he would ever make contact. And then I just remember it was like a crash sound. I just remember smashing into the wall. I went down, my glasses went up, I smashed into the wall. He was on me, and then I was being pulled down. I was being hit, and I don't know where and by what. I had closed my eyes. I was trying to protect my face and my head. He had me by the hair, and I was still getting hit in the head. In the meantime, I saw my law clerk who was sitting next to me, who had dove almost in front of me as Mr. Redden came at me. And he was on top trying to pry the defendant off me. By this point, I had pulled down. I was kind of laying down like in the back of the bench. I had gone my head from this side to this side. And I just remember saying, help, help, somebody get him off. I mean, in my head, I was completely defenseless. He was so determined and so violent and so...
I mean, and so much bigger than you are.
It was scary. I didn't think I was going to get out of there.
I'll give you a moment. I want to play a little more video and back up a little bit.
That's what...
Oh, fuck that bitch! Hey,
There are people in court on the video screaming stop at him. And then people are screaming get off of her.
don't do this!
Oh, the genuine emotion always gets me. You can feel it from her as she's testifying.
Hey, can you fucking radio somebody? Fucking radio somebody!
Yeah, fucking radio somebody is
Can you do your best to describe
an understatement.
force he used when you were under the bench and we can't see in the video?
The level of force he used the entire time was superhuman. I don't know. From the time he came through the air and smashed into me, he knocked me literally almost through the wall, out of my chair. He knocked me so hard, he knocked me out of my shoes. You know, when you see a car accident and people get hit so hard by a car, their shoes come off. I mean,
that's how
hard he hit me. And when I was down there, it didn't get less.
We saw there are a couple of individuals jump in, one of them being your law clerk.
Yes.
While, if you remember, if you know, while your law clerk was trying to save you, was Mr. Redden stopped?
He was not.
Can you describe that? What was going on physically and how?
Only by feel. Because
do your best.
I was down in the ground and I could just feel someone going at me who was Mr. Redden, because that's where he was. And I could feel someone trying to pull him off and leave her alone. And you know, this like they're fighting over me. I mean, Michael's trying to pull him off and he's not letting go.
Do you know, based on memory, where his hands were?
I do not.
Do you remember being struck or hitting your head while you were down behind the bench there?
Yes.
Do you?
And again, I'm going to
remember
pause
what-
this real quick. The DA's questions are very concise and are just not leading, but the direct questioning is linearly going through what happened and pausing between the video to allow her to explain what's going on. You also saw her moving around on the witness stand as she's trying to not just access memory, but explain what happened in a very traumatic event. And she is doing a very good job of saying, this is what I heard. This is what I felt. I did not see that. I heard this. She's not trying to fill in the gaps of what happened. Part of that's because it's on video, but she's also seen the video and she's not filling in the gaps of what she saw on the video. She's done a very good job as a witness of parsing between what she felt and heard and what she knows happened because she saw it on the video. And that is a difficult thing to do for anybody, but her testimony is very clear and she is trying to remain restrained in discussing something awful that happened to her. So it's interesting to watch when we watch all kinds of different cases and how different people testify. What I always hope to hear is people very clear on, I remember this, I saw this, I heard this, and that's what we hope to see from witnesses.
I do not.
What do you remember? What side of your head it was?
Left at that point.
Did Mr. Redden continue to attack you while Mr. Lasso was pulling you?
He did.
At some point,
he doesn't agree with
Mr.
that at all
Lasso
based on
and
his
the others
face.
Are successful in getting him physically off you. Is that right?
3 of them. 3 or 4 of them it took to get him off me.
Where did you go, or what did you do once they were able to?
As soon as I was clear enough, I literally rolled onto my bench.
Yeah, she had
fetal position.
I would presume that this was extremely traumatic for you, but I have to ask, do you know if you went unconscious during the attack?
I don't know.
She does not know.
What is the next thing you remember after rolling into the fetal position under the bench?
I remember thinking, why is it taking so long? I mean, there was chaos in the courtroom. There was screaming. The alarms were going off, and there was still a struggle. Again, I couldn't see it. Partly my eyes were closed.
3 minutes is a long time.
Sight, and so I was just.
But during this, it's going to feel
thing
so much longer.
I remember is Jory coming up. Is she okay? And Michael came up earlier. Michael Lasso, my law clerk, and kind of stood by me. Kind of, are you okay? And also, at least the feeling I got was that he was the buffer in case they lost control of the defendant again, because he was still
her
very
staff
close.
was protecting her.
While the attack was actually going on, what was going through your head?
I'm not going to get out of here. And it's a weird thing because I know that there's video and there's a part of me going, I'll be dead. But I have 3 kids. They're going to watch. And that's what they're going to see. That's what was making me so mad. Not what he was doing to me, but what he would do to my family. Okay.
So alarms are going off, lots of physical chaos going on. Did you look around? Or eventually were you able to get up and look around the courtroom?
Yeah. Oh.
What do you recall seeing?
Well, behind the bench, there was blood everywhere.
Where did that come from, if you know?
Shane, my marshal.
Did you look at Shane?
I did.
What did you see?
Shane, his forehead was literally sliced open, and the skin had been just flapping.
Ooh.
As he was trying to protect me, even though he was hurt. But
yeah.
He was getting blood all over the bench. There was clumps of my hair on the floor. The calendar papers were all covered in blood.
Eventually is what I'll call the scene. Is it all secured and Mr.
Oh, I feel
Redden
for her
taken
so
away?
much.
I'm gonna resume the video here for a moment.
This is going to get loud when the alarms start going off. I'm turning it down a little bit. They're turning it down in court. I'm turning it down a little bit too because the alarms are very loud. But her testimony is very visceral. And when people ask how juries evaluate witnesses, evaluate victims, you can feel it. Like you can feel testimony that is authentic versus testimony that is exaggerated. You can also feel testimony that is downplayed, and you can look at somebody and being like, you're still downplaying what happened to you, which I understand is a defense mechanism. So you can see the genuine response, and that will, in jurors, they will feel it, and you can see that. I've had jurors in my cases cry during victim testimony. You have a human response. And then there's sometimes when people are testifying in court and you're sitting there going, yeah, no, that's a whole bunch of bullshit. So it's interesting to watch a variety of different cases with different types of testimony. So, but you just feel for her. So for everyone that's at work and tearing up, I am so sorry. But I really did want to see this judge's testimony, and it is heartbreaking because you should be able to do your job. We should be able to operate in the world as humans safely. Somebody's saying, one of the DAs is saying he fucking hit his head. I've turned this down because that alarm is so loud. They're looking for the judge. People in the audience are still screaming. It sounds like his family members.
Stay down. Get on the ground.
Is she talking?
Oh shit!
The alarm is hard. I turned it down as much as I can. There's a lot of cursing. That's the defendant yelling.
Hey, my man. Calm down. Yeah. Hey, you come here. I'll take care of it. That's my guy.
Those are the sheriff's deputies trying to arrange who's going to do what, because one of them is bleeding and has injured their shoulder. The fact that there aren't other deputies running into the courtroom at this point is staggering to me. That it's been going on this long, that we don't have just a herd of people running to this courtroom. I have no idea who was clapping. The fact that they don't even have enough deputies to clear out the people sitting in the audience at this point. It's wild. There are some more deputies. They are getting the other custodies. Remember, they still have while this is happening, they still have a jury box. That might have been who's clapping. They still have a jury box of other in custody defendants. So that might have been other in custody defendants, but they still have other in custody defendants sitting in the jury box. Some courtrooms have other arrangements, but when you've got in custody defendants sitting there, you still have a situation that can escalate, because now there's an opportunity for things to escalate. So there's a lot for the deputies to deal with, and there are not a lot of them. My cat's name is Karen said, why didn't they tase him? I don't think they had room to. I don't think they had room to safely tase him, and they didn't have enough distance to drives done. So a taser shoots barbs. There were too many people in that space to do that.
You see yourself finally getting up there?
I did.
I believe previously you said you don't know if you went unconscious or not.
Correct.
Do you remember getting up and trying to walk where there's no exit?
Well, I remember because I've seen the video. I mean,
she doesn't remember.
You have no independent recollection of trying to get out of the courtroom by going over the other side of the bench?
I don't think she does. No. Yeah. Because you hit your head. Because trauma.
She hit her head, bro. She hit her head. She hit her head hard.
Her clerk is trying to get her up and get her out.
What are you looking for?
Shoe.
Once you are cleared from the courtroom, can I presume that there was an investigation that ensued?
Yep.
Las Vegas Metropolitan Police Department detectives come down and document the scene.
I don't know who documented the scene. By then we were in the back. AMR came and medical was clearing everybody and taking Shane out and stuff.
Eventually, you give a recorded statement like any witness to a crime or a victim of a crime.
I did.
And can you describe for the ladies and gentlemen of the jury the injuries you sustained, if any?
Obviously, I hit my head. I did. My family didn't want me driving, so my daughter drove me home.
Good.
And then they insisted that I go to the hospital and get a scan to make sure I woke up in the morning.
Yes.
It looked pretty
concussed.
Scary. The scan was okay, but obviously I had a headache for a few days.
You had a
the spots where he pulled out
concussion.
My hair, you know how when you get your hair pulled out, it's sore for a while. That was sore for a few days. My arm, my back, everything was stiff, like, you know, you get jostled around.
She described it like a vehicle collision. She said she got hit so hard she got knocked out of her shoes. The force with which he was jumping over the bench knocked her into the wall and hit her head. So it's not surprising to me that she had what like the whiplash type of symptoms that you would have from being in a collision like that.
The worst part for me the next day was my neck. I don't know what it was. I don't know. All I know is I literally during the day was holding my head up like with two hands because my neck was so sore and so tired.
Because you probably strained your neck and the hospital should have given you a neck brace because you were hit by a car, essentially.
My tailbone, that hurt for weeks. If you ever bruise your tailbone, that just doesn't go away right away. And I was walking.
No, it sucks.
Walking older than my age for a while. I didn't get back on the treadmill for 2 or 3 weeks. And when I say back on the treadmill, that means I walk on it. It's nothing. But I couldn't even walk on the treadmill for a couple of weeks. And then it was several months before I could lay on my left arm.
Ow.
I couldn't sleep on it. That was.
What type of injury did you have on your left arm?
That's what took, I think, the bulk of the initial hit. Again, I don't know what it was that hit me there, but I still have, it's been how long now, and there's a round, it's not horribly disfiguring, but it's a definite, you can still see a round, raised, bruised, fleshy, something not like the rest of it, marking where he made contact with me that day. But it took me months before I could sleep on my left side again.
In the days following the attack, were you photographed, and did you also, you and your family members, take photos of your injuries as they progressed?
We did.
Were there several times in the following days where you lost large clumps of hair?
Yes.
Ouch.
Have to ask for the record, ma'am, how old are you?
63 now.
He said I have to ask for the record.
I was.
thank you very much. I'll pass it over to Judge.
And now cross-examination.
Good afternoon, Your Honor.
Good afternoon, Mr. Arnold.
Your Honor, isn't it true?
Did you see her just go, "Good afternoon, Mr. Arnold"? I wonder just how often this defense attorney who practices in this courthouse, this defense attorney has appeared before her. It has to be very strange as a judge to see the attorneys that practice in front of you now questioning you. But her tone was very much, "Good afternoon, Mr. Arnold." So it was, I'm interested to see what happens from here.
You didn't have any bruises as a result of this attack.
That's not what she said.
And
I'm sorry, I didn't catch that. What was your answer?
No.
And isn't it true, Your Honor, that you didn't suffer any bleeding as a result of this attack?
That's true.
And isn't it true that you had no broken bones as a result of this attack?
That's also true.
And in regards to your neck, you didn't have any bruising on your neck. Isn't that true?
True.
Isn't it true that you didn't know how many times, if any, that Mr. Redden hit you with a fist?
True.
In fact, you don't know for sure if Mr. Redden hit you with a fist or if you were kneed or anything like that.
True.
I don't know if that makes a difference
After the obvious initial.
to the charges.
Correct.
However,
And
his questions are concise and leading. He is doing his job, and he is just concise, leading questions, which on cross is appropriate. You didn't have this, you didn't have this, you didn't have that.
let's make that clear for the record. So when you say after the obvious initial, I'm not talking about the leap, but when you're actually on the floor, you don't know if you're being struck
I
by
don't
Mr.
know if
Redden,
it makes a difference if he punched her or
with his
kneed her.
feet, his fist, or anything like that.
I don't know if that makes it better.
Just that I'm being hit.
Just that you were being hit. And were you covered up? Was your face covered up at the time?
I'm going to assume so. I mean,
Prior to him jumping over the bench, you didn't see him with anything in his hand?
No.
And you didn't see
I
during
don't
the
think
attack
there's any
him having anything in
weapon.
no.
I don't think anyone's insinuating.
You're asking it in the negative, the last two questions, Mr. Arnold. And I'm afraid that it'll come across in the transcript.
I don't
as
think
a
anyone's
double
insinuating the
negative. Could you
defendant had a
re-ask those
weapon.
questions? I just want to make sure you're getting the meaning that you want.
Yes, Your Honor.
I mean,
so isn't it true?
He ripped her hair out, but nobody said he had a weapon. Nobody thinks he has a weapon.
That you didn't see anything in his hand?
Yes.
And isn't it true that during the attack, when you're on the floor, you didn't see anything in his hand that he was attacking you with?
Also true.
I mean, how much does he weigh? He seems like a taller dude. There's a lot of force with the body.
Talk about the PSI. In regards to the PSI, you reviewed it.
I did.
And did you, was there a section that you recall in regards to his mental illness?
Yes.
And you were aware that he had suffered from, he had a previous mental illness history, is that correct?
Correct.
And do you recall, was it paranoia and schizophrenia?
I remember schizophrenia. I don't remember what else.
Did you have any concerns going into the actual sentencing hearing about his competency?
No.
Did you make any inquiries to Mr. Amalsi, his defense attorney, in regards to his competency prior to proceeding with sentencing?
I did not. If I recall, the mental health history was fairly long ago about his diagnosis of schizophrenia and that he had gotten some treatment and then he was not on medication. He had graduated from mental health court And according to him, he didn't feel like his mental health was causing him any issues. That was kind of the summary of the mental health issues as I understood them from his PSI.
Right.
And then coupling that, normally it would be, the defense attorney would be the one to bring it to my attention that there's a competency issue if it wasn't obvious.
Right.
And that
then
doesn't surprise
that coupled
me.
with his appearance in court didn't give me any cause for pause.
And that doesn't surprise me either, that when he got out, his PSI was done after he got out of custody. He had been in mental health court. So he had been sent off for competency. He had been medicated, and then they had been doing the PSI in that time. So when he thought his mental health wasn't causing him any problems, I wonder if those questions were coming during the time that he was on medication. So at the moment, it didn't feel like a problem. It clearly became a problem, but it doesn't surprise me that he said it was not a problem. Because again, that is the thing with medication. When you are on it and you feel fine, you're like, oh, I'm fine. It's like, right, but that's the medication.
Did you note, or was it brought to your attention through your review of the PSI that on your case, prior to it proceeding to district court, that he was found to be incompetent?
I don't recall he was found to be incompetent. I recall he was referred to competency court, but I don't recall the findings.
And then was treated and then came back to
And
court.
do you know, after he was referred to competency court, how long did the case languish prior to you receiving a guilty plea in the case?
Languish? He was in court for 5 months receiving treatment. I don't know if that's languishing, but okay. I'm going to put him on 1.25. I can't with these pauses.
And again, you weren't aware or made aware by anyone that he
We're at 1.25.
Was supposed to be on medication at the time
I
of
was
his
not.
sentencing.
I was not.
Just check my notes.
I feel solid in my decision. And again, the defense attorney is doing their job. There are things that will happen in court that do not. There are questionings that would happen in court that would not happen in like civilian society. But in court, there are going to be questions. But also when he asked about bruising, she said she did have bruising.
Was
He
he
asked that in the
saying
negative.
anything to you that you recall when he was on top of you?
I don't recall.
Do you recall if you heard any statements that he said that he was trying to kill you?
I don't recall.
I'm slowing this back down as they're asking
Do you
about the
recall
defendant's
anything that
behavior.
was being said to you by Mr. Redden?
I do not. It was literally chaos.
Right. And chaos plus a head injury.
And again, all the blows that you said that you felt to your head, you don't know who gave those blows, number one. Is that correct?
I don't think you're going to argue the clerk was punching her.
You're
sir.
assuming that it was Mr.
Michael
Redden.
Jury and Richard literally were pulling him off me, saving my life.
Okay.
But for them, I'm not here. But no, I guess theoretically, my law clerk could have punched me in the head.
Well, you said that you experienced blows to your head. Is that correct? And so again, there was a huge scuffle in there trying to get him off of you.
True.
And so you don't know what part of anyone's body that actually landed on your head.
With
that
the video,
could have
this is
caused
going to land
injury.
with a jury, though.
Eventually, but initially, he was the only one near there.
Right.
That could have, yes.
And do you recall also that when you gave your voluntary statement that you
I don't know if it's I appreciate what the defense attorney is trying to do, and I'm trying not to just pick at it, but it's not really a voluntary statement when you're the victim of a crime. Okay.
stated
Emily, breathe.
that you were only struck in the head once.
I don't recall. If I said that, I do.
Okay. And
I don't think I've ever said there was the initial and then there was a second.
There were different interviews. Also, counsel, there is
I'm going to.
video.
Page 7. May I approach to refresh and recollection?
Sure.
Did it again. I'm so sorry.
That's okay.
The defense attorney said, "Can I approach?" And she said, "Sure." But it sounds like she said to the other judge, "I'm so sorry." Again, she's used to being the judge in court. So she's answering like the judge in court, not like the witness in court. She's like, "I'm so sorry." This has got to be so surreal for her.
Yeah. Just read in between that.
You want me to read it to you?
No.
He's refreshing her recollection.
Refresh your recollection. You know the drill.
He's like, "You know the drill." She's like, "This is a weird side of the drill to be on, though." Also, head injury.
Yeah.
There you go. Okay.
And so, based upon your review of the voluntary statement, do you recall how you were hit?
Same thing. I don't know if it was head or elbow, head, hand. Yes.
Okay.
I don't know.
And you don't
I was
know,
hit, but I don't know with what.
Right. And you don't know how many times you were
I
hit?
don't.
Okay. That's all the questions I have.
And that's the end of
Redirect.
cross. Do you need any redirect on that?
I'll be brief, Judge. You gave a voluntary statement to police that was recorded, right?
Yes.
Subsequent to that, you testified at a prior court proceeding.
Yes.
And throughout that, you've been consistent that you don't remember how many times you were hit.
Yes.
In fact, as you sit here today, you
Head
can tell
injury.
the jury if you were knocked out or not.
No.
Right. Because when you go unconscious,
I think you might have a double negative as well.
when you go unconscious, you don't know you're going unconscious. I appreciate this judge saying no double negatives. It makes the record
In
confusing.
fact, as you sit here today, you can't tell the jury if you were knocked out or
No.
not. Mr. Arnold,
I think you might have a double negative as well. Could you re-ask that question?
do you know if you were knocked out?
No. I mean, no.
May I approach?
Yes.
There was a question or a line of questioning about whether you sustained bruising. Do you remember that line of questioning?
Yes.
Showing you now, 27, 28, 29, 30, 31, 32, and 33. Are those documentation of your bruising
Yes.
after the incident?
Right.
And these will be available to the jury. These are already admitted, Judge, so.
So there are photos of her injuries and bruising.
When you described this attack initially, I asked you about the level of force that was used. And I want you to do your best to describe the level of force used and why it is you don't remember how many times you were hit.
I was hit so hard between
It knocked her out of her
the
shoes.
defendant's body and behind my bench. It's a marble wall. And so, like I said, I was hit so hard that I literally smashed into it.
Right. She was tackled.
And then I was at best dazed. And I was pulled down behind me, and he continued going after me so forcefully and so violently that literally 3 or 4 healthy, strong young men couldn't get him off of me. It was so strong. They saved my life. I tell them that all the time. You guys saved my life.
As that was happening, do you recall a hand on your neck?
I remember being held.
By the hair.
No, not clearly, no.
Fair enough. You're doing your best to recall the events as you remember. Is that right?
Yes.
Head injury.
I do know I lost hair, a lot of hair from that side.
Thank you.
Any recross?
Yes, just real quick. And,
Really?
Your Honor, in regards to the bruising, the pictures that you were just shown, those were pictures in regards to bruising on your shoulder, your arms, and your legs and tailbone. Is that correct?
Well, you don't have a picture of my tailbone, but
your back area.
I was going to say, what nobody wants is to try to photograph tailbone bruising. No one needs that. Also, bruising doesn't always show up immediately. We know this.
but my lower hip, my
Right.
shoulder, and my upper arm. Yeah.
Okay, and there was no bruising to the face, and there was no bruising to your neck. You have to say,
As there was no bruising, and she's saying no.
but we have to get it verbally, and I'll start it over again.
There was no bruising to my neck
There was no bruising
that I'm aware of. Yeah.
to your neck, and there was no bruising to your face.
No,
That's correct?
that's correct. Sorry.
Okay,
That's all right.
all
I
right.
just want to make sure the transcript reads the way that you guys want.
There
it to
was no
read.
bruising.
Right.
No.
All right, no further.
So yes,
questions. Thank you.
that's the problem with the negative
Thank
question, or the question framed in the negative. And this witness, the first witness from the state was the victim, the judge who was injured. She is the victim of the one count
The
that's
next
going to
witness?
trial here.
The state calls Michael Lasso. May I put your photograph?
Sure.
This is the clerk. These are the two witnesses I very much wanted to hear from. So I'm interested to see what the clerk remembers, because again, the clerk observed what happened to the judge.
You
So
solemnly swear the testimony you're about to give in this action shall be the truth, the
This
whole
is
truth,
witness
and
two.
nothing but the truth, so help you God.
I do.
And can you please state and spell your name for the record?
Yeah, Michael Lasso, Michael Lasso.
wait, like Ted? No way. I have questions for you about your last name being Lasso, sir. So this is the judge's judicial clerk.
Yeah, proceed, Your Honor.
You may.
Good afternoon, sir.
Good afternoon.
How are you currently employed?
I'm sorry?
How are you currently employed?
Right now I'm a law clerk, so I'm law clerk for the Honorable Judge Mary Kay Holthus.
And did you just see Ms. Holthus leave the courtroom?
I did.
How long have you been her law clerk?
I've been a law clerk basically a year now, maybe a year and 1 month. So August 2023 is when I first took the job, and right now I'm scheduled to be there till August 2025.
You've known her much longer than
Yes.
a little over a year, correct?
I've known her a long time. She's really a family friend. I kind of know her children very well. Almost grew up together. So, yeah, I've known her a long time. That's how I got lucky enough to kind of be able to work with her. And, since working with her, I see her in a whole new light now. A lot of respect for her.
How long have you known her?
Man, probably since I was 8 years old. So maybe 11 years, just about.
How
Years old?
Yeah.
11? I'm just, are you 19 years old?
Oh, no, wait a minute. Oh, my God. I'm like, wait.
I was trying to do the math, and he's like 11 years now, and the judge is like, "Sir, are you 19? Because it feels like maybe you've been to law school." He's like, "Where does the time go?"
Wait, I'm actually not good at math. That's why I'm a law clerk.
Accurate.
So, man, has it really been that long? Because I'm 27 now. So, like 21 years? Wow. Or no.
19.
Oh, no.
Sir, I feel you.
It was a long time. Long time.
Okay, so you've known her for 19 years.
Yeah.
Now 27.
And
You
that's
would
how
be
you became
taking
a
this
law
job
clerk?
after law school
Yeah,
and
pretty
then
much.
clerking for a
So I
judge.
became a law clerk. I guess got a good recommendation, so I was able to get the job.
What does a law clerk do?
Law clerk basically kind of just does whatever the judge needs. I mean, I don't.
Also, I'm kind of jealous as a law clerk. He works with one judge. As a research attorney, I worked with multiple judges. It was a very busy job.
A lot of briefing for her. I'm almost the middleman in between the judge and anyone else, like attorneys. So anyone that wants to contact the judge, anyone wants to speak with her,
Yeah.
anyone that files a motion, anything like that, I'm the middleman in between. So I'm looking at all the motions. I'm speaking to all the attorneys. I'm kind of coordinating everything. I brief all the motions for the judge, kind of give her a heads up. And sometimes it's
Sir, if Carrie Morrissey filed motions in your court, would you go into chambers and be like, Your Honor, you're never going to fucking believe this? Yes, you would.
as simple as, just giving her a cup of coffee.
Yep, that happens too.
Do you also accompany her
they
to her
run
calendars?
stuff.
Oh, yeah. Yeah, absolutely. Every calendar, I sit directly next to the judge, kind of on the left side of her. And we have a split docket. So we have
I hate to interrupt, but we also saw this with and sometimes they're called judicial clerks, but law clerks, generally different than like clerk of courts. Law clerks have gone to law school and are bar passed attorneys, generally. So we saw the law clerk for Judge Newman do such an excellent job. She sat right next to him during his hearings. You saw her handing him like the rules of evidence and handing him what he needed. So they are really the right hand of the judge and making sure everything gets pulled up and is handing it to the judge as court goes along. So some jurisdictions you'll see the clerks in court with the judges, some jurisdictions you won't, but we have seen some really excellent law clerks supporting their judges in court. They are their fact checkers, their research attorneys, all the things. So
and civil. So I'm just kind of on that left side, almost where this monitor is, and I'll kind of be right here, and the judge will be right there. She has her own monitors, and I have kind of my own computer.
Yep.
And I'm directly next to the judge for every calendar.
And when the calendar is occurring, what are you doing while you're seated next to her?
It depends. I'm usually checking my emails. I'll also keep going along with whatever matters up. So, maybe if it's a criminal matter, I kind of pull up that entire file. If there's anything that the judge quickly needs printed, or maybe it's a police report or anything like that, I kind of right there. I have a printer there. I can print anything she needs. Or sometimes I need to run in the back, get her something that she needs, maybe make a copy, basically anything at all just to make sure the calendar runs smooth.
Yep.
Okay. And what days does she hear her criminal calendar?
She hears her criminal calendar on Mondays and Wednesdays, and then Tuesdays are civil.
Okay. Is it fair to say that the courtroom that she presides in is set up very differently from the courtroom we're currently in?
Oh, absolutely. Much different. This is a much bigger courtroom, but the defense and plaintiff desks are much further away. I would say these are a lot closer than the ones that are in her courtroom.
Okay. I'm going to show you some photographs of your courtroom.
Sure.
So that you can help explain the layout for us. I'm showing you
yes,
on the
talking
overhead
behind the
what's been
lawyer's
admitted
back
as
is a part of
states
it.
Too. Could I get it flipped over, please?
So this is the layout of the courtroom they practice in. This looks very much like the Sarah Boone courtroom, the layout with the bench in the middle there. It looks laid out much more similarly to Sarah Boone's courtroom. Very different than the courtrooms in Massachusetts. So yes, for all of you in the chat singing right-hand man, yes, I agree with you.
Actually, you might take away, I think the light is hitting.
Your Honor, I can't see yet. Sorry. I couldn't see the monitor was taking.
Yes, the light is hitting it weird on the Elmo.
Pull up the lamps. Yeah, pull up the lamps just a tad.
I might turn them off. There we go.
There it goes.
Okay, Mr. Lasso, this is State's Exhibit 2 for the record.
That's much better.
These tables right here that we see, who typically stands right there?
So usually the defense.
During a calendar.
Yeah, usually the defense stays there. And then on the other side, that opposite desk is where the DA or the state, whoever's representing the state that day, maybe it's an AG, will be sitting over there.
And then.
We do have a mouse there.
Oh, perfect. Yeah.
Okay, where did the defense sit?
He's so comfortable in court.
Defense would be right here, typically like right here. Maybe the attorney would be next to him. And then on the other side here.
No worry, we can just show you with the mouse. We'll just like
kind of where that mouse is. That other desk is where the state.
We'll mouse it.
Okay. And then is there also an area where the court staff, such as the court clerk and a court reporter, sit?
Yeah, it would be. I don't know what's going on here. That would be like right here. So this is where our court clerks are. This is where our court recorder would be, kind of like right here. That's our monitor. That's where the judge is. And then on that right side, that monitor is my monitor right there. And then to the right of that is actually where that little monitor is the witness stand. So usually during criminal calendar, we have a correctional officer that would sit there.
And was there a correctional officer sitting there on January 3rd of 2024?
Yes, there was.
What is the difference between a court clerk and a law clerk?
There's a big difference. The law clerk
there is a big difference.
Usually has a legal degree. So, we're briefing actually the law that's involved in the motions. So, we're looking up the case law, making sure it's, still good, reliable, kind of briefing those, telling judge, giving her recommendations as to what she should do, what she shouldn't do.
Writing opinions.
Whereas the court clerk is also a middleman in between the judge, but at the same time, they just kind of handle just different areas. They're not really involved in any legal advising or aspect of it. I would say more just kind of coordination, handling minutes, like court minutes, things like that.
Getting the files.
So just kind of a little different.
Okay. And then
It's,
the court recorder.
The court clerk function, as he's not describing this very well, the law clerk function is very much a research attorney function. The court clerk function in the courtroom is much more administrative, making sure that the sheriff's deputies are bringing all the paperwork, making sure that they know who's being ordered out, keeping track of the minutes, the cases that are being handled, calendaring the cases that are being handled. They run the organizational calendar, set the dates for the next hearings and all of that. It's much more of an administrative function than a research function. So different than clerks that work directly in the clerk's office that are handling other administrative matters, ordering juries and stuff like that. There are lots of aspects to being a clerk of court, which apparently I can never say.
You said you guys have a recorder in that department.
Yeah,
correct?
and that one right there. So this one, that monitor, you can kind of see it's light. That would be for the court clerk, and then to the left side would be the court recorder.
Okay.
The court reporter.
And
doesn't sit in the well, sits behind the
with
desk.
regards to
Interesting.
that courtroom, is there actually an entrance behind that tile wall that we can see?
Yes, yeah. So that's where the judge and me, that's where we usually enter, along with the entire court staff, really. We all kind of enter in through that door. Her chambers would be right behind there. So we kind of come in through this right side way. Then I take my seat right there. Judge will sit right there.
Kelly,
and
he
then,
does not do the admin job. He does the legal job. So he's more of a research attorney. He will hand the judge the law, the case law. He takes in and will read all of the motions and briefing and give the court a brief on that. This attorney's arguing this. This attorney's arguing this. The law says this. The potential outcomes are this, this, and this. So he's helping the judge prep their calendar. Let's continue.
Of course, the court staff will take their place.
And then moving on to states.
So he's a lawyer.
Oops, let me take this one off. What are we looking at here?
So this is kind of just a seating area. Usually people who are supporting
audience, the gallery.
defense or the defendant would be sitting in this back area, but it really could be anyone. So that desk right here is the defense desk, kind of just the opposite angle. Or I'm sorry, the state's desk. I'm sorry. So this would be usually anyone that on behalf of the state sits right here. And this would be, like I said, where the DA or the state would be. And then that opposite side is where the defense is. So this would be where any defendant would be, their
Next to the jury box?
attorney. Usually it's a PD. And then, like I said, this is usually where family members will sit, supporters, friends, anything like that.
And do you see another exit in this photograph?
Oh, yes, absolutely. Yeah, it would be right here in this photograph. This is an exit also to that chamber hallway where there's a lot of different chambers and offices, things like that.
So staff and sometimes attorneys might use that?
Oh, absolutely. Yeah, there's a copier machine. So sometimes when I have to run and go make copies, I'll kind of run to that backside. And occasionally I'll come through that door, but usually not. But right behind there's like a big copy machine and jury rooms for deliberation.
But generally speaking, the public would not use that.
No.
And then showing you,
Sorry.
Another double negative there.
So the courts really had it with the double negatives. But for those of you that remember, I think from Members Only Live, my story is about jury rooms being used for deliberation. It can have multiple meanings depending on the courthouse. So I'm going to just continue on.
Does the public use those doors?
Today
Not that
made
specific
me
one,
laugh.
no. And the one behind the judge, no, never.
Okay.
showing you states 4 on the overhead.
Yeah, the public should never be back
Is
there.
this,
the jury should. The jury goes back there to
Does this appear
their
to be a
room.
photograph taken from the area where the juror box was in the previous photograph?
I like seeing the layout of the court.
This is that angle, kind of where that door would be, and so this is where like the jury would sit. This is where like occasionally witnesses will come up and maybe a victim statement would be given, or attorneys will go up there and make an argument. This is where the state would be, and that was kind of where that previous photo was taken, would be back here for friends and family. And then this door is kind of where a holding cell is, and then also where
so that goes back to lockup.
During our criminal calendars, that's where they will walk those defendants through that door. And then to the right side is where our recorder would sit, and then this is the court clerk here.
Okay, and when you say defendants, do you mean in custody defendants?
Yes, absolutely.
Okay.
He does say absolutely.
And
A
then
lot.
showing you states 5. What is this?
So this is kind of the angle from the recorder and our court clerk. So this was kind of that long desk here, and this is facing the jury box. So kind of where that last
like the
picture was
layout of the
taken would be
courtroom.
right here, and then this is that door that leads to the copier. So then you can kind of go through there, but typically there wouldn't be public that'd be going through there. Occasionally attorneys do, but yeah, this is just kind of that opposite angle. And then to the right side here would be like the defense table where usually PDs sit or defendants that are out of custody.
Showing you.
This is
state
just the
6.
nuts and bolts of a courtroom.
What are we looking at here?
This is the view from the court clerk's angle here. So this is where the judge would sit. This is my monitor right here. Literally right where that picture is being taken, it would be exactly like the angle from the court
Standing
clerk.
where the clerk is.
And then this right here would be the witness stand. It's kind of like right here. Then we have a TV there, and then that's that same door, obviously the jury box. And then when we have criminal calendars, instead of a jury there would be the in-custody defendants would all be kind of taking up that area.
Okay. If you could look right here for me, where my finger is.
Yeah.
Is that essentially like a wall between where the judge sits and the court clerk?
Yes, it's a full wall. There's no kind of opening that you can go through there. Kind of the only access point to that chair that you're seeing where the
Yes, this is the video of the monitor where the clerk, who was a little bit flabbergasted about the video. This is where they were sitting because it was the court reporter and the court clerk right there. I think the clerk was the one who was kind of laughing. The reporter, I think, was the one who was like, "Ee!" So yes, these are the videos where that happened. But I appreciate the view of all the different aspects of the courtroom.
judge would sit is through that right side. So you'd have to go through that right side. There's kind of like maybe 2 steps that you go around and
But
yeah.
From
right
this
there.
angle, you can see that from where the defendant leapt over the bench and then pushed the judge towards the clerk, you can see that there is kind of a hard stop there that the judge couldn't get over when there's nowhere for the judge to go to get away.
There's kind of 2 steps that you would go around, and that's the only way to get over there. Unless you were to hop over this little
Which is
wall
not
there,
happening.
you can't really get to that side of there's no access to it, essentially.
Okay, so this would be the door that you'd walk through to get to the
Yeah. It kind
area
of
where you
swings
would-
around. Yeah.
Okay. Showing you state 7.
And then from right here, this is the view from the judge, kind of where the judge sits. That's a microphone right here. And there's a little sign too that will say like always recording. That's right there. And this is her view. That right there, that monitor would again be where an out of custody defendant would be, along with a PD or whoever their attorney would be. This side would be usually typically filled up on criminal days with defendants, the in custody ones, and then on the right side would be where the DA or the state representative would be.
And kind of like the equipment where I'm standing, there's an Elmo there.
Absolutely, yeah, just like that. And attorneys will walk up, they'll give arguments, and that main door right there is the access point for the public or attorneys that are going into the courtroom that day. Anyone that's essentially not a courtroom staff member is typically walking through that main door there.
And you're talking about the 2 double doors?
Correct. Yeah.
We're starting to talk over each other, so why don't we make sure she gets her question out, and then counsel make sure he gets his answer out, okay?
Showing you state.
The court's like, can you
8.
please slow down?
What are we looking at?
This is kind of my view, even though that's not necessarily my chair, that's the judge's chair. I'm just kind of just turned to the side. But this is my angle. This is my monitor right here.
I'm sorry, Clerk Lasso, Judge Newman's chair is far superior to this chair. But this is him saying, from my perspective, this is where the judge would be. Again, it's very strange when the crime scene is a courtroom. So this is them breaking down the crime scene with the witness who was there. But it's kind of surreal because the crime scene is the courtroom.
And this is kind of the view if you were to stand up in that little room section that's blocked off. This right here is that wall area that we were talking about earlier.
And that should be I think that would be the emergency button down there, the red and green buttons.
Right here in the recorder. And this is, like I said, my monitor. So this is kind of would be my view.
But I don't know for sure.
I'm going to zoom in on something really quickly here.
Yeah, is that the panic button?
Do you see the red and green buttons right there?
Yeah, I do.
What are those?
I'm not exactly sure what they
Should've
are. I
asked
think they're panic buttons
Should've
or a
asked the,
silent alarm. I'm not exactly sure. Or
Should've asked
they
the
may
judge.
be, I know there are certain buttons that lock the courtroom doors. It could be those, but I'm not exactly sure on what those are. I really had to use them.
They'll ask the sheriff.
Showing you states 9.
Yep, they should have asked. Witness said the judge was just on the stand. Yeah,
What
they
is
should have
this?
asked the judge.
So this is kind of
but the courtroom sheriffs will also testify, so it's not as if it's a huge deal because the courtroom sheriffs who deal with the court would know that better than the clerk of court would because it's not really within his job purview.
the angle that you would see if you were, like, let's say a defendant walking through that door, the in custody,
The custody door?
almost where that holding cell is. So once you walk out, if you were to just look left, this is the angle you would see. This is that door that I was talking about earlier that leads to like
The jury
chambers and
deliberation
offices and
room.
things like that. And then if you see on the right side, if you were to loop around, that is how we would walk up to where we would be sitting, me and the judge. But this is just kind of that angle there. This chair to the bottom side.
So
this
that's
is like,
the door to the judge's chambers deliberation room, and then where the person taking the photo is standing is in the hallway where you would go to the lockup.
typically an extern may sit there, but it's usually either an officer or no one sitting there.
Thank you. Showing you states 10. What are we looking at in this photograph?
Yeah, this would be the witness stand. This is there's a monitor similar to how it is here, where anything that's being shown on the Elmo could be seen by the witness. That would be the judge's chair right here. That's the judge's monitor. That would be my monitor. There's typically 2 chairs up here, so I would have a much smaller chair right there. And this is
I
that
get the
door
little
that
chair.
we would enter through. This is kind of that one
it is a
access
tight
point to
space.
wrap around. And this is kind of just a granite wall that we have that sits behind the judge.
Okay, and I'm sorry, I may have missed it. You may have already answered this
Yeah.
question.
Yes,
Right
it is a
here,
very
is there any way to
stately
access
wall.
the area where the judge sits other than to climb over that wall?
No. These doors, those aren't doors. It's like a wall almost.
And just like in here, the witness stand is lower than where the judge sits?
Yes. Yeah. Absolutely.
Everything is lower than where the judge sits.
In the back hallway
Mhm.
that you've referred to, that staff and in particular you and judge would use to get to the courtroom, are there exits to the ground floor? Like, are there stairs back there?
Like in that backside to go down.
Like in the rear hallway?
Yes. Yeah, there are. If you were to walk out of that kind of that
Like
door
if
I
you
was talking
escaped
about near the
that way,
copier,
could you get
you
down?
would just turn around. There is a big door right there where there's a stairwell, and you could go down. I'll often use that stairwell to go down to be like a little supply office to get some extra Sharpies or whatever I need or whatever the judge needs.
What about elevators? Are there elevators in the rear?
Yes, there's elevators instead of making
It's the most court shit ever. When you need some extra Sharpies, a few Post-it notes.
All right, if you were to just make a left, there's elevators right there as soon as you were to walk out. And then there's also, if further down the hall, another pair of elevators as well.
Thank you. Showing you states 11. What are we looking at in this photograph?
Sharpies are critical.
So this is the angle from
Especially
the
for
witness
writing on
stand.
court files.
That's that monitor that I was saying that's similar to this one here. That's the microphone. Those doors for the public to go through. And this is just kind of that angle if you were to be sitting at the witness stand.
And you indicated that on January 3rd, there was a correctional officer sitting right there?
Yes.
Showing you states 12.
And the correctional officer
This
was
appeared
the
to be a
one that ended
photograph
up
of
I think, getting injured as he was trying to climb over the wall, but I don't quite remember from opening. But he was sitting there taking down what was happening in the proceedings, because you need to know, the sheriff's needs to know for each defendant the next day they're back in court, what's happening with them, if their status has been changed. There's quite a lot of information that is required. So he was sitting there to note down the proceedings from the bench, different than the deputy in the courtroom behind where counsel tables are.
Judge Holthus's bench.
Yes, absolutely. That's just right. She'd be sitting right on top of there, and then I'd be on that right side.
And there's a bit of a glare. in
Getting
this photograph,
over
but
that
is
4-foot
there a
bench
nameplate there
and
too?
clearing it completely
Yes,
is
and
bananas to me.
Honorable Judge Mary Kay Holthus.
Showing you states 13. Is this a close-up of that
That is it right there.
nameplate?
Mm-hmm.
And it says Judge Mary Kay Holthus.
Yes.
Yes. And it has the recording always on.
Showing you states 14. does this appear to be the desk or counter area in the judge's bench area and where you sit?
Like,
Absolutely.
how deep is that? I mean, I realize it's not going to be, it's a deep enough desk. So not only is the defendant clearing 4 feet vertical of the bench, but you also have to clear like the horizontal of the bench and the desk. It's
So I'd
just
be
so
on that right side where this
improbable.
monitor is. This is that kind of wall that cuts off between where the judge would sit and then the court clerk on that left side. Again, this is the judge's monitor, and then this is kind of that front view and that nameplate that we were just discussing.
Sir, can we get kind of out of our vocabulary?
Showing you states.
Mr. Lasso, did you watch the Karen Reed trial? Has Lally impacted your speech patterns? No, can we get rid of the kind of?
15. What is this?
So this is once you were to walk out that door
That should be
between
the
kind of like the
access
chambers and
elevator.
those offices, kind of where the whole court clerks and the entire court staff essentially walks through. If you weren't going down that long hallway that we discussed earlier, where the court clerk and recorder sits, this would be making a left. So this is how me and the judge, this is the only access area to that little kind of sitting area where the judge would be, and then myself. So every time that we go into court, whether it's for a trial or a calendar, we go through this area. That door that's closed right now is usually open, and we just kind of walk through. There's kind of like 2 steps, and you just walk up, we
And
make
then
a
it
right, and
also
then I'd
would
be sitting right
have
on this
an
right
elevator
side
in
here,
there
and then the judge
for
would be kind of right here.
access.
Okay.
So the
And going
floor,
back to 9.
because there would otherwise be stairs. So that door has the buttons that you can use the elevator up so that it's wheelchair accessible to get not just up to where the judge is, but the witness box normally has that as well.
Sitting right on this right side here, and then the judge would be kind of right here.
Okay. And going back to 19, this is the door that you're referring to, correct?
Exactly, yes.
That you and judge enter into?
Yes.
Are there cameras in the courtroom?
Yes, sir.
Are you familiar with the JABS system?
Yes.
Is that one of the recording systems in the courtroom?
Yes.
Do you know whether or not the system will kind of alternate between various cameras in the courtroom?
Absolutely. Yeah. Depending on whatever the mic picks up, it'll usually, could change from the witness stand to the judge and also whoever's speaking, whether it's
So
an
it's-
attorney or a defendant or,
So
kind of whoever's on that other side.
The
where
recording
desks-
switches
the desks are.
based
So it's
on
activated by
audio.
noise.
Absolutely.
Interesting.
And JABS, what does that stand for?
He's like, I have no fucking idea.
That I don't know. I just.
It's just the JVS system.
Exactly. But I know, just kind of the recording system that can catch whatever's going on. And
Your Honor, ask the judge in Oklahoma. She knows a lot about the recording system. I mean, I'm sorry, the former judge in Oklahoma. The texting judge knows all about the recording system because she tried to cover it up.
if like we need to look back or like if the court clerks are making their minutes, they'll typically go back and watch the JABs to hear exactly what attorneys were saying or the judge, so that way they can get an accurate depiction of what had happened and occurred during court.
And
That's, by the way, JABS is Jefferson Audio Visual System. Just an FYI.
Is the judge wait, the judge is chiming in. The judge is chiming in being like, JVS stands for this. I guess we're marking it for the record.
Thank you. Learn something new every day. Is there also a fixed camera in the courtroom? Do you know?
Yeah, I believe there is. Yes.
And do you know approximately where in the courtroom it's mounted?
I believe it's, I don't exactly know for sure. So I don't, I'm pretty sure it's kind of right behind us looking at the entire courtroom.
Ask the sheriffs. It's their job to know.
But I don't know for certain, but I know there is one that kind of looks down, but I think that will partly be activated by the JABs as well.
Is JABS always running during the course of the criminal calendar?
Oh yes, absolutely.
Yep. Was it running this day? Yes, we know that it was running this day.
Now, to go to January 3rd of 2024.
Mm-hmm.
On that date, you were not originally supposed to be working, correct?
Correct.
I'm not even
were you
supposed to
have
be
the day
here
off?
today.
I don't know if I was supposed to have the day off, but that morning I woke up and I was actually studying for the bar at that time. The bar was taking place in February, so this was January 3rd. It was kind of our first. It was right after New Year's, so it was our first criminal calendar of the year, and actually our only criminal calendar that week. So
He was going to take the
and
week
it was
off
on
and
Wednesday.
study.
So my boss had texted me, one of the court staffs, and said, "Hey, why don't you take the day off? It's not that long of a calendar. Why don't you study? It's coming up here pretty soon. It's a pretty stressful exam, so
Yep.
you can go ahead and just take the day to study." And for whatever reason, I just really wanted to be there. I wanted to, it was our only criminal calendar that week, and it was just something that I don't know. I felt like I just should be at. So I told her thank you, but instead I decided to go into.
It's
work
my
that day.
job. I'm going to go to work.
And on that date,
It's
did
only
you
one day of work
sit
this
next to
week.
the judge like you would during any other calendar?
Absolutely.
I bet he's glad he's there.
Were you multitasking like you indicated you typically do?
Yeah. I prepped the files that day, kind of started off as any other, and during calendar, I remember just going through emails, checking to see if there's any updates. Sometimes
Everything. It was a
attorneys will
normal
email you
day until it
right
wasn't.
during calendar. So just kind of checking and making sure everything was running smoothly.
During a typical
Thank
criminal
you, Kristen.
calendar, I know you indicated that there was at least one correctional officer seated in the witness stand in the courtroom.
Yes.
Are there typically more than one correctional officer?
There usually is. Sometimes there's only one. We always have our marshal there as well. But especially if it's like a lot of defendants that are in custody coming in, there will be maybe 2 correctional officers, occasionally 3, but usually, like I said, you'll have the one. You'll always have the marshal there as well.
Are there times when the correctional officers who are present in the courtroom might remove some of the in custody defendants and take them back to the Clark County Detention Center?
Absolutely, yeah. Especially if there's a lot of defendants in a particular day, or maybe if there's like some sort of intermission or break.
Zoe in the chat asked a great question. Why all personnel that work in the courtroom, specifically close to the judge, are not trained in the security system panic alarms? Generally because everybody has their job to do. And so they might now in this courthouse, but generally everyone has their jobs to do. I don't know if anybody foresaw this being an issue. Normally you foresee that if something goes down, the court can hit the panic button because the court has not been assaulted from somebody leaping over the bench. This is quite an extreme situation, but generally the role of the court staff is to hit the panic button and get the fuck out of the way. That is generally the training from the sheriff's department. Depending on what the sheriff's department needs to do, what you don't need are other people in your way when you are trying to subdue somebody in court. So that is the general training in court. Also, you don't need the clerk trying to get over the judge to hit the panic button. So it's going to be determined by the sheriff's department that operates each courthouse on who does what. But generally one person does their job, and then this whole group, their job is generally, if there's an issue in court, to leave and go to the back hallway and go into chambers and lock the door.
Whatever ones we've kind of gone through
protocol.
the in custodies, they'll go ahead and kind of uncuff whoever together or whoever hasn't gone, and then they'll go and walk those individuals through that door that we were talking about, and then onto CCDC.
But there will always be at least one correctional officer in the courtroom if there are in custody defendants,
Yes.
correct?
Oh yeah.
And you indicated that there's also a court marshal that's in the courtroom during criminal calendars?
Always, yeah.
And is that Marshal Shane Brandon in your court?
Yeah, this is a very unusual
And typically,
circumstance.
how is he dressed?
In full uniform. He's got, a vest on, and he looks almost like a police officer. It's like a brown tan shirt that he has, and like I said, a vest. He's got a full belt. He's got a gun on him. He's got a badge, everything like that.
With regards to the correctional
He's a
officers that are in the courtroom, are
sheriff's
they
deputy.
typically dressed in uniform?
Oh yes, yeah, almost identical to the marshal.
And readily identifiable as law enforcement officers?
Yes, absolutely.
Are they typically armed
Yes.
with a firearm?
Yes.
And that will vary by jurisdiction too. Sometimes
On
the lockup
January
deputies will lock up their weapons when they're going back into lockup so they can't be disarmed. So that varies substantially by jurisdiction, is who is armed in a courtroom and who is not armed. The custody officers are not always armed when in court. A lot of courts have lock boxes. But again, depends on jurisdiction.
24. Do you recall a defendant being on your calendar that day by the name of Redden?
I do
Yes, I
now.
Do you see that individual in the courtroom today?
Yes, I do.
Could you please
I don't
point to
know if
him
they
and
asked the
identify an
court to
article of
identify
clothing that he's
him.
wearing today?
I don't
Sure.
remember if they
That's
did.
him right there, wearing. Looks like I can't really see the color of the tie. Almost like a purple tie, blue shirt.
Thank you for
standing
the
up
help,
right
sir.
there.
May the record reflect that he's identified the defendant here.
Maroon and gray
So
tie.
reflect.
Now, with regards to Mr. Redden on January 3rd of 2024, Were you aware of whether or not he'd ever been in your department prior to that date?
Yes,
Was he or was he not?
he was. Yeah.
And do you recall what he had been in your department for previously?
And he would have known that from looking at the docket.
Exactly. I'm not sure. I believe, I don't want the record to be wrong here.
They did
I believe
ask,
it was
thank you.
a domestic violent offense, if I remember correctly.
Do you know what kind of hearing it was?
I
Sorry.
just forgot. Thank you, chat.
The kind of hearing that he was there originally for, or that
Previously. Previously.
day? It was a sentencing hearing. Where we would, I believe, given him probation.
Okay. And there was nothing particularly remarkable about that hearing, correct?
Nothing remarkable at all.
Were you
Normal court
aware
day.
on January 3rd of 2024 when his case was called? Were you paying attention?
Yes, I was absolutely paying attention. I remember him kind of getting walked through by our marshal. When there's an out of custody defendant, whether it's a sentencing or really any hearing whatsoever, we always have a marshal directly behind him. And it's typically Shane, who's directly behind that particular defendant, whatever it is. And I remember him coming into the courtroom, and I remember him kind of talking for a long time. The judge had given him an opportunity to address the court. I remember at that point, there was really nothing unusual. He seemed really polite and courteous, and there was no kind of nothing unique about the situation. So I kind of had lost interest a little bit. I was, doing my emails. It wasn't really
like, I went back to working.
anything unique about the situation. And
Normal work day.
And I kind of, like I said, I kind of just started answering emails.
Doing work.
Prior to Mr. Redden addressing the court on his own behalf, do you recall whether or not anyone from the state made an argument on behalf of the state?
I think I can't.
Were you paying attention at that point?
Yeah, I don't necessarily recall. I mean, I think the state may have, but I don't necessarily recall exactly what, kind of right before then. Like I said, I was kind of answering emails and stuff, and I didn't think anything of it.
Do you recall who the calendar deputy was that day?
The calendar deputy?
Who was handling
The DA.
calendar on
Who was
behalf
the
of
DA
state?
handling?
On January 3rd.
State. It was, there's Jory, I know, was there. I know Richard Scow was there. I think it was Scow at the time, because Jory will kind of pop in from time to time. So I think it was Scow.
Okay. And
What they mean by the calendar deputy, since they're not explaining it, most DA's offices will have a deputy that's assigned to the courtroom and handles all of the calendar matters in that courtroom. And then you have deputy DAs who are assigned to the trials in that courtroom. And then they talked about one of the other DAs who was assigned to a special unit. People assigned to special units will go wherever their cases are. So if you have 5 cases in 5 different courtrooms, you will go to those 5 different courtrooms throughout the day and handle just your assigned cases. So there are a multitude of ways that DAs are assigned to courts, but a calendar deputy is assigned to that judge, that courtroom, and handles the calendar, assigns out the trials, gets discovery, does all the plea deals, and just does day in and day out work in that courtroom. So that is generally the division of how things are, which is how DAs end up with like 17 bosses, because you have, your calendar deputy all the way up.
with regards to,
since we're doing all of
a calendar
the
deputy, is that the individual that would handle the
all
bulk
of
of
the ins
matters
and outs
on the
of
criminal calendar?
inside baseball of running court?
Yeah.
And occasionally specialty team deputies might pop in and out to handle individual matters?
Keep reading, Emily.
Okay. So on that date, Richard Scow was the assigned calendar deputy,
Yes.
and Jory Scarborough was a specialty team deputy that appeared on January 3rd. At some point after Mr. Redden addressed the court, do you recall something unusual happening?
Oh, yeah. So, like I said, I was kind of lost. I didn't lose interest, but I was kind of listening, but I wasn't
back to work.
paying too much attention. I was just kind of answering emails, and then I could hear. I remember the judge speaking. I remember the judge
Cell
kind
phone
of
in court.
going and
No bueno.
saying what she was going to say, and then I could remember hearing some handcuffs. And then what really caught my attention was I heard, excuse my language, but I heard, fuck that bitch. And when I heard that, I immediately.
He was like, what just happened? Yeah, immediately looked up. He's like, pardon my language. Let me say fucking court. I have not seen an attorney that has not enjoyed at some level just dropping fucks in court. We saw it. Alan Jackson aggressively enjoyed cursing in court. Anytime there is an opportunity to curse in court, it will be briefly acknowledged. Hey. I'm going to curse now. And then it will be embraced with vigor that there is cursing in court.
Hearing some handcuffs.
Embraced.
And then what really caught my attention was I heard, excuse my language, but I heard, fuck that bitch. And when I heard that, I immediately looked up.
Yeah,
And
we saw the
I-
video.
Then I'd seen Mr. Redden, and I'd seen him kind of hop over the defense desk that we were speaking about earlier. And he'd kind of put one hand down, and it just kind of pretty easily just hopped right over. And at that moment, I was obviously my full attention was looking at this particular individual. And at that moment in time, I actually thought he was going to go for the door because occasionally when we go to remand defendants into custody, they'll go and make a run for it. And there was that particular door that we were speaking about earlier. So I actually was under the impression he was going for the door. Never would I even imagine that he was going to go for the judge. But
Then he did.
I remember looking at him. I was actually saying like, whoa, because I was trying to like process what was even happening. And it all happened so fast. Like I was saying before, the defense desk is actually a lot further than these desks are here. And he was able to scale that distance in such a short amount of time. The video doesn't even do it justice as to just how fast that all took place. And then I remember him doing this just incredible leap over the judge's bench bar there. And at that moment in time, I kind of just reacted. I wasn't even thinking, to be honest. It was just all reaction and a reflex. I went right in to try my best to kind of to protect the judge. So, no hesitation. I tried my best to go in. And at that point, unfortunately, he was so fast and kind of just
strong.
athletic. He was able to get to her. And I remember him kind of sprawling his arms out like this and just clamping those arms down, and one kind of right on her hair here, and then the other one kind of like right in between the neck and shoulder blade, kind of like right
grabbing
here.
her.
So kind of just clamping down. And then I remember him just smashing the back of her skull on that tile wall that we were discussing earlier, just smashing the back of it. And at that moment I was actually thinking to myself like, oh my God, like fuck, kill Judge Holthus. And
right.
I remember after he'd smacked her skull, he had actually dragged her down. So he goes and does that. And then he actually drags her down, almost twists her a little bit, and was like face to face with the judge. And at this point, I am almost like on his back trying to get him up. And, he's like this. And Judge Holthus is actually, Judge Holthus was like frozen at the time. She was literally frozen.
That's
solid,
one of those responses.
almost like a piece of petrified wood. She was just not even moving. I think she was in a state of shock at the time. And
yes, freeze is one of the responses. When your brain responds, freeze is one of those responses. But yes, he would have told this story numerous times at this. But yes, the judge absolutely, I'm not surprised when he's like, the judge was frozen. Yeah, freeze is absolutely real, which is so scary. If your body freezes when the judge is like, I couldn't do anything, I couldn't fight back. Yes, she was frozen. She has no control over that response, which is part of why she was probably so scared that she could not do anything. And also she has someone much larger than her and, an injury to the head. It's just a horrific situation. And he's like, this is the situation.
He was yelling things at her. He was saying things to her, and I couldn't make out anything that he was saying because I was actually in turn screaming at him and saying,
right,
get off the judge, get off the judge. What are you doing? I was like, what's wrong with you? Get off the judge. And I remember vividly just how strong Mr. Redden was. This guy, he is unbelievably strong and much bigger than me. So I'm trying to wrestle him and get him off, and he is glued to her like a magnet, like an actual magnet. I couldn't pry him off of her. And it actually took, I'm sorry.
Where was he grabbing
He's like,
at that time?
Can you just let me
Same
finish?
thing. It kind of just the hair and right here. So, and would not let go. Was just stuck on her.
And you indicated that he was right in her face, approximately how far?
Yeah. You couldn't get any closer. Almost like touching noses. Like this.
Just in her face.
I'm sorry. Could you?
Oh yeah, yeah. Almost like this. Literally like this. Like yelling at her, saying things at her. This is when he had kind of twisted her, and I'm on his back.
Because he had her hair
almost this close, face to face.
Approximately like 3 to 6 inches apart, maybe.
Yeah, I'd say so. Maybe even closer.
He's like,
and
how close is my hand?
And she's completely unresponsive, just petrified, just completely, like I said, just a state of shock.
Had had you ever seen Judge Holthus in that state before?
Oh, never in my life. I've never seen her, let alone really anyone. I mean, she was frozen solid. And just, I mean, it was, like I said, I mean, it was unbelievable to see, especially coming from her. And I've known her a long time, and I've never seen anything like that.
Generally speaking, would you say that she is a timid person or a strong person?
No, absolutely a strong person, very strong person. You know,
I don't know if that
strong
matters
personality, really tough.
too much to the case, but
you know, not much can really rattle her. But I've never seen her like that ever.
And you indicated that he was screaming things at her. You don't have any recollection of specific statements he was making?
I have none. Honestly, some of it, you know, you can't even hear much because so much adrenaline kicks in. It's like everything kind of goes silent. I remember just him saying things to her, and I remember saying things to him, but I can't really make out anything that was said.
right, because he was screaming. The defendant was screaming.
What was the tone of voice that he was using?
And just, I'm not surprised.
I remember him saying things, you know, almost like it was a pretty stern voice, but I can't really make out much. I mean, even the tone too much, to be honest.
It's on the video. I don't know if
I was
you
just
need it.
so like I said, it was like everything went blank, and I'm yelling at him. I'm like, get off the judge, you know. I'm so just focused on trying to just get him up, and it was just so unusual, and I just wasn't even really paying attention to anything that he was saying.
As you were trying to pull him up, what was he doing with his body?
Oh, he was just stuck to her. There was no getting him up. He was fighting tooth and nail. I'm trying my best to get him up, and he is just lashed onto her. There is no getting this guy off of her. It was unbelievable. I mean, I actually remember saying to myself, I could not believe how strong Mr. Redden is. It was unbelievable. I mean, I could not. I'm just trying my best. I mean, I'm struggling to try to just get the guy up just a little bit. I mean, off judge, and he is just glued to her.
Where were your arms placed on Mr. Redden as you were trying to lift him off?
Yeah. So honestly,
he's trying to
I was
narrative.
almost like kind of around him.
The DA is trying to stop him from narrating, but he's full narrative.
Not in like a chokehold or anything, but kind of like right underneath and kind of grabbing with this other arm and just trying to just lift him up. Anything I could do to just try to, you know, get him off the judge.
So your arms were wrapped around his chest area?
Almost, yeah, kind of like right here, almost like right below the neck area.
And he continued to go towards her and was refusing to let go?
Oh, absolutely. Yeah. Just kind of, like I said, just still with that kind of just death grip almost.
And you indicated previously that you, at the time that you were seeing this occur initially, you had the thought, oh my God, he's going to kill her?
Yes, especially when I saw her hit the back of her skull on that tile.
With that force.
I absolutely thought he's going to kill her.
When you observed his hand, I believe you indicated that it was between the shoulder and the neck area.
Mm-hmm.
Was she already on the ground at that point? Or was that as he was kind of flying into her forcefully?
You know, right when he kind of did this, where his hands landed is almost where they stayed the entire time. So they kind of just, like I said, kind of just latched on.
What you see in the video, you see him flying with his arms out and grabbing the judge
a little bit, and you know when they were on the floor, but they didn't really move much, the hands, and that, I mean, that's basically it.
Can you tell me when they were on the ground how they were positioned?
It kind of had changed. So like I said, they were face to face. But then when I was trying to get him up, he kind of had gotten up a little bit. She was still kind of frozen. But he had his hands right on her hair and, you know, still in that like neck area. He's got long arms. So he's kind of holding her like this. I'm trying to get him up, and he's, you know, just relentless trying to just get back at her. And, you know, they kind of just changed positions a little bit, depending on kind of just wrestling with me also as well. You know, they kind of started out like this, but that only had lasted just momentarily. He was still saying things to her, but, you know, she had kind of, like I said, was just kind of frozen a little bit. And there's just a little bit of like wrestling going on almost, but those hands stayed kind of where they were.
Was he directly on top of her? Was he next to her?
At first he was on top of her. And then as I was kind of pulling him off, and then especially when the CO came, he'd kind of gotten up a little bit and kind of maneuvered his body, but you know, the kind of hands, you know, stayed in place.
When you say that he'd kind of gotten up a bit, was he on his knees?
And the DA is trying to get this described. This is what is outside of the view of the cameras, because you can see the defendant tackle the judge to the ground, but the clerk is there seeing what's happening on the ground. the witness is in a narrative, and the DA is doing a very good job of pausing and backing up and making him describe it in more detail. It's like, okay, you're saying he's on the ground. Is he laying on the ground? Is he kneeling on the ground? Is he leaning over? And that is sometimes hard to do when your witnesses are full steam ahead, retelling an event that is hard to piece it down, back it up, and explain where everybody is. So that's what the DA, I think, is doing a really good job of slowing down and doing.
The ground flat? What was he doing?
When he had first jumped over, it was such a incredible jump that he had like almost landed on his knees, but like he actually wasn't like fully flat on the ground. It wasn't like he had just laid on top of her. He almost had like a pretty good leverage formation, I guess, of where he was. So like he almost had like a leg out and kind of was able to really be on top of her and kind of prevent anyone from just kind of, it wasn't like he was just dead weight and couldn't lift him up. I mean, he had like a good position on her. And that's why I think also, I mean, it was so hard to lift Mr. Redden off of her. He was just kind of in a good spot and was not letting go, almost just determined, like he was on a mission or something.
While she was on the ground and he was kind of on top of her, or at least had his hands around her neck, shoulder area and had her by the hair, did you see him do anything else to her?
No, I didn't see him really do anything else to her other than, screaming at her and kind of just having his hands like that.
Grabbing her.
That was basically it. I didn't see really any like punches or anything like that.
You indicated that he was extremely strong.
Yes.
Like incredible strength.
Oh yeah, absolutely.
I mean, adrenaline again.
What about his physical build?
Oh, he's a big guy, a lot bigger than me, and athletic, very strong, tall, and I've been in that courtroom many times. I don't know anyone that can make that kind of a jump. It was honestly impressive.
Do you have any idea approximately how tall he is?
I believe he's like 6'2", maybe 6'1".
You indicated that at some point you became aware that
will
the
say
correctional
that.
officer had jumped in to assist you.
Yes. Yeah. So it was about 7 seconds of me wrestling with him before the correction officer could make his way past that barrier we were talking about, because he was sitting in the witness stand similar to how I am now. And then he had taken about 7 seconds before he could actually cross that barrier, because once you are able to get through that, it's essentially just you and whoever's back there. So at that point, it was me and the judge. And you're blocked off from everyone else in that courtroom.
Right.
So it took about 7 seconds of me kind of wrestling with Mr. Redden to try to get him up before the correctional officer came in. And actually, until the correctional officer had come, I was unable to actually get him off of her. And thankfully, when the correctional officer came, it took both of us. We were able to finally unlatch him from Judge Holthus.
And when you unlatched him initially, did he stay unlatched?
When we had gotten him up, yeah. I mean, I would say when he was actually up, yes. I remember him because I kind of had him. My arms were almost on his chest area, right below his neck, kind of like right here. And I remember him holding on to my arms, and I remember thinking to myself, I hope he's not going to turn around and attack me. So I remember just trying to get him
holding
up.
on so he doesn't turn around,
fighting, just really trying to get back at the judge. And I remember the correctional officer being right there. And I was actually under the impression, once the correctional officer was there, that there were more officers behind him. I remember seeing a blue suit. I wasn't sure at the time who that individual was, but I just thought, there were actually more people that were right there that were coming to our aid. So when we'd finally gotten him up, I actually had kind of let go. I kind of stopped engaging in the situation because it's not really my place to put my life on the line and try to protect the judge. And at the same time, I also didn't want to get in the way.
You're in the way of the
officers.
sheriff.
I'm not really trained, and I didn't want to kind of be somewhere I wasn't supposed to be. So I actually completely almost let up entirely. And at that time.
Okay. And when you let up initially, what did you do? Where did you turn your attention?
Where did Mr. Redden turn his attention?
Where did you turn your attention at that point?
I was watching the situation. I was watching where Judge was also. She was kind of my first priority. But I had kind of just completely let up and just watched the correctional officer there kind of, was hoping he would be able to contain the individual.
The correctional officer that assisted you, was he armed with a firearm that day?
Yes, he was.
You saw the firearm on his side?
Oh, yeah.
And did you observe that firearm on his side during this interaction?
Yes.
At some point, do things go south again?
Yes, they do. So I
Right,
kind of
and
let up,
then-
like I said earlier. And the correctional officer, who is much smaller than Mr. Redden,
Was
the
Redden reaching
correctional
for his
officer-
gun?
And I remember too, I had a blue suit at the time that was right here, so I was under the impression that was another officer, and
That was another lawyer.
And I'd let up, and then I remember Mr. Redden just going at the correctional officer and just winding back his arm and just landing blows, like really big blows, just boom, boom. And then I realized it was actually Jory in the blue suit right there, and it wasn't another officer. It was one of the.
He's just like, I am going to tell you this as if I am telling my best friend. He's like, he's just what? Like, the expressiveness in this testimony is something that I have not seen very often, but he's just giving a narrative of, he's like sitting there with the jury, like, you're never going to believe what the fuck happened at work today. And then he's just like, whomp. I don't think I've ever seen testimony like this from a witness, but he is deeply invested.
DAs who would have ran around. So when I had seen that, I'm like, oh my God, this is far from over. So that's when I had no choice, but had to jump back in and try my best to help subdue Mr. Redden.
And that's when he started
indicated-
punching him.
You made kind of a fist when you were punching.
He was
he striking the correctional officer with a closed fist?
Oh yeah, absolutely.
it's genuine testimony.
I mean, like I said, real
It's just-
windups, just huge blows. And I actually remember saying to
expressive.
myself, like, oh my God, I hope he doesn't, grab the gun and
Right.
maybe start shooting at someone in the courtroom.
That
I don't
is
know what's going
a
to happen. I know
huge
the
concern.
correctional officer's got a loaded gun right there, and now the correctional officer's in distress, and it's just me and a DA here. I wasn't sure what was going to happen.
It's like, man, we're lawyers. We don't math. We don't fight. Like, we're in suits. Don't leave it to us. We are not the law enforcement officers. Like, what are we going to do? If he is able to subdue the only sheriff's deputy, what the fuck are we going to do? I mean, I think it's fair for him being like, what the fuck are we going to do? Like, what are we going to do? And the defendant is someone acting on like full adrenaline fueled just anger, which they know from seeing him leap more than 4 feet over that bench. So, I mean, he's definitely telling you the story. I mean, I'm here. Most witnesses are not this comfortable in court, but this is also his workplace. So I'm not surprised that he is uncomfortable, that he's so comfortable in court, which you don't see from a lot of witnesses. But he's, I mean, again, a civilian witness. He's like, I'm going to tell you exactly what happened. Let me tell you what happened. It's riveting, though.
What actions did you take to assist at that point?
At that time, I began punching Mr. Redden.
He's like, I
tried my
started
best
punching him.
to help. And, I remember eventually Shane had gotten up, which was our marshal at the time. He had gotten up and ran around. And at that point in time, another DA, Mr. Scow, he had actually gone around, and there was about 5 of us trying to contain him.
Okay.
Whose last name is Scowl? I
When
need
you
to
say
know.
that Shane had gotten up and come
The
around,
DA?
do you mean he'd gone around that kind of triangular shaped wall?
No, he had gone around the other side where like the witness stand would be kind of like right here.
Okay. And you said the other DA, Richard Scow, was also back there now assisting?
Yes.
So
we've had some DAs with some names, but DA Scowl is going up there with Rottenborn and with Judge and with Mr. Bloodworth. Like, DA Scowl is going up there too.
it was you, Jory Scarborough, Richard Scow, Shane Marshall, and the corrections officer.
That's correct.
And ultimately, with the assistance of these 4 other people, are you all able to get him detained or restrained?
Yeah. When it took 5 of us, but once we were able to kind of get him, with a correctional officer managed to get up, and with the help of everyone, we were able to, like I said, finally, contain Mr. Redden. And the minute that the correctional officer had gotten up, and I realized that, kind of the situation was handled, then I immediately went to check on Judge.
And when you went to go check on Judge, what did you observe about her?
Oh, she was frightened. She was in a fetal position right underneath the bench. There's like where my feet are now. There's
Which also has to
kind of
scare the
opening,
shit out of him.
where she sits,
Like,
and she was literally in a fetal position, shaking, just still frozen, scared for her life, just, almost like this, like just in a full state of just shock.
Yeah.
Is it fair to say that even once Mr. Redden had kind of been finally constrained or detained,
Mhm.
he was still lying in the area where
Restrained.
you and the judge would.
Yes, absolutely. Yeah, he was laying there for quite some time.
And was that while he was being handcuffed so that he could be
Yes.
relocated?
Yes, and I remember a flood of security coming in and marshals and other people coming to help.
Did you, when you checked on Judge Holthus, did you try to get her to go back into chambers with you?
Yes, yeah. Well, I mean, I stayed by her side the entire time. I didn't leave her side after that, and I remember her not wanting to go through our normal walkway whatsoever. She was so scared that she actually hopped over that where that clerk sits. She actually like hopped over that other side because she was so just scared and just, like I said, just it's kind of the state of just shock and emotion that she couldn't bring herself to just walk through that
Past
other area.
him. Well, if he could
Once
get back
Mr.
up on his
Redden
feet,
was-
even if his hands are handcuffed, if he can get back up on his feet, he can still continue to try to get away from the deputies. I'm not surprised the judge was scared. I'm not surprised she doesn't remember what she was doing to try to get away at all because trauma, she had just been attacked and hit her head. I'm not surprised she doesn't remember what she was doing to try to get away, just that her body was like, get away, get away. He remembers it, which is why he's testifying to it. But I appreciate that the defense is just letting him talk. Some of this is speculation as to the judge's mental state. However, the judge just testified about what her mental state was. So it's not, it's not something that hasn't already been testified to. So I appreciate that the defense is just like letting him run with it. It's on video.
Was relocated, was she then able to exit out her normal path?
Well, no, she went over, like I said, she went right over the that where that clerk is, that big wall. She wouldn't go. She wouldn't walk through that normal path.
You also indicated that you became aware of an injury to Marshal Shane Brandon
Yes.
after things kind of settled down a little bit.
Yeah, I mean, I do remember when all the people were kind of trying to detain him, like all five of us. I remember looking up at Shane, who was sitting, or standing almost right here, and I remember seeing his head busted wide open like an onion peel, and his forehead was literally dangling off of his forehead.
That's very descriptive.
I remember, him saying, "How's the judge? How's the judge? How's everyone?" And him, kind of just worrying about
Sir,
everyone
you're
else. And
bleeding.
meanwhile, he's got an injury to himself. I'm like worried about us. How are you?
Mr. Redden was not bleeding though, correct?
I don't believe so.
Okay. I want to show you some photographs on the overhead showing you states 17. Do you recognize this
the
as
jury's
a photograph
right
of
there
the
with
bench
them
area
as
after the
he's
incident?
telling us.
Yes.
Oh, there is a bunch of blood on that
And
paper.
the disturbance, the papers all over the place, the apparent blood on some of the paperwork.
Oh yeah.
Good job, Madam DA, for going apparent blood because you probably didn't test it. I very much appreciate that mindfulness.
Is that all the result of Mr. Redden trying to attack Judge Holthus that day?
Absolutely.
Or
I don't
attacking
think-
her, actually attacking her?
Yeah, actually
Absolutely.
attacking her.
And the blood that's on the paperwork, is that Marshall Brandon's blood?
Yes, it is.
Counsel, how many more questions? I'd like
Just-
to give the jurors.
I'm almost done.
Okay.
Showing you states 18. The area where Judge Holthus was curled up in the fetal position, is that depicted in this photograph?
Yeah, it was would be right there, kind of right underneath
Right
that
here?
monitor. Yes, exactly.
Under the desk.
Showing you states 19. Is this the area where you would typically be seated during a count?
Oh,
Yep.
there's
Yep.
a.
And obviously
yep.
this is after the incident on January 3rd of 2024.
Correct. And the reason why there's so much blood is because that's
the
where
face.
our marshal was over, trying to help and assist. Like I said, kind of right here. So that's where the witness stand would be, and that's why there's so much blood in that area.
Yep.
Showing you states 20.
And again, that
Is
witness
this
will testify
the,
that he was bleeding from the head. So
stair
it's
leading
not.
up to the judge's bench area?
They're not
Yes, it
using.
is.
She said apparent blood. It's appropriate. They didn't test it. They're not using it to tie anything to the defendant. That witness is going to have photos of what happened to his face. So, yeah.
And the floor
Yep.
just outside. And this disturbance was, or the papers and the trash can being knocked over, that's all part of the incident, correct?
Correct.
Yep. The defendant on his monitor can see everything that's happening. So he's got to be sitting there being like, yeah. I mean, it's court staff. It's not like they're not going to show to testify. So
I'll pass the witness, Your Honor.
Okay. We're going to go ahead and take a break. Ladies and gentlemen, we're going to take a 15-minute break.
All right, the
During
court
this
is
period
going to
of
break.
time, you are admonished not to talk and converse among yourselves.
We're going to zoom past the court break. We are in witness 2, the clerk of court, Michael Lasso. So I am going to, this break ends up being more than 15 minutes. Again, I appreciate Court TV for time stamping that. And we are going to resume as court resumes. So let's see when I'm waiting for the audio to come back on. And that ended up being much longer than a 15-minute break. They are just coming back to court. So we are going to zoom as they are coming back to court. So I'm waiting for the audio to come back because that's when we'll know they're on the record. But the defense attorney is talking to his client. I am trying to get us to the point where the audio comes back without going too far ahead. So let's see. Lots of conversation. I'm going to try to get us to where the sound is real quick. Because there is,
Accepting your guilt.
There we go. More conversation. All right. This should be us back in court.
Substantial bodily harm.
Hold on.
Count 5.
I went too far.
Your Honor,
I went too far. Emily, you have failed. This is why the break was so long, though. All right. So as the court comes back, we are going to see the end of this case. Whenever that is. There we go. The court is back on the record.
You all may be seated. Okay, are we ready to proceed?
Yes, Your Honor.
Okay. Are there any representations that you'd like to make?
And now they're going to make a record.
It is my understanding that Mr. Redden is going to plead guilty but mentally ill to all of the charges in the second amended indictment that was previously filed. The state is willing to stipulate to allow him to withdraw his prior pleas of guilty so that he can enter pleas of guilty but mentally ill to counts 2 through 7. And he's also pleading guilty but mentally ill to count 1.
So the defendant was charged in 7 counts. The defendant had taken a deal on 6 counts and was going to trial on the attempted murder. The defendant is changing his plea mid-trial and is saying, I would like to plead guilty to the entire indictment, all 7 counts, and would like to plead guilty but mentally ill. So the DAs are allowing the defendant to change his plea mid-trial. Yes, this does happen. To change his plea mid-trial and plea guilty but mentally ill to all of the counts. So he's going to withdraw his previous guilty plea on counts 1 through 6, or the first 6 counts, and then he is going to plea to these counts, and we'll see what happens from there.
That's our understanding, Your Honor, and he's prepared to go forth with the plea.
So he saw the victim testify, he saw the witness testify, he saw the rest of it happen. Sometimes when defendants hear the opening statements, see the victim testify, they're like, I just want to plea. Which is difficult for the jury because then the jury just gets dismissed. So Steel City said, how does the plea affect the jury? The jury gets dismissed. And they'll be brought into court and told, not until the plea's done, but they'll be brought into court and told, your services are no longer needed. This case is resolved. And I'm sure they'll be able to interpret that as they will.
Right.
But in terms of the negotiations, there are no negotiations. Each side will argue for a lawful sentence under the statute.
Oh!
Okay.
So there is no plea deal. There is an agreement by the DA to allow him to plead open. So the DA just said, I want to make this clear. There is no negotiated plea deal. He is pleading open to the court. What that means is he is accepting responsibility and the judge gets to determine sentencing. Each side gets to argue sentencing. The only thing the DA agreed to was that he could withdraw his previous plea to enter a guilty plea to everything and plead guilty but mentally ill to the judge. And then the judge gets to decide what sentence there is. So the DAs didn't offer a deal. but he is pleading open to the court. No charges will be reduced. No charges will be removed. He's pleading to the entire sheet. So with him pleading to the entire sheet, the DA's only agreed to allow him to withdraw those previous guilty pleas to plead guilty but mentally ill.
All right.
So let's see what happens.
Mr. Redden?
Yes.
I'm going to be asking your lawyer to state in open court the substance of the plea agreement. In other words, the primary, the most important terms of the negotiation.
There really aren't any negotiations, Your Honor. He is pleading to the judge, which does happen, and it's not unusual when the reality of trial sinks in of like, oh, I'm done. But yeah, 2 witnesses in and taking a plea is unusual.
Or agreement between you and the state. Actually, this is a guilty plea memorandum.
Yeah,
Okay.
it's pleading
I
open.
want you to listen. After your lawyer's done speaking, I'm going to ask you if you heard him and if you agree that this is what the parties have agreed to enter into. All right?
Okay.
Okay. Mr. Arnold?
Your Honor, he's agreed to plead guilty, but mentally ill to count 1, attempted murder, victim 60 years of age or older. Count 2, battery on a protected person, resulting in substantial bodily harm, victim over 60 years of age or older. Count 3, intimidating a public officer. Count 4, battery on an officer resulting in substantial bodily harm. Count 5,
That's the officer that had the shoulder injury and the injury to the head.
performance of act or neglect of duty in willful or wanton disregard of safety of persons or property, resulting in substantial bodily harm or death. Count 6, battery by prisoner. Count 7, unlawful act related to human excrement or bodily fluid.
There was spitting.
Okay. And this is what I will do.
Though there are courts in LA when I was still working there where defendants hurled fecal matter as well, but that's a spitting charge. Some jurisdictions call spitting gassing. Look, you learn new things every day, but fecal matter is not as uncommon as one would hope.
Once I canvass Mr. Redden, I will go ahead and allow him to withdraw his guilty plea with respect to the counts 2 through 7.
Thank you, Your Honor.
Did I get the numbers right?
Yes.
Okay. All right. Mr. Redden,
Yes.
did you hear your lawyer just state the substance of the guilty plea memorandum?
Yes.
Okay. Did he accurately state the terms that you had agreed in order to resolve the criminal charges lodged against you?
Yes.
Do you read, write, and understand the English language?
I do.
Okay. Did you receive a copy of the...
These are standard waivers. So the judge is giving the standard waivers that you would give to any defendant taking a plea. So these are the standard waivers that she is going through.
Guilty plea memorandum?
I did.
Did you review the second amended indictment?
Yes, I did.
Okay. Did you receive a copy of that as well?
Yes.
Okay. Do you need me to read the second amended indictment now before we take your plea?
No, you don't.
Okay. Before accepting your guilty plea, there's a number of questions I'm going to have to ask you in order to assure me you are entering a valid plea. If you do not understand any of my questions, will you please let me know so that I can rephrase them?
I will.
Lisa, he is pleading guilty to all of the counts, including count 1. So the court has allowed him to withdraw the previous guilty pleas to enter the guilty but mentally ill pleas, which open up availability to mental health treatment and sometimes locked mental health facilities in lieu of prison. And then you will he's being allowed to withdraw the guilty pleas because they were just guilty pleas, not guilty but mentally ill. And so now he's being allowed to plead to all 7 counts to be guilty but mentally ill. So withdraw the prior pleas, enter this plea into everything, and then the judge will be able to sentence him. I don't think that'll be today, but we'll see. I don't really know.
Anytime you wish to take a break in the proceedings so that you can discuss matters in private with your lawyer, will you let me know so that I can give you an opportunity to do so?
Yes,
How old are you, sir?
I'm 31.
The jury will
Where
be
you
out
born?
of the courtroom when this is happening.
What is the extent of your education?
12.
Did you graduate from high school?
No.
Would it be fair to say you dropped out in the 12th grade?
Yes.
Okay. You finished the 11th grade?
Yes.
Okay. Are you taking any medications or suffering from any medical, physical, or mental health conditions that would interfere with your ability to understand these proceedings and the terms of the guilty plea memorandum?
I am on mental health meds, but as long as I'm on that, I don't believe that it will affect any of my
Okay.
understand.
Well, I know that you've got to be on some medication, sir. I think we've been discussing that here today. But I want to know, are you taking any medications or suffering from any medical, physical, or mental health conditions
That make
would
you not
interfere
understand.
with your ability to understand what is going on here today or the terms of the guilty plea memorandum?
Oh, no.
He's like, no,
You
I
fully
understand.
Yes.
Have you had an ample opportunity to discuss your case with your lawyer, Mr. Arnold?
Yes.
Are you satisfied to have him as your lawyer and the advice that he has given to you?
Yes.
Do you understand you are entitled to have an attorney represent you at every stage of the proceeding lodged against you?
Yes.
Do you understand you're entitled to a trial by jury, at which in order to convict you, all of the jurors would have to agree that you are guilty?
Yes.
Do you understand at trial you would be presumed to be innocent, and the state would have to overcome that presumption and prove you guilty beyond a reasonable doubt?
Yes.
Do you understand that to do this, the witnesses for the state would have to come to court and testify in your presence, and your lawyer could cross-examine those
Ma'am, he well understands he's in the middle of it.
witnesses?
Yes.
This
Do you
is her
also
taking his
understand that
plea
your lawyer could object
and
to
waivers.
evidence offered by the state at the trial and could call witnesses and present evidence on your behalf?
Like
Yes.
standard plea and waivers.
Do you understand at trial, while you have the right to testify if you chose to do so, you also would have the right not to testify, and if you decided not to testify at your trial, the state would not be able to use the fact you did not testify in any way to prove its case?
Yes.
Do you understand that by entering your guilty pleas, you are giving up these rights and other rights listed in the guilty plea memorandum?
Yes.
Are you aware of the penalties for committing the crimes which are listed in count 1 through count 7?
Yes.
I'd like to review all of them with you. This will take a little bit of time, but I want to
I'm
make sure you
curious.
understand, okay? Do you understand, as a consequence of entering a plea of guilty but mentally ill, you have the burden of establishing your mental illness by a preponderance of the evidence?
Oh, yes.
Do you understand that except as otherwise provided by specific statute, as a defendant who has entered such a plea, you would be subject to the same criminal, civil, and administrative penalties and procedures as a defendant who regularly just pleads guilty?
Wait, so
Sure. Do you understand, except as provided by specific statute, as a defendant who has entered a plea of guilty but mentally ill, you are subject
You can
to
still
the
go to
same
prison.
criminal, civil, and
Right. It doesn't
administrative penalties and
change the penalty.
procedures as a defendant who pleads guilty?
Yes.
It doesn't change the fact that you're pleading guilty and can go to prison. It changes the access
Do
you have to care.
understand that if the court finds by a preponderance of the evidence you are not mentally ill at the time of sentencing, that the court may impose any sentence that the court is authorized to impose upon a defendant who pleads or is found guilty of the same offense, or that you are mentally ill at the time of if you are mentally ill at the time of sentencing, the court shall impose any sentence the court is authorized to impose upon a defendant who pleads or is found guilty of the same offense, and include in that sentence an order that you, during the period of your confinement or probation, be given or obtain such treatment as is medically indicated for your mental illness. Do you understand that?
Yes.
That's all set forth on page 2 of the guilty plea memorandum. Okay, do you understand that as a consequence of your plea of guilty but mentally ill, the court must sentence you as follows? First, with respect to count 1, the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 2 years and a maximum term of not more than 20 years, plus a consecutive sentence of 1 year to 20 years for the age enhancement. Do you understand that?
Yes.
Do you understand the minimum term?
That's
of
a high
imprisonment
age
may not exceed
enhancement.
40
So what she just said is on the 66418, well, no, that's California. On the attempted murder, the minimum sentence is 2 years. The maximum sentence goes up to 20 years, but there is a mandatory consecutive enhancement for the age of the victim, and the age of the victim adds a mandatory consecutive of 1 year to up to 20 years, which is higher than I've seen in a lot of jurisdictions, that elder enhancement. So we're going to keep going.
% of the maximum term of imprisonment.
Yes.
Do you also understand that you also may be fined?
Yes.
Okay.
And that's just count
Do you
one.
understand that you are eligible for probation for the offense to which you are pleading guilty?
Yes, I understand.
I mean, not all of them.
Do you also understand, except as provided by statute, the question will
If there's a mandatory minimum sentence, then he can get probation later. But if there's a mandatory minimum, he can't get probation until he does the mandatory minimum, but okay.
whether you receive probation is in the discretion of the sentencing judge.
Yes.
With respect to count 2, do you understand
count one,
that
this
the
is
court
count
must
2?
sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 2 years and a maximum term of not more than 10 years, plus a consecutive sentence of 2 years, minimum 2 years
Really?
to 10 years for the age enhancement?
Yes.
Do you, again, as with count 1, do you understand that the minimum
that's
term
count 2.
of imprisonment may not exceed 40% of the maximum term of imprisonment?
Yes.
Do you also understand in that situation, you may also be fined for that?
Yes.
And as, like count 1, do you also understand you are eligible for probation for the offense to which you are pleading guilty?
So the minimum on count 2 is 4 years. The minimum on count 1 is 3 years. Those can be mandatory minimums consecutive, so that can start to stack.
Meaning count 2.
Yes.
With respect to count 3, do you understand that the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 1 year and a maximum term of not more than 5 years?
Yes.
Do you also understand that you could be fined up to $10,000?
Yes.
And as with respect to counts 1 and 2, the minimum term of imprisonment may
So
not
minimum
exceed
1 year.
40% of the maximum term of imprisonment.
Yes.
And I might save a little bit of time, but the minimum term of imprisonment may not exceed 40% of the maximum term of imprisonment would also apply to counts 4, 5, and 6, and 7. Do you understand that?
Yes.
So all of them are
And
40%.
you also understand that you are eligible for probation with
Yes.
respect to those other counts,
Yes.
as well as count 3.
Yes.
Your Honor, I think count 7 is actually non-probationable.
Okay. Okay. I will get to count 7. I thank you, counsel, for doing that. You are not eligible for probation with respect to count 7. We will get to that in a few.
Just 10 asked, are there age enhancements for children and enhancements for disabled victims as well? It really depends on the jurisdiction, but generally, yes. Sometimes they are in the same statute, where it is victim under a certain age, victim over a certain age, victim who is particularly vulnerable, victim who is disabled. It depends on the statute, but yes, there generally are other types of enhancements for victims that are vulnerable in different ways depending on the crime. I also saw the question about these stacking. I don't think they're going to get to sentencing today because the defendant has to plead. The defendant has to prove at hearing by a preponderance that he qualifies for the mentally ill designation on the plea. So that is probably going to be set for down the line, but let's continue on.
Moments. Do you understand
They have
that?
to advise him of all of its
Okay.
maximums. Oh, I saw did he have a chance to talk with his lawyers about this? The 15-minute break before cross-examination ended up being an extended break that we zoomed past. So we are going through that.
With respect to count 4, do you understand the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 2 years and a maximum term of not more than 10 years?
Yes.
Do you understand in that instance you may be fined up to $10,000?
So this is just charge by charge.
With respect to count 5, Do you understand that the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 1 year and a maximum term of not more than 5 years?
Yes.
Do you also understand you could be fined up to $10,000?
And these can go consecutive or concurrent,
With
depending.
respect to count 6, do you understand that the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 1 year and a maximum term of not more than 6 years?
Yes.
Do you also understand in that instance you could be fined up to $5,000?
Yes.
Okay, and that again is with respect to count 6. With respect to count 7, do you understand that the court must sentence you to imprisonment in the Nevada Department of Corrections for a minimum term of not less than 2 years and a maximum term of not more than 10 years?
Yes.
Okay.
So your
And you
heaviest
understand
charges
that
are
you
counts
not
1,
eligible
2, and
for
7.
Probation for the offense to which you're pleading guilty with respect to count 7.
Yes.
And do you understand you could also be fined up to $10,000?
It is going to, I mean, it's going to be a prison term no matter
That
what.
the law does require
It
you
has
to
to
pay
be.
certain administrative assessment fees.
Yes.
Do you also understand the court may order you to make restitution to any victim of the offense to which you are pleading guilty?
Yes.
Has anyone threatened you or forced you to plead guilty by
This
but
is
mentally ill?
standard plea waivers.
Has anyone told you if you do not plead guilty but mentally ill, some other adverse action will be taken against you?
No.
And I take it that you have, you've received a copy of the guilty plea memorandum.
Yes.
So he gets
Okay.
this, he gets this information in the waivers. He gets the information in the waivers, both in writing, and the judge will read them verbally and check in on each one. You understand that these are all of the potential penalties.
Signature is affixed thereon on page 8, is that right?
That's true.
And your lawyer, Mr. Arnold, he signed the guilty plea memorandum on page 9.
Yes.
Prior to signing the guilty plea memorandum, did you read it?
Yes, I did.
Did you discuss it with your lawyer before you signed it?
Yeah, I did.
Did he answer all of your questions?
Yes, he did.
Did you sign the guilty plea memorandum willfully, knowingly, and voluntarily?
Yes.
Do you feel you understand the terms of the guilty plea memorandum?
I do.
Has anyone made any promise to you other than those set forth within the guilty plea memorandum that induced or caused you to plead guilty but mentally ill?
Say that one more time.
Sure. Has anyone made any promise to you other than those set forth within the guilty plea memorandum that induced or caused you to plead guilty but mentally ill?
No.
You understand that later on, when there are requests with respect to sentences or any sentences that may be agreed to by your lawyer, and the lawyers for the state would not be binding upon the sentencing judge.
I don't understand what that means.
Do you understand that
'Cause there wasn't
sentencing is
any.
totally up to me?
Okay, yes.
Yeah, there wasn't
That's
any promise by the
irrespective
state.
of whatever your attorney argues to me.
Mhm.
If later on there's
Oop,
deals made
sorry.
between your lawyer and the lawyers for the state,
There aren't
I
any
don't
deals.
have to abide by those deals. You understand that?
Yes.
Because there aren't
Okay.
any deals. So,
And do you also
This is an
understand
open plea to
that
the
you
court?
might, on the basis of your guilty plea but mentally ill, receive, if there was any deals going on, that you could receive a more severe sentence than that, either requested, recommended, stipulated, argued by your lawyer?
Yes.
Okay.
yeah, he can get
Do
up
you have any
to,
questions as to what you're alleged to have done within the second amended indictment?
he can get up to like
Do I need to
76
review all
years
that
is
with
the
him?
max.
He's never been canvassed as to count 1, Your Honor. I think the parties can agree to incorporate the factual basis from his previous plea as to counts 2 through 7, but he's never been canvassed as to count 1.
Okay, let me go through that. I don't have that right in front of me, so let me pull it up.
A number of you asked about what happens with the fines. Again, some of the fines go to court fees, some of the fines go to victim witness assistant funds. It depends on how the state divides them up, but fines go into the state and the state divides those up. How they decide to divide that up varies by state. I don't know how they do it, but yes, some fines
I'm gonna
and
go through
fees
all the counts.
go to victim assistance, some go to the restitution fund, some go to court costs. He
Okay, I'm
should have
looking
this in
at
front of him.
the-
Yep.
Well, it's called the amended indictment. And it was filed on August 30th.
It's the second amended that was filed on Tuesday, Your Honor. That's the charging document we're going off of.
Okay.
Witness asked if I've seen enhancements on charges for court staff and law enforcement officers. Those are normally separate charges. They're not enhanced the way an enhancement would be for age or other vulnerability. There's normally separate charges, and we heard that when they read the charges here. There's charges for attacking a court officer. So not an enhancement on a charge, a separate charge.
Counsel, and I, for whatever reason, hasn't made it yet, but they're going to do it right
The
this
fines will normally come out of custody work when they go into custody, but those fines can be tacked on for later. It really depends on how much they add to that, but it would come out of work done in custody if he's sentenced to custody, which in this case he will be.
If you want to read that charge.
If you got a file stamp on it, I'd be happy to do that.
The court's like, can you just give it to me? They're looking for the second amended complaint.
In fact, counsel, would you approach?
Sure. All right, we're going to zoom while they approach as they are pulling up the second amended complaint to continue advising the defendant of his rights and go through the plea for the record. So that is what they're doing. We're going to zoom until we're back on the record.
Okay.
Because we're doing a trial in a day.
Mr. Redden?
Yes.
There we go.
She's got a copy that is file stamped. Well, it's not file stamped, but it is the one that was filed. I'm going to go ahead and review the second amended indictment with you, if I may, and tell me if this is what you did. And again, you're pleading guilty, but mentally ill. I appreciate.
So you will hear the rest of the charges again. The defense attorney read them in the record. The court is going to read the charges into the record again.
Appreciate that. So I may not add all of that. Okay, tell me if this is what you did with respect to count one, attempt murder, victim 60 years of age or older, that you willfully, unlawfully, and feloniously, and with malice aforethought, attempt to kill Judge Mary K. Holthus, who is 60 years of age or older, to wit, during your rendition of sentence, and once you knew she was about to sentence you to prison.
So we're taking the plea now
over defense counsel's table into
with
the
factual
well
basis.
of the courtroom, and thereafter rushing towards the judicial bench and jumping over it Superman style directly into Judge Mary.
They put Superman style in the indictment? Okay, so they're going through the factual basis here in the indictment. So they are reading the indictment into the record. So Superman style is in the indictment. I mean, it's an accurate description. I don't know how else you describe it, but that's wild. All right, I'm going to back that up.
60 years of age or older, to wit, during your rendition of sentence, and once you knew she was about to sentence you to prison, did leap over defense counsel's table into the well of the courtroom, and thereafter rushing towards the judicial bench and jumping over it Superman style directly into Judge Mary K. Holthus's judicial space, landing directly on top of her and immediately attacking Judge Mary K. Holthus by grabbing her, pulling her hair, placing your hands around her throat, and or hitting her on the head by manner and means unknown. Did you do that, sir?
Yes.
Okay. With respect to count two, tell me if this is what you did.
So these are the pleas.
And by the way, this is on or about January 3rd, 2024 in Clark County, Nevada.
Yeah, for everyone who's thinking Soldier Boy.
Battery on protected person resulting in substantial bodily harm, victim over 60 years of age or older, that you did willfully, unlawfully, and knowingly use force or violence upon the person of another, to wit, Judge Mary.
So the battery charge will probably not get sentenced separately. It will be generally a lesser included of the attempted murder. So he's going to plead to the sheet, which is the entire indictment. But when it comes to sentencing, you're generally not going to see a sentence on count 2 in addition to the sentence on count 1, because they will generally be subsumed into one another as the lesser included. But we'll see that when we get to
Kay
sentencing.
Holthus, who is 60 years of age or older and is a protected person employed as an 8th Judicial District Court judge while Judge Mary Kay Holthus was performing the duties
Maybe not because
an
of the protected
8th
person
Judicial
status,
District
but we'll
Court
see.
judge, which you knew or should have known that Judge Mary Kay Holthus was an 8th Judicial District Court judge by grabbing her, pulling her hair, placing your hands around her throat, and or hitting her on the head by manner and means unknown, resulting in substantial bodily harm to Judge Mary Kay Holthus. Did you do that, sir?
Yes.
Okay, with respect to count 3, intimidating public officer that on the same date, place, and time, that tell me if this is what you did, that you did willfully, unlawfully, and feloniously, directly or indirectly, address any threat or intimidation to a public officer, namely Judge Mary Kay Holthus,
By yelling,
a
"Fuck
judicial
that bitch,"
officer with
and
intent to induce her, contrary
attacking her?
to her duty to do, make, omit, or delay any act, decision, or determination with use of physical force or the immediate threat of such force, to wit, during the rendition of sentence, and once you knew she was about to sentence you to prison, did leap over defense counsel's table into the well of the courtroom, thereafter rushing towards the judicial bench and jumping over it Superman style directly into Judge Mary Kay Holthus's judicial space, landing directly on top of her and immediately attacking Judge Mary Kay Holthus by grabbing her, pulling her hair, placing your hands around her throat, and or hitting her on the head by manner and means unknown. Did you?
I have seen a lot of charging documents. Assaults, to wit. I had an assault that was to wit Starbucks water. I have seen people have assaults, skateboard, various types of adult toys, what have you. But Superman style, I have never seen an assault to wit leaping Superman style. This one is new to me, and I think probably new to everyone. I mean,
Do that, sir.
Yes.
that's count 3.
Count 4, battery on an officer resulting in substantial bodily harm. On the same date same date and place, tell me if this is what you did. That you did willfully, unlawfully, and knowingly use force or violence upon the person of another, to wit, J. Cabralda, who is performing the duties of a peace officer employed with the Las
That's the
Vegas
officer that was
Metropolitan
injured.
Police Department, which you knew or should have known that J. Cabralda was an officer by punching and or kicking and or pushing the officer, such acts resulting in substantial bodily harm. Did you do that, sir?
Yes.
Okay. With respect to count 5, at the same date, place, and time, tell me if this is what you did. That count 5, performance of act or neglect of duty in willful or wanton disregard of safety of persons or property resulting in substantial bodily harm or death. That you did then and there unlawfully, willfully, unlawfully, feloniously perform an act in willful or wanton disregard of the safety of persons or property in the following manner, to wit, by jumping over the defense counsel's table into the well of the courtroom, thereafter rushing at the judicial bench and leaping over it Superman style to attack and or kill the judge, causing Marshal S. Brandon and others to respond in defense of your actions towards the judge, resulting
And that's
in
how we get to that
substantial
charge.
bodily harm or death to Marshal S. Brandon. Did you do that, sir?
Yes.
Okay. With respect to count 6, battery by prisoner, on the same date and place and time, tell me if this is what you did. That you did willfully, unlawfully, feloniously, and knowingly use force or violence upon the person of another, to wit, Officer C. Boo, by spitting on Officer C. Boo, defendant you at the time of the offense being a prisoner in lawful custody or confinement. Did you do that, sir?
Yes.
With respect to count 7, on the same date and place, and the act being unlawful act relating to human excrement or bodily fluid. Tell me if this is what you did.
And this is going to be the
that
description
you
of.
did then and there, willfully, unlawfully, feloniously, and intentionally use,
I think
propel, discharge, or spread any human excrement or bodily fluid consisting of saliva with the intent to have the excrement or bodily fluid come into physical contact with any portion of the body of another person, or under circumstances in which the excrement or bodily fluid was reasonably likely to have come into contact with any portion of the body of another person, to wit, Officer C. Boo, whether or not such contact actually occurred while you were a prisoner in lawful confinement, you committing the offense in the following manner, to wit, by spitting saliva on Officer Boo. Did you do that, sir?
Yes.
Okay. And for that reason, you are pleading guilty to committing the crimes by pleading guilty but mentally ill to committing the crimes of count 1, attempt murder, victim 60 years of age or older, a category B felony in violation of NRS 200.010, NRS 200.0.
So they are taking the factual basis, which is did you do all of this stuff, and now they are taking the pleas for count 1 through 7.
030, NRS 193.153, and NRS 193.167. Count 2, battery on a protected person, resulting in substantial bodily harm. Victim.
Sarah, I think the spitting happened after they took him into custody. He was sentenced to custody and then they detained him in the courtroom. I think it happened as they were going back. So.
Over 60 years of age or older, a category B felony in violation of NRS 200.481. Count 3, intimidating public officer, a category C felony in violation of NRS 199.300. Count 4, battery on an officer resulting in substantial bodily harm, a category B felony in violation of NRS 200.481. Count 5, is that what I'm on? Count 5, performance of act or neglect of duty in willful or wanton disregard or of safety of persons or property resulting in substantial bodily harm or death, a category C felony in violation
he
of
has a copy that he's probably reading along with now.
Count 6, battery by prisoner, a category B felony in violation of NRS 200.481 2F, and count 7, unlawful act relating to human excrement or bodily fluid, category B felony, in violation of NRS 212.189. Is that right, sir?
Yes.
Okay. Is the state satisfied with that canvass?
Yes, Your Honor.
Okay. At this time, I am going to allow Mr. Redden to withdraw his original guilty pleas to counts 2
and enter these guilty
through
pleas
7,
instead.
And it is the finding of the court the defendant is fully competent and capable of entering an informed plea with respect to the 7 counts, and that your plea of guilty but mentally ill is a knowing and voluntary plea supported by an independent basis in fact, containing the essential elements of the offense charged, and for that reason this court accepts your guilty pleas. We need to give this gentleman a sentencing date.
All right, pleas have been entered.
Defense counsel was requesting 60 days.
Yes, Your Honor.
60 days?
Yes.
I think we can accommodate that.
Because at sentencing, the defense has
Just for
to.
the record was the
At sentencing, the defense will have to put on a bit of evidence regarding the defendant's mental state and mental illness because of the pleading guilty but mentally ill. That has to be proved by a preponderance. A preponderance is a lower standard. He has to show that. They will likely use the doctors they were going to use in this trial anyway and bring them in, but he has to show that that's at the time of sentencing, not at the time he went to be evaluated for competency. So they might need to do additional information. So let's go through, but they asked for 60 days.
Mr. Arnold's acknowledgement attached to the guilty plea agreement.
I've got it, yes. The certificate of counsel?
Yes.
It's there.
Thank you.
Okay, and go ahead.
November the 7th, would you like a special time, Your Honor?
Do you want a special time?
Yes, please.
Usually I have my calendar at 8:30. Do you want to do it after? Or do you want to do it in the afternoon?
We can do 10:30 or 11, or we can do it in the afternoon. whatever.
So they're asking for later because they are going to have a hearing.
Oh, now this shouldn't be a Wednesday.
No, I'm saying on the Thursday.
Yeah, because I have gotten where I just don't just so on, there's just no way I can get it done. Right now, we've got 6 criminal sessions on that. I could probably do it at noon if you want to just do it at noon.
Whatever Mr. Arnold's preference is.
That's fine, no.
Okay. We'll just take a later lunch, okay?
November the 7th at noon.
It's going to take you
Thank you, Your Honor.
like 2 hours.
Okay, thank you.
You're going
And
to keep your
Mr.
court
Clerk,
staff till
I'd
2?
like these documents.
All right, sentencing November 7th at 12 p.m.
Dr.
Pacific.
Paganini's report, left side filed, as well as Leo Rowley, Dr. Leo Rowley's report, left side filed.
All right, and that is the end.
Okay. And
2 days of
thank you,
trial?
very much.
2 half days of trial.
Mr. Arnold, do you want to take the defendant out now? I was going to tell the jury.
Oh, yeah, we don't need him here.
Yeah.
You don't need him?
No, we don't need.
Okay. All right. Are you ready for me to invite the jury in?
Yes, sir.
I'm
Okay.
interested what she says to the jury, and then I'll be answering questions, and then we'll be done for the day. 2 half days of court. But the court is bringing the jury in, and then she will excuse them.
I take it you don't want.
I'm just interested what she says to the jury. So. And November is when the KPD trial is going to trial as well. So this is the same defense attorney on that trial, which will be interesting to see. So, Linda, I will plan on doing this sentencing hearing. However, sentencing hearings get moved. But I'll plan on doing this sentencing hearing.
Counsel, please stipulate to the presence of the jury. Okay. You all may be seated. Ladies and gentlemen, I know that was a very long break, but there's a reason for it, and that is that the party.
They were told they were going out on a 15-minute break, like 2.5 hours later. It's like a full 3-hour tour. The jury gets brought back in and is like, and the defendant's not sitting there. So now they have to be told what's happening and excused from jury duty. Though at this point, I think the jury's probably invested and they're like, wait, what?
Have resolved their differences between them. Should I go ahead and tell them? Okay, essentially what Mr. Redden did was that he pled guilty to all the charges set forth within the second amended indictment, guilty but mentally ill. So as the case has been resolved, I can excuse you now and release
Thank you for your
from
service.
I want to thank you very, very much for taking your time, and I really do appreciate it.
Thank you for doing your jury duty.
It's the only service that we do owe to our country, but it is really a necessary service, and I really do appreciate it, and you are excused from my thanks. At this point, you may say, well, can we talk about our experience?
Yes.
If you had a good experience in this courtroom, say, yes, we had a great experience in Department 22. If you didn't, I would appreciate that you not. I'm kidding. But yes, you may talk about your experience, and I certainly hope that whatever you have to say does encourage others to engage in jury service as well. So we're going to take you in the back, get all your badges and all of your stuff.
And then they give them their jury
and,
slip.
The lawyers may want to talk to you, and if they do, I would certainly
I don't know if the
encourage
juries
you
want to
to
talk
do
to them in
that,
this case.
'cause I know I learned a lot whenever I was a lawyer.
I bet the jurors are more interested in talking to the lawyers in this case than the lawyers are talking to the jurors. I bet the jurors might have questions for the attorneys.
Sitting at those tables to hear what jurors had to say. I think it made me a better lawyer. Okay?
10 out of 10 agreed.
Thank you.
We're gonna line up in the hallway, just.
All right, and that's it. They will get their jury duty slip that says if you get called back for jury duty within a certain amount of time, you don't have to do it.
Bring the candy bucket.
He said, bring the candy bucket. Bring the candy bucket. I like that they have a candy bucket.
Okay.
Snackies are needed.
Okay.
But this jury was only in court half
Counsel, I may want
days.
to meet with you in the back hallway.
So they just serve 2 half days.
Not now, but wait until they get into the jury room.
So, and that's it. That is the end 2 days. Lyndon said justice indeed runs on sugar and caffeine. Yep. Not always the healthiest way to do it. And adrenaline. Emily, how many lawyers do you know that have had
By the way,
adrenal
the jury
fatigue in
does not
addition
left
to
the
you?
courtroom until that
Many.
door closes. The jury has left the courtroom. All right, I am going to encourage them to talk with you, but in the meantime, I'd like to talk to you guys first, okay? All right.
All right. And that's it. So, jury out and case done. I was very interested in seeing the judge testify in this case. I very much wanted to see the law clerk testify in this case. We did get the testimony of those two individuals before the defendant took a plea. I'm going to do a quick summary, and then this was wilder than I anticipated when I was like, I want to see opening statements and these witnesses. When I saw that the case had resolved, I'm like, we can do this in a one-day stream. So I very much wanted to do a one-day speed run of trial and spend a day taking a look. Lots has happened in the news today. Don't worry, I'm going to be putting stuff up in our member spaces because lots has happened in the news today. So I will be covering it in other content. Today, we're going to wrap up this trial. Next week, I'm going to be traveling, so stay tuned to the Law Nerd app for what's going on. But I really wanted to take a look at this case, and I thought that we could do it. So I appreciate it. So let us continue with a quick summary of this case. So in Nevada, we had the Nevada versus Redden case. This is the defendant. The clip of whom went incredibly viral when he Supermaned over the bench and tackled the judge. This is the trial for everything that happened that day in court. He was there to be sentenced on a case he had previously pled guilty to. The court opened with opening statements that were interrupted because the court did have Zoom open, or Blue Jeans was a system they used open, and somebody spammed the video and audio with adulty inappropriate videos that caused, I think it was the clerk of court or the court reporter, to actually gasp as you heard the moaning over the audio system in court during the prosecutor's opening statement. The prosecutor, to her credit, recovered fairly well from the auditory interruption. They put on the record that none of that was seen by the jury, but it did interrupt the opening statements of the prosecution. And you could see the court staff being quite caught off guard. It seems that courts don't know how to mute all participants so they can't unmute themselves and disrupt live court, which we have seen in other cases. And it doesn't surprise me that there were disruptions in a high profile case. Courts have to know when cases are streamed. The internet will internet and sometimes intercede into the court case, even though they shouldn't. But after that, we saw the opening statements of both parties, the prosecution opening up with the defendant saying, I tried to kill a judge today, and then showing the video of the defendant leaping onto the bench with full audio where you can hear the defendant saying, nah, fuck that bitch, and then flying at the judge. We saw the defense say 3.7 seconds from the time the bailiff handcuffs clicked to take the defendant into custody. There were 3.7 seconds before he was at the bench, over the bench, and that was not enough time for him to form intent. They also talked about the defendant's mental health history, his mental health diagnosis, and that he did not form the intent to the attempted murder. He was charged with 7 counts. He had pled guilty to 6 of them and was only going to trial on the attempted murder of the judge. We then heard the judge testify, went through the injuries that day, that she thought she wasn't going to make it out of work that day. Watching the video back with the judge and her talking about the injury to her head, the force with which the defendant hit her out of her chair up against the wall behind her and knocked her out of her shoes, and then grabbed her hair as he held her on the ground. We then heard from the clerk that was next to her, her law clerk, who does her research and helps prepare her case calendars from the legal side. And he had very descriptive and active testimony. He was telling the jury exactly what happened, that he saw the defendant like winding up and wailing on the bailiff, that he saw the deputy coming around and get injured and his head had flapped open. It was descriptive testimony, but he was very much retelling and reliving what he had seen. But his mannerism with the jury was very much, you're never going to believe what happened at work today. It was this, and then it was this, and then I saw this, and then I heard him say, fuck that, and then he's running at the bench. It was very engaging testimony, and I imagine that the jury was like, this is wild, and we saw the video again. The jury took a 15-minute break, and the court took a 15-minute break before cross-examination of the clerk of court. That break extended quite a while, and the defendant came back and pled open to the court to the sheet. What that means is that the defendant withdrew his prior guilty pleas for counts 2 through 7 and decided to plea to the court, no plea deal from the prosecution, to counts 1 through 7 as guilty but mentally ill. What that means is at sentencing, the defendant will have to prove by a preponderance of the evidence to the court that at the time of sentencing, he was mentally ill. His diagnosis of schizophrenia should count for that, which entitles him to mental health treatment and sometimes a different housing designation within the prison system so that he can receive that treatment that seemed to be beneficial to him based on his defense attorney's statements and opening statement. That is not a plea deal with the prosecution. That is the defendant coming to the judge saying, I'm guilty. If he does not prove the mentally ill component at the time of sentencing, which again, his diagnosis will generally cover, but if he does not prove that at sentencing, then he will just be sentenced to a prison term. He will get a prison term either way. The designation will just be different. So the defendant has pled. He will be sentenced in November. They will have a short hearing for him to prove that he was mentally ill at the time of his plea, which is the time he took the plea in court that we just watched. That will happen, I think I said, in November. This defendant does have the same retained counsel as Keefe D, which was interesting to see. I did not know that he had hired the same defense attorney there in Nevada, but we will see the Keefe D trial in November. So we will see more of this defense attorney in November, and we will see this sentencing. The minimum potential sentence for this defendant, the bare minimum potential sentence, is 2 years. That's a mandatory minimum on one of the counts. The maximum is upwards of 50 years. I think some of those counts will consolidate. So he is looking at probably a substantial prison term based on the injuries to the judge, the injuries to the sheriff's deputy, and his behavior in court. So I would imagine we will see, and his criminal history. So we will see that sentencing in November. And with that, this trial is done. You've got questions. I've got questions. We've got questions. Let's go to questions. So I'm going to go through your questions from our court day today. I will be covering other news in the podcast as we get into next week. And in our member spaces, I'll probably do some, if you guys are subscribed, if you guys follow me on Instagram or on the Quick Bits channel, I will probably do like a couple reels on all the breaking news today. It's been very busy. It's why Nightbot always says no breaking news. But for those of you that are here, yes, the Idaho case has been moved to Boise. We thought that was going to happen. A new judge was assigned. Yes, Karen Reed appealed and the DA's office made a statement. I'll cover that for Quick Bits. And stuff's happening in the Girardi case in Illinois as well. So this week, Quick Bits isn't going to be a summary. Quick Bits is going to be all the new stuff that we didn't get to today while this was happening. Donna Adelson was back in court today and is going to trial next week. So I am traveling next week. I think all of next week in Adelson will be taken up by jury selection. If Adelson starts with opening statements, I am bringing my streaming setup with me, even though I'm traveling, and I will figure it out. So don't worry. Stay tuned to the Law Nerd app. I'm going to keep you in the loop. So I'm going to go to our questions specifically regarding the plea first, and then we'll get to some of our questions and our super chats. But there were a lot of questions right at the end that I want to get to. So Mazzo said, why not release the jury before the 2-hour wait? Because sometimes you get into the middle of a plea deal and a defendant says, nah, fuck that, and says, I'm not pleading, bring the jury back in. Until the plea is entered on the record, it's not done. So you can't dismiss the jury prematurely. So they have to wait until it is all the way done. Heather asked if I was going to Bourbon. No, I'm not going to Bourbon. I will be seeing Dave at Pilgrimage in Nashville, but I'm not going to Bourbon because I will be out of state. And I will not be back in time. So unfortunately, I cannot make both happen, but I will get to see Dave soon in Tennessee. Mama Bear said, what happens if not proven mentally ill? Can the plea be reversed and the sentences changed? No. If the defendant does not prove by a preponderance that he's mentally ill, I think he will here. But if he does not prove that, then the plea still stands. He's just sentenced to prison without the mental health conditions that might entitle him to different housing units, to more mental health care. So I think it's probably the goal of the judges, not for a defendant who is malingering because they just want to be in a different housing unit, but for defendants that have need, that they are provided with medication. He is on medication. He does have a diagnosis of schizophrenia. So those things are going to meet the standard that this is someone who needs ongoing mental health care, and that they will be housed in that way and provided treatment in that way. So Laura M. asked, does the judge decide the punishment based on the experts? No, the judge decides the punishment based on the defendant's history, the actions in this case, the pre-sentencing investigation report, and the rest of it. But the experts will come in just as to whether or not the defendant qualifies for the but mentally ill part of it. Lisa H. asked, category B felony. Different states categorize felonies differently. Some states use a letter system. Some states use a number system. Sometimes you'll see class 1, class 2, class 3. It is a way of categorizing sentencing, and then it generally correlates with categorizing felonies, and it generally correlates with the sentencing guides. Like a category B felony would have XYZ sentencing. A category C felony would have XYZ sentencing. And sometimes they have different levels of whether you can get probation or not. So it's just categorizing crimes based on severity and classification. Atomidate, I'm going to get that wrong. Will I review Karen Reed's appeal? Yes, probably on the podcast. I mentioned, or possibly on Quick Bits. I mentioned it today, but we knew it was coming, and it's going to be on the same grounds that the motion to dismiss was on. Here's what's happening with the appeal for Karen Reed. I have not read it. This is me without reading it. Ladies and gentlemen of the appellate court, the jury said this. We asked the judge to dismiss. The judge did not dismiss. You must dismiss. That is what that appeal is going to be. So it's not going to be much more than that. Am I taking my streaming setup on the road for Adelson? Yes, but I think they're going to have 5 days of Adelson jury selection. So I don't think they will start opening statements until the following week. I think we can probably anticipate opening statements for Donna Adelson on Monday, the 23rd. I think when they start jury selection on Tuesday, the 17th, that jury selection is going to take them through Friday, the 20th. It might take them through Monday, the 23rd. So Monday, the 23rd of September, Corey Richens has a pretrial and Donna Adelson has trial. It's going to be a busy day. We'll figure it out, but I'll be home then, so it will be fine. So I don't think we will be streaming next week because I am traveling. I'm going to try to take a moment to like be present where I'm at and then go, we're back to trial. We're back to Adelson, then Boone, then probably Keefe D is what it looks like. We've got a lot coming up between now and then. That girl, Mimi3, said it seems like they're making an example out of him. I respectfully disagree because the defendant chose to plead guilty to all of the charges. The charges reflect the actions. I don't think the defendant was overcharged. Some of those charges might be lesser includeds of each other, so he wouldn't be sentenced on them separately because they account for the same action. Some of those are different, but it accounts for the same action. He chose to plead open to everything, and that was his choice. So I don't think that he did. Sandy asked, can you tell us the lowest total time he needs to serve? If you do just the one mandatory and do everything else concurrently, it's 2 years is the lowest. I don't think that will happen. Grass folk, I hope I answered this question, how this is different from a regular guilty. It's a different designation, which will entitle the defendant to different treatment within custody, probably different financial allotments for treatment in custody, likely different housing in custody as well. The crazy treehouse, as we were talking about names of, Rottenborn and Bloodworth, and it might be Scowl, it might be Scowl for the defense attorney. I think Scowl would be funny, or for the DA, I think Scowl would be funnier because I just said, my son's principal, not joking, is Miss Murder. I think, I mean, it's kind of fantastic. It's kind of fantastic. So Maddox Mikey said, question, if he's charged to fine, where does it go? I think we covered that. It will get divided up to different funds, victim witness fund, restitution fund, court fees. That will all very much depend on jurisdiction. So I see a lot of you saying, am I the only one that gets nervous when Emily travels? I've traveled a lot less this year than I have in previous years, but I can't wait to share with you what I am going to go do. I can't share that yet, but I'm very excited and I very much want to be present for that. A, it will recharge. B, it is related to content. And C, I will get to see some friends that I haven't seen in a minute. So every now and then we need a recharge. And this is a really unusual and surprising opportunity to recharge. So I will be sharing that more with you soon. So I'm excited, but I also am trying to be present. It's been a very busy year of trials, and trying to also reset for me and kind of refill my cup is needed, which is why I'm not going to try to stream if there's nothing crazy happening. But I will, if anything pops off and we need a quick update, I'll update you in the app. But it is really my intention to take a beat before we get into 3 more trials before the end of the year. This is the most trials I've covered in a year, and it's busy. It really, really is busy. But yes, Mr. Lasso, I thought was a great witness. It was wild. So Lauren, a lot of you were debating whether or not he was a golden retriever, or a Labrador, or what have you. He was very invested in his testimony. Steven, it's good to see you. Said, I left and came back and I'm not disappointment. Bro said, I have the tea. I'm going to spill it. Pull up a chair and your thermos. He absolutely did do that. I've never seen To Wit Superman, but there were so many references to Superman in this. I was singing in my head, Superman. It's wild. Verna asked, did anything similar ever happen in your county? The amount of shit that pops off in LA County cannot be understated. So when they were talking about the gassing charges, which is what they're called in California, the bodily fluid charges here, the poop, the spit, that is very real. I've seen defendants hold on to things from lunch and hurl them at the jury. I have seen people run out of court. I have had coworkers who have had poop enter the chat in the courtroom. Wild stuff happens in court. Just wild stuff happens in court. Miss Kitty 8080 asked a great question that I also wanted to address and said, isn't the video enough evidence? No. The video can't be cross-examined. So the video is evidence, but they also need the witnesses to say that this is an accurate representation of what happened, and also to fill in what happens in the what happened leading up to this, what happened after that. So the video alone is not sufficient. So the witnesses plus the video, somebody has to authenticate the video. Is this you? Did this happen? And explain it. So if you had a victim in a case where they had a head injury and they didn't remember, you would bring them in and show them the video and say, is that you? Yes. Were you there on this day and time to the best of your knowledge? Yes. What do you remember leading up? What do you remember after that? And go from there. So the video alone, no, you need the live witnesses too, because you have the right to confront and cross-examine, and you can't confront a video, and you have to prove that the video is accurate. V-Rod said, have you ever had porn streamed into one of your trials? No, that did not ever happen. That one was new, but also there was no Zoom call-ins when I stopped prosecuting cases. When I started prosecuting cases, I don't even know if Zoom was around in 2006, but no. The interruptions are wild. Interruptions happen in court. I've never seen an interruption like that. Like, I've never seen an interruption like that in court. The Amber Alerts going off during Rottenborn's closing argument, which I actually think were technically weather alerts for severe thunderstorms, that I thought was wild. But this is crazier. Carrie Bose said, what did I pop into? Poop and porn. No poop in this courtroom. There was a charge for spitting, but the bodily fluid charges involve all the bodily things, and poop counts, fecal matter counts separate from a bodily fluid. Law's weird. Somewhere lawmakers had to be like, so as we're writing charges for what happens if somebody spits, flings urine, flings poo, bleeds aggressively on somebody, what do you charge for that? And somebody somewhere had to debate whether or not fecal matter counted as bodily fluids, and how you had to account, or semen, how you had to account for it differently. So you have, these are conversations that have to be had when putting these charges on the book, because the poop happens in cop cars amongst other bodily fluids. So there's it happens in custody. Flinging other bodily fluids happens. We're going to just leave it at that. We're not going to get into all of it. Law Too Bad said, wasn't the Amber Alert during Amber's testimony? No, it was during Rottenborn's closing argument. And they said it was an Amber Alert, but it wasn't. So we will see. I agree with you, AH Smart. We talked about that earlier in the stream, that the overlap between mental health and the criminal justice system is incredibly high. So we did have that conversation. I live for Sharpies and flares. I love flares. I wrote on my court files and flares all the time, because then it was easier for me to see where my appearances were and what had happened, because at the time we still had physical files that you wrote on the face of the file. One of my supervisors was like, you can't write on that in purple ink, because I've always loved the color purple. And I'm like, it's the only way I can see mine separate from everybody else. Like, I'm dyslexic and ADHD. Like, it's visually hard for me to separate all these lines of writing of what my notes are every single time. The amount of time it takes me to find what I'm writing, I just need it to be color inked. He's like, no, you have to write in black. I'm like, no. I'm like, write me up, and then we're going to talk about accommodations, because I can't see it if it is just a sea of black ink on tiny little lines. So no. That supervisor did not love me, because I was just like, no, write me up. Nope, write me up. Go ahead. Wish you would. Love to chat about it. I needed to be able to see quickly my files, or I could not do my work. So they were in purple. Music to My Soul said this was certainly a speedy trial. It absolutely was a speedy trial, which is why I wanted to try to cover it in a day. I would have tried to cover it in 2 if we needed to. So that's what we would have done. Peony Rain said, Emily, will it be an appellate issue that this could make the jury fear the defendant? Do they know he's probably shackled? I can imagine the jury could feel scared seeing this and creating bias. The defense attorney, I think, addressed it really well in his opening statement. And no, the facts are what they are. And it is more prejudicial to the defendant to be seen to be shackled. And the defense attorney could have asked, I mean, I guess, that he be shackled, but the defense attorney addressed it in opening. So I don't think it would impact that. Let's see. Friendly Farm Girl said, did you ever lose a case that broke your heart? Yes, I did. It was very early on in my career. Most of the time, no, but there was a DUI, and it was the poor person's 4th DUI. I have very strong thoughts on DUI, but it was the person's 4th. They were on probation for DUI at the time of driving DUI. And there was somebody on the jury that I was unable to yeet from the jury due to an error of the judge. But because DA, there was nothing we could do to deal with the error of the judge, and that person hung the jury. It was not, I mean, I didn't lose. It was a hung jury. But I felt very strongly that this was a person who was going to injure and or kill someone down the road. So having them on the road was frustrating to me, especially since DUIs don't aggregate until you get to your 3rd one within 10 years. And this would have been a 4th. It frustrated me. But we had a juror who said, I think too many people are prosecuted for DUI. And I also have lost people who have been killed by drunk drivers. So my feelings on that are strong, especially when you work in courts, especially in misdemeanor courts, and you see the amount of DUIs that come through, it makes you scared to drive. The anxiety I have about my kid driving has nothing to do with where him driving. It has everything to do with other people driving. So I was frustrated with that. But that's a very long story about a newer judge who was very wrong, and a newer DA who, when he's like, name them, the judge is like, cite where it says that. I'm like, in the civil code. I mean, I need 20 minutes to go find where it says that. Who knows that? And even the defense attorney's like, Your Honor, she's right about she's right about that. And the judge is like, no. And I'm like, can we just take a time out? Can we all just pause? I'll go find the citation. And me in my high heels early on in the career, running down the whole corridor, just like to my supervising attorney being like, you're never going to believe what the judge is doing in any of the civil court. Ah! And my boss is like, wait, what? The judge is doing what? No. And it was a whole thing. Anyway, hung jury 11-1. The one for not guilt. That juror looked at me as they walked out and went, So yes, frustrating. And the jury didn't know that this was this person's fourth DUI. Anyway, let's see. Do you think the inappropriate video on blue jeans could be used by the defense on appeal? The defendant pled, but no, it didn't interrupt the defendant. I don't think the jury could have heard what was happening very clearly. And it didn't say anything to the defendant. It didn't say anything about the defendant. It threw off the prosecutor's flow. So no, I don't think that's a problem. Let's see. Hannah said, so I just got my husband in trouble. He's watching while at work, and one of his coworkers walked into his office, heard what was going on, and asked, what the fuck are you watching? Sorry, Hubs. Court is dynamic. To Hannah's husband. I'm sorry. I didn't expect court to have a Cinemax after 11 p.m. soundtrack. Jamboy said, I'm really interested to hear the defense opening. I have bipolar, and when unwell, still upsetting to me that to this day, and I'm utterly devastated and remorseful after. Not sure if this witness is. It'll be interesting following with you. Jamboy, thank you for sharing your experiences. And yes, it is tough. The defense opening, I thought, was good. It was good. So Pesky asked, do you remember the most frightened you have ever been trying a case in court? Often when you deal with this, that comes later. But yes, there are hard days in court. There are scary days in court. And you get up and do your job and trust the people around you. Best Snow said, I would like to see commentary on older trials. I just love your commentary. If the newer trials slow down, maybe we could do that. I would love for the current trials to slow down, but that's not happening anytime soon. But I'm not opposed to it. It's all a matter of time, especially with the amount of motions and how quickly some of the cases we're watching move. Ty Mao said, it's not every day that you get to hear so much of the prior bad acts being relevant to the trial portion of the case. Almost never. This was a very, very unusual case and a very interesting peek behind the curtain of the ins and outs of a day in court, which I thought was very, very interesting. And I hope you did too. Jay McCarthy said, this dynamic must be so awkward for them. I can't imagine what it'd be like as a prosecutor and defense attorney or a judge witness, the sheer power struggle between the three. I think the judge victim witness did a great job. I think the attorneys handled it with respect. So it was, I don't know. I think they did a good job. So with that, I know there are stuff that I have missed. Casey Cat said, the porn on Zoom is happening a lot for a while. YouTube took down Judge DeSantis' court for months because they couldn't get a handle on it. It's wild to me that courts can't figure out how to get people into their hearings and have the public come in separately and be kind of locked out. It's wild. So It is, oh, Jamboy, I get it. Meant I did things when unwell, still upset with. No, if I read that awkwardly, I understand. But yes, I can imagine. And it is one of the things that is incredibly tough. Linda said, do the bailiffs not have tasers? They probably do. But when we look at that situation, it was so dynamic and they were in such close proximity. There's not much that they could, have done. I don't think. Just by looking at the video and looking how many people had hands on the defendant, you can't hold the defendant and tase the defendant. So I don't think there was anything they could have do except try to physically restrain him. They were in a very close quarters and letting him go where the judge is was never going to work. So no, I don't think there's anything they could have done in those close quarters and in that dynamic of a situation. And this is why when there are situations in court, normally it is the role of the judge, the clerks, and everyone else to get the fuck out of the way. So if the bailiffs need to do that, then everyone else is out of the way and doesn't get injured because the bailiffs don't want to hurt anyone else in the courtroom. And dynamic situation, small space. I don't think there were many options that they could have done there. So, all right, let us wrap up as we do as we are going. So real quick to zoom through our members. It's good to see everybody. No, I'm still here. We just delete the spoilers in the chat. That's it. We just delete the spoilers in the chat. That's all. We just delete them. But I knew this resolved last week, but I know a lot of you didn't watch when this case was happening live because we were dealing with other stuff. So I appreciate it. Leonard Soph said, as a clerk of court, we sit directly in front of the judge in the UK. This is a clerk's nightmare. That would be terrifying to see somebody running at you. Absolutely wild. Emily, happy birthday. Good to see you in the chat. Janelle said, I need this today after losing my brother. Janelle, I am so sorry for your loss. It is not, there have been some other losses in the chat this week, so I completely understand and I am sorry. Do judges have a gavel to use? If so, when? I haven't seen judges lately using gavels, but normally it would be when court comes to order and ends. I don't know if federal judges still do. Sneaky Snake said, as a judicial assistant in Utah, this has been a huge problem. What is wrong with people? Like, what in the world is like, you know what I'm going to do today? I'm going to go on to random Zoom courts and just spam it with videos that don't need to be played in court. Absolutely wild that's the choice. So it's good to see all of the members saying thank you. It's nice to see those of you that gifted memberships. I appreciate it. For the curls, thank you. For all the Emily, embrace your wavy hair. Here's our suggestions. Thank you so much. Let's see. We are yes, Leonard's always stay hydrated. Nightbot was getting sassy. I realized earlier. All caps will do Nightbot in because it does my brain in. Jay McCarthy said, I often say to my husband, what? I didn't say anything. And he says, yes, you did, loudly with your face. My face as well. My face as well. BLH said, this poor judge, even I'm tearing up and it didn't even happen to me. You could absolutely feel what the judge was feeling in her testimony. It was just very authentic, very raw, and just accurate. Palette cleanser, can we see your pretty nails, EDB? Amanda, yes, we can. I'm going to be changing them shortly for travel, but yes, they're more simple this time, but yes, they are glitter. Motion for Clerk Kent. Clerk Kent. I think we definitely named him Clerk Kent. The guy has bumper from Pitch Perfect energy. It might have been the hair, but yes, he was giving a bumper. Virginia, thank you for the 10 gifted memberships. Everybody has named him Clerk Kent. Granted. Clerk Kent is granted. And with all of that, I know we had to speed run some of that. I appreciate all of you. Thank you for being here. Thank you for being a Leonard. Make sure to subscribe to the channel. Make sure to join the Leonard app at leonardapp.com so you stay in the loop. And I will be updating you on all the things that have popped off today and probably tomorrow in Quick Bits and in Quicks over on the Quick Bits channel. So there's that for you as well. And with that, we're going to replay the outro, which today was also the intro, because streaming. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.